Tabling of documents, dépôt de documents, the Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 10 petitions.
Tabling of documents, dépôt de documents. Introduction of government bills. Déclaration de ministre.
Statements by ministers.
Reports from interparliamentary delegations. Presenting reports from committee, the Honourable Member for Vegreville-Wainwright.
Thank you very much, Mr. Speaker. I have the honour to present in both official languages the first report of the Committee on Natural Resources. In accordance with the order of reference of Thursday, November 3rd, 2011, your committee has considered votes 1B, 5B, 10B, 15B, 20B, 25B, and 30B, and agreed on Monday, November 28, 2011, to report it without amendment.
Presenting reports from committees. Dépôt de projet de loi imminent. Ms. Charlton, seconded by Mr. Gravel, moves for leave to introduce a bill entitled An Act Respecting the Harmonization of Holidays. This motion is deemed adopted. The Honourable Member for Hamilton Mountain.
Thank you very much, Mr. Speaker. It's my great pleasure to introduce a bill respecting the harmonization of holidays. This enactment will entitle employees under federal jurisdiction to all the general holidays observed in the province in which they work. I know that I only have 30 seconds to explain the intent of this bill, so let me try to put it as succinctly as possible by way of an example. A few years ago, the Ontario government created a new holiday known as Family Day. Employees in federally regulated workplaces in Ontario, however, are not currently entitled to that provincial holiday. As a result, we find ourselves in the curious situation where a worker in the federally regulated courier sector, for example, is forced to try and deliver packages to retail businesses that are closed because of the provincial holiday. Moreover, these workers are not able to share the holiday with their family and friends, despite the fact that they too work in Ontario. My bill would end this unintended disconnect between federal and provincial laws by entitling employees in federally regulated workplaces to all of the general holidays that are recognized in the province in which they work. I want to conclude by thanking Sean Flannery from my riding of Hamilton Mountain for first bringing this issue to my attention. I met him while I was knocking on doors in his neighbourhood, and I'm delighted to be able to table this bill for him and for all the workers under federal jurisdiction who would benefit from this enactment. Thank you very much, Mr. Speaker.
Madame Charlton, appelée par Monsieur.
Ms. Charlton, seconded.
Imprimé cette motion.
The motion is deemed adopted.
First reading of this bill, première lecture de ce projet de...
When shall the bill be read a second time? At the next sitting of the House. Monsieur Bellevance, appuyé par...
Mr. Bellevance, seconded by Mr. Plamondon, moves for leave to introduce an act entitled An Act to Amend the Competition Act, Inquiry into Industry Sector. The motion is deemed adopted. The Honourable Member for Richmond-Arthabaska. Thank you, Mr. Speaker. The Bloc Québécois has come back with this. A former colleague, the member for Shefford, my colleague, in fact, had introduced this bill, and what we're seeking to do is to give greater influence, more teeth to the Competition Act. We know that if prices are set for oil, the Bureau needs more teeth. We know that there have been examples to this effect, namely in my region, in Victoriaville, but also in the surrounding areas, Sherbrooke, the Eastern Townships, Thetford Mines, where people were found guilty of price setting, price fixing. So what we want is the Competition Bureau, like the police forces, for example, to have the authority to conduct investigations without someone necessarily putting forth a complaint. What happened at home was that there was a complaint and accusations were made. This was in June of 2008 and in 2010 as well. It dealt with price fixing in Magog, Sherbrooke, Thetford Mines, etc., and 6 companies pled guilty and received penalties and fines of up to $3 million. Of the 11 people who pleaded guilty, half of them received prison sentences, but we needed to have a complaint for that to happen. What we want with this bill is to allow the Competition Bureau to undertake investigations without complaints having to be formulated first, and I think that we'll be in a better position to deal with price fixing for gas. Thank you, Mr. Speaker.
Seconded by Mr. Plamondon, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
Première lecture de ce projet de loi, first reading of this bill.
When shall the bill be read a second time? At the next sitting of the House. First reading of Senate public bills. Motions, motion. Présentation de pétitions.
Presenting petitions.
Presenting petitions, the Honourable Member for Niagara West Glenbrook.
Mr. Speaker, I would like to bring to the attention of the House a petition I received which calls on Parliament to enact stronger legislation to deal with child sexual abuse. Statistics show that 39% of those that possess child sex abuse materials have images of children between the ages of 3 and 5, and 83% have images of children between 6 and 12 being sexually assaulted. Section 163 of the Criminal Code currently allows sentences as little as 90 days for making criminal child sex material and only 14 days for the possession of criminal sex materials. Mr. Speaker, well over 5,000 signatories of this petition are requesting stronger, mandatory minimum sentences that protect children, provide justice, and deter pedophilia. I should add in closing that the Canada Family Action, who are sponsoring this petition, applauds our government for addressing this issue in a meaningful way with our crime legislation, Bill C-10, that is currently before the House. Thank you very much, Mr. Speaker.
Presenting petitions, the Honourable Member for Kingston and the Islands.
Monsieur le Président, je me lève aujourd'hui de...
Mr. Speaker, I rise today to present a petition signed by Canadians from across Canada. It deals with C-10.
The petitioners say that it crudely bundles together too many pieces of unrelated legislation, some of which make sense and some of which does not. There's also a big problem with implementation because Ontario and Quebec may refuse to pay for the cost of some of the measures in this bill that will be downloaded to them. The petitioners call on Parliament to separate Bill C-10 into its pieces and allow members to vote on each part separately.
Presenting petitions, the Honourable Member for Saanich Gulf Islands.
Mr. Speaker, I rise to present a petition today from Canadians primarily from the Montreal and Ottawa areas, also concerned with Bill C-10, making the same point that we have 9 separate bills put together in this omnibus crime bill, the so-called Safe Streets and Communities Act, that many petitioners believe will not deliver safe streets and communities. They have asked that this House consider separating Bill C-10 into its component parts so that each part can be dealt with separately. I present this petition, Mr. Speaker, in hopes that this House will still come to its senses and not pass the omnibus crime bill as drafted.
Presenting petitions, the Honourable Member for Winnipeg North.
Mr. Speaker, with pleasure, I present this petition on behalf of prairie farmers. Mr. Speaker, it indicates that the desire was to address it to the Minister of Agriculture and requesting that he honour the democratically expressed wishes of the Western Canadian farmers. Mr. Speaker, we're all aware in terms of what took place yesterday where Bill C-18 passed, which disagreed with the prairie what the prairie farmers were actually requesting, but still felt important to table this petition so that the Minister of Agriculture would be aware of the fact that most farmers did not support Bill C-18.
Presenting petitions, présentation des pétitions. Questions on the order paper. The Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker asked that all questions be allowed to stand.
Is that agreed? Agreed and so ordered. I understand the Honourable Member for New Brunswick South West is rising to respond to the point of privilege.
Mr. Speaker, I rise today to respond to the supposed question of privilege from the Honourable Member for Mount Royal, which was raised on November 16th and 23rd, along with the submissions made by the Honourable Member for Windsor-Tecumseh. I appreciate that you have allowed. I appreciate the time you've allowed to return with a response. For the reasons I will put before you, I believe you will find that there is no basis to conclude a prima facie breach of privilege has taken place. Monsieur le Président,
Mr. Speaker, the issue at stake is linked to the identification of voters by the Conservative Party of Canada in the electoral district of Mount Royal. As you know, Mr. Speaker, each political party in the House of Commons identifies its electors in one way or another. This is an important aspect of the political process. Communicating with Canadians to discuss issues with them and to ask them whether they support our party is nothing new. The resources used for these calls were not the resources of Parliament or the government, but instead the resources of the Conservative Party.
Parliamentary resource or time used to conduct a routine political activity. Mr. Speaker, we are aware of numerous circumstances where the Liberal Party of Canada was prior to the last election, making voter identification calls into various ridings across the country, targeted seats held by Conservative members of Parliament. I will also add that, at that point, the election timing was entirely speculative, there not being an election called or scheduled until after all the opposition parties joined together and voted on March 25th for an unnecessary early election. Did those calls impinge on the work of the sitting members? Did those calls prevent the MPs from doing their job? No, absolutely not. This is exactly what a political party is supposed to be doing, targeting ridings they believe that can eventually be won. Mr. Speaker, the honourable member from Mount Royal indicates that his ability to do his job as a representative of the riding because of these calls has been undermined. This is simply not the case. As the honourable member noted, he has many bills and motions on the order paper and notice paper. Moreover, I am told, he has been very active in recent meetings of the Standing Committee on Justice and Human Rights. Clearly, his work in this place has not been impeded in this regard. Moreover, members have numerous tools provided by taxpayers to communicate with constituencies as a result of being elected to Parliament. These include householders and 10%ers, among other tools. And finally, a member of this House can simply make a statement to the press, which is what the honourable member did in this case to ensure his constituents are aware of his intentions. As well, he penned an op-ed in yesterday's Montreal Gazette to inform voters of the work he is doing on their behalf. I was impressed by the volume of his work, and I'm sure they were too. Mr. Speaker, it may be helpful to draw the Chair's attention to other cases of rumoured by-elections. En 2003,
in 2003, during the leadership race for the New Democratic Party, Jack Layton didn't have a seat in the House of Commons. On Friday, the 10th of January 2003, the Toronto Star wrote that Mr. Layton would not rule out the possibility of a by-election in Ottawa Centre. The problem, Mr. Speaker, was that there wasn't a by-election in Ottawa Centre. However, the Toronto Star wrote that Mr. Layton would not rule out the possibility of participating in a by-election in order to fill that vacant seat. The Liberal member at the time who represented Ottawa Centre, today Mark Harb, a Liberal senator, never raised a question of privilege. He'd never said that his rights as a member of Parliament had been violated, for good reason, because they were not. Mr. Layton simply responded to the rumours whereby the Member of Parliament may well resign.
I'll draw your attention to a line that appeared in a recent news article from iPolitics with respect to the claims advanced by the honourable member from Mount Royal. It appeared on their online news site on Wednesday, November 16th. Quote, while the member from Mount Royal, who has an international reputation for his human rights work, has often been rumoured to be on the brink of quitting as an MP, in an interview with iPolitics, the member from Mount Royal said he has no plans to quit and has not been offered any position or appointments. End quote. Monsieur le Président.
Mr. Speaker, allow me to reiterate, the honourable member has often been the subject of rumours that he was preparing to leave his position.
The honourable member has, quote, often been rumoured to be on the brink of quitting as a member of Parliament, end quote. So to restate the essentials here, the Conservative Party calls people for the purpose of voter identification. It is an important job, part of the job of any political party, to ask Canadians if they support the party in the event of an election or by-election. The honourable member has often been rumoured to be on the brink of quitting. It is hardly an intolerable leap to insert this in a call script to identify potential voters. Mr. Speaker, this is not a prima facie breach of his privileges or of his collective privilege of this House. It is, in fact, routine political discourse. That's right. And for members to find this objectionable is to be shocked to find gambling going on in this establishment. Some members might be stunned by routine political activity conducted by all political parties, or at least the successful ones, but that indignation is no more surprising than Captain Renaud's feigned anger in Rick's Cafe. And I should correct myself, Mr. Speaker. This activity didn't happen in this establishment. It was not done by any body affiliated with Parliament or under your supervision. Mr. Speaker, I would ask you to be cognizant of free and robust dialogue and democratic activities enjoyed in Canada in respect to the election of members, whether it be as a candidate, a partisan, or a voter, when you come to your decision. Monsieur le Président.
Mr. Speaker, I would ask you to take into account the political dialogue and the political activities in Canada as regards the election of a member, be it a candidate or voters when you make your decision. To my mind, the fact that raising a prima facie question of privilege in these circumstances would be unreasonable and would affect discourse in this country, and it should not. It should only be used in extraordinary circumstances, and these extraordinary circumstances do not exist in this case.
Privilege in these circumstances would, I suggest, place an unreasonable and unacceptable chill over political discourse in this country, and therefore should only be done in the most extraordinary of circumstances. And those circumstances are not present here. Accordingly, I believe you will agree that this is clearly not a matter for the House, that the House should consider further, given that there was no breach here whatsoever, and that the Chair should rule that there is no basis for prima facie breach of privilege. Thank you, Mr. Speaker.
I will recognize the honourable member for Mount Royal on the same point.
Thank you, Mr. Speaker. If you will look back to my statement on privilege, Mr. Speaker, and both of them, I said that I had no problem with people engaging in voter identification. I said I understood the practice of outreach. I said I understood that political parties, including ours, had engaged in the issues of voter identification. Right. And the issue is not because of the calls themselves that my work was impeded, calls, voter identification, and the like. It was because in the course of those calls, my work became impeded by the false and misleading information contained in those calls. That is something very different. The voters were not just asked, do you support and would you support the Conservative Party in a general election? I could understand that, even though we had just had a general election 6 months earlier, but let us say in the realm of political discourse, I could understand. Voter outreach being done all the time, that's fine. That was not how it was put, Mr. Speaker. What my constituents were asked is, will you support the Conservative Party in the pending or imminent by-election?
Big difference.
Now, there's a fundamental difference. This is not normal political discourse, as the honourable member said. This is clearly false and misleading information because there was no pending or imminent by-election. And when my constituents replied, what by-election? We don't know of any by-election. They were then told that the member from Mount Royal has resigned or is about to resign. That clearly comes within the breaches of privilege of sowing confusion in the minds of the voter, and clearly comes within the breach of privilege with respect to prejudicing both my standing with the electorate and not only causing confusion, but impeding my work because of the flood of phone calls and emails, etc., that our office received asking, what about this pending by-election? Or when is this imminent by-election taking place? Or we didn't know that the member from Mount Royal was stepping down. Or we didn't know that he has already stepped down. That's fundamentally different. The fact that there may have been rumors, Mr. Speaker, after 12 years, I'm still here. In that article that he quoted, I said those rumors have been going on for 12 years, Mr. Speaker. The fact that it emanates very often from the members opposite is something else, Mr. Speaker. These are, and rumors are rumors, I'll just say. People can say rumors. That's fundamentally different again. Fundamentally different of a rumor than to call constituents in a systematic way and specifically targeting those constituents with a view and certainly having the effect of sowing confusion in the minds of the electorate, impeding the member in the performance of his functions, causing prejudice or standing to him within the riding. And, Mr. Speaker, these calls have not abated. And yes, I think it is important that such a practice be ceased and desisted from. I don't think any member of this House should have to be subjected to the kinds of calls. And this is not a matter of party, and that's why I was not saying, although I will say, when that comes, that the former candidate in the riding of Mount Royal against him, when asked if he was involved with this, said, "No, I had nothing to do with this. It was the party. It was the Conservative Party." He identified, Conservative candidate identified the Conservative Party as being involved in this. I believed him when he said he wasn't involved. I equally believe him when he says that the Conservative Party was involved. He identified them. But leaving that aside, Mr. Speaker, the whole point here is that this was not in the course of normal outreach. This was a form of prejudicial misrepresentations, of false and misleading information, and, as I say, comes squarely within the criteria. We quoted principle and precedent as to what constitutes a breach of privilege. This is not chilling political discourse for you to rule that it was a breach of privilege. Mr. Speaker, this will chill false and misleading information that tends to corrupt the political process. Yes, that kind of constraint should be placed so that no member in this House should be subjected to false and misleading information. And again, it wasn't held out as a rumor. It was stated as a fact, a false fact. But it was held out. The member has resigned or is about to resign. There is not a by-election at some point in the future, as I said, let alone a general election. They were talking about a by-election. They said the by-election is pending. The by-election is imminent. There were a series here of ongoing false, misleading, prejudicial misrepresentations, and I think that the Speaker should rule as a question of privilege, not simply for my case, but to protect all members of this House from such false, misleading, as I said, not so much in information, but indeed the kind of innuendo that should find no place in this House or outside of this House in order to prejudicially affect members in this House. Thank you, Mr. Speaker.
I'll recognize the honourable member for Windsor-Tecumseh.
Thank you, Mr. Speaker. I have spoken once before on this question of privilege, but after hearing the Conservative member and now the member from the Liberal Party whose motion this is for privilege, finding a privilege, prima facie finding a privilege, I want to draw to your attention the complaint that came from the member from Windsor West with regards to a 10%er, because I think it's exactly on point and fully supports the argument that we just heard. In that case, it was a member from the Conservative Party who had sent a 10%er, which of course is no longer allowed, into the riding of Windsor West, accusing the member from Windsor West of supporting a particular position. I think it was on a crime bill. And Mr. Speaker, in that case, the person who sent it was Monty Sahlberg, who at the time I think was a minister, if not a member, certainly a member of the Conservative Party, sent this 10%er in, claiming that, or accusing, in very strong language, the member from Windsor West of supporting a particular position. Mr. Speaker, what it was all about was that was a position I had taken as the member from Windsor-Tecumseh. The member from Windsor West had not taken a position on it at all. In fact, I think he was on the other side of the issue at the time. So the material that went into the riding in the form of this 10%er was, again, false and misleading in terms of the position that the member from Windsor West had taken, or maybe had not taken any position at all. And it is exactly the same situation we have here. The allegations that we're hearing, and I think they're confirmed now, I don't think there's much of a dispute over the facts, that in fact the Conservatives, we think, but anyway, the phone calls that were going out were clearly false and misleading as to whether the member was going to be retiring or in some respect leaving his position. That does have, as it did with the member from Windsor West, a negative impact on his ability to perform his function. The same thing happened. All sorts of phone calls into his office, emails, letters, asking about why he had taken this position, when in fact he had not. And that's a direct interference. False and misleading, has a negative impact on the ability of the member of Parliament to do their job. And so that file by Speaker Milliken, I think, is exactly on point with the situation we have here. I would urge you to make a decision that, in fact, would find a prima facie case, let us investigate it at PROC, and let us deal with it in an appropriate fashion, as we did in that case.
there were repercussions with regards to Mr. Sahlberg in terms of having to apologize, et cetera, et cetera. We need to be doing the same thing in this case. Thank you, Mr. Speaker.
I'll go to l'honorable député de...
The Honourable Member for Richmond North Athabasca. Thank you, Mr. Speaker. In fact, I don't want to repeat all the arguments that have already been said by the previous member as well as by the member targeted by this issue, the member for Mount Royal, but I'm very disappointed that the Conservative member who defended the position of the Conservative Party in this file did not have the class to tell us that it was a mistake to act that way. Instead of that, he justified the use of this kind of tactic, and often when I do something that is not so nice, in her mind, my spouse, and of course this is very rare, Mr. Speaker, but my spouse will say, put yourself in my shoes. So I would ask the members, everyone who is here, all parties, particularly the Conservative Party members, and including the member who's just spoken, to put themselves in the shoes of the member for Mount Royal. So when there are people who are organized, who make phone calls, polls, or anything else in the riding, and they clearly say that there will be a by-election, this means that the member who is elected is about to leave. And obviously this has been a breach of the privileges of the member, as I said during a first intervention on this very point, Mr. Speaker, not so long ago. The individual or the company or the organization that wants to deal with this member might say, well, is it worth going to see my member about this bill or this issue in order to move this forward if soon he will no longer be there, because I have heard, in fact, that this person is leaving. So you know what happens. It's like a snowball effect. The media talks about it, and then because of a few phone calls, everyone's convinced that the member is leaving. It's clear that there is a breach of the way this member is able to work. He has to answer those questions to the media. He has to respond to constituents. We all have evenings and weekends, and we spend our evenings and weekends meeting with people. During the break weeks, we go to seniors clubs, and I'm convinced the member for Mount Royal has been asked before, is it true that you're leaving? Because I got a phone call. And he spends his time denying this, and I think he should spend his time instead, like we all do, working in order to move forward files. And I have heard no justification from the Conservative member to say that it was unacceptable to act this way. If we accept it for the member for Mount Royal, it will be accepted for everybody here. I have a team, who makes phone calls. I've got a lot of volunteers, and we could do the same thing. I have the Minister of Industry, who is just in the riding next door. I could say the Minister of Industry is about to leave. He had an offer to be an ambassador, so he's going to leave. I'm not going to do that, but I'm just going to say that we all don't want to start creating this kind of precedent, Mr. Speaker.
I'll go to the honourable member for New Brunswick Southwest, and then I think it might be time to you have something else to add? The honourable member for New Brunswick Southwest.
Mr. Speaker, I'm going to make a couple points. One, the 10% program, householders, falls within the purview of Parliament. Activities by political parties do not. Number two, members seem to be concerned about tactics that political parties engage in order to ID vote or engage in activities to win votes. Again, I submit that this is of no business to this House. And third, in this case with the honourable member, there is talk and rumor out there that he's put it to rest, and I accept that. But it is not unreasonable in a political discourse to have heard that and to accept that, or for that to be inserted into a script or used to explain why calls are happening. Good, strong political parties are ready for elections at any time, and they'll conduct work throughout the years, in this case 4 years, and not just wait for 4 weeks before the next election. So again, it's important that we separate these activities from the business of Parliament and the business of political dialogue outside of this chamber. That is legitimate and appropriate. And I'll leave it at that. Thank you, sir.
Well, I see the honourable member for Humber St. Barbe-Vert has gotten up, so I'll recognize him. But I think it's quickly time to.
Speaker, I think I should respond to the supplementary remarks of my colleague.
Do you have a point? I didn't see you getting up. Okay. The honourable member for Humber St. Barbe-Vert.
Mr. Speaker, thank you very much for recognizing me, and I'm sure you'll recognize the member for Mount Royal for closing summation comments. I want to be very clear here. the actions that occurred in the electoral district of Mount Royal are irrefutable. They are vile, they are corrupt, and they are anti-democratic, and they happened. Now, they happened in a way which was very consistent to the previous actions of the Conservative Party of Canada, using House resources to conduct a message targeted, a negative message and a false message targeted at a particular electoral district and a particular member of this House. You know, Mr. Speaker, a professional polling firm, a company, a corporate entity does not do this activity out of their own political philosophy or own personal actions. They do it for remuneration. Someone paid a company to conduct a false poll, a push poll, in the guise of a public relations survey to convey a false message to the electoral district and to the electors within the Mount Royal district. Mr. Speaker, there has been past activity, precedents, which outline that House resources were used to conduct that activity. That is irrefutable. What is also irrefutable is that this particular survey could just have easily been conducted through one of two means. Through House resources, using the research budgets of the Conservative Party of Canada, or through a subsidy from taxpayers. But bottom line, Mr. Speaker, it is not acceptable to any member that we just simply whistle past the graveyard and sort of ignore this issue. There is a precedent that has been set, there has been rulings that have been set, that if you were simply to find the basis of an investigation to find out the truth, not to whistle past the graveyard, given the fact that there is past activity which supports the notion that House resources were used to do this type of activity, that House resources could now be used to conduct this type of vile activity, not to refer this to committee, not to find a prima facie case, in my opinion, would be an offence to the House. We just simply cannot walk past the graveyard on this. Mr. Speaker, it is incumbent upon us to protect all of us, to protect the rights of individual members. I call on you to do the right thing and allow this matter to be properly vetted. Do not let even, the perception or the reality of House resources, of the people's resources, to be used for a false, corrupt message which betrays the true character and integrity of a member of this House. It would be unacceptable.
The Honourable Government House Leader.
You should let the member for Esquimalt Sandwich go first, and then I'd be prepared to.
And Skull Violence.
Thank you, Mr. Speaker. I'm just rising to make one small point. That when I made reference in the first instance on this argument to examples where personal privilege had been found to be violated, they were not limited to the kinds of examples the Honourable Member for New Brunswick Southwest put forward. They were not limited to householders or things within the purview of this House. They included misleading advertising in newspapers, that anything that leads to a confusion about the role of a Member of Parliament in this place is actually against our principles and does constitute a point of personal privilege being breached. I don't want to repeat the argument I made earlier, but just to reinforce that what I've heard from the Honourable Member from New Brunswick Southwest falls short of a satisfactory response to this point of privilege.
The Honourable Government House Leader.
Mr. Speaker, Member for Mount Royal, in addressing the matter that he's concerned about, the suggestions that there would be potentially a by-election in his constituency, has used some very, very strong language to describe these as misleading, wrong, untrue. But when we go back to the original arguments he made, we'll recall that he said people were receiving these calls and they were perplexed. Why am I receiving this call? And they, of course, asked the question, why are you calling me? A reasonable question to ask in the circumstances since he is here. And the response that was given by the callers was, as he said, one that there was a possibility or rumors or suggestions that there would be a by-election. Well, that response that was given was something very interesting. It was the truth. What he is asking you to do here is, while this normal activity is taking place, suppress people from being able to speak the truth. When they're asked, why are you making this call, that there are rumors that there might be a by-election, is the true answer. That's what was prompting the political activity. It's something that he himself acknowledges, has been out there, has been present for some 12 years. We're not talking about the past couple of weeks. We're talking about years and years. So clearly, the basis for them answering the truth when asked that question is most reasonable, a reasonable part of speech. And in this case, what you're being asked to do is also extraordinary in that you're being asked to reach far outside of this House to make a ruling that will affect the freedom of speech and the ability to speak their minds of every single Canadian. Their fundamental charter rights, their fundamental democratic rights, and to say that they aren't able to comment or speculate on whether or not he would be leaving his seat, whether there might be a by-election. Well, you know, if I think about the programs that I watch, the news stories that I read, there are continually items of speculation on whether particular individuals politically in this House might leave early, might retire, might resign. Were you to find favour with the point that the member from Mount Royal is asking you to make, you would be effectively making that type of speech illegal or outlawed speech that would be affecting the privileges or offending the privileges of every member of Parliament if it ever happened. Kind of putting this special cloak of protection around parliamentarians, insulating them from the normal part of the political and journalistic discourse. Think of the logical outcome were you to find favour with the member from Mount Royal's suggestions. A political pundit goes on a panel on a TV show and says, well, we've heard, that the member for York Simcoe may want to return to the private sector soon, and it's more lucrative anyhow, and so there's going to be a by-election there in that riding maybe. All of a sudden, that pundit, having speculated on that, is going to be found having offended the privileges of the member, subject to a contempt of Parliament ruling, subject to the fairly extreme potential consequences that are available to the Speaker in that case. That seems to me very unreasonable. The same would apply to any journalist who would engage in that kind of speculation. Entirely normal freedom of speech and expression. The member for Mount Royal is asking you to suppress that. That's the logical outcome of his decision. There are fundamental rights that exist in a democracy, and I can understand his concern about his privileges being offended. But to say that one cannot speculate on his future, that form of freedom of speech should forever be chilled and suppressed, is to me an overreach that is far too great, that really reflects more his insecurity rather than a confidence in the robustness of our democracy, of our long political traditions. So I'd be very concerned, Mr. Speaker, were you to go down that path with its impact on suppressing democratic activity, suppressing the freedom of speech, not just of political parties, but of every single individual outside this place, and saying to them that somehow we are beyond their ability to speculate or talk about. Because if they say anything negative about our performance, if they say that we might leave, that we have other plans, or that we're not working hard enough, that they are somehow offending our privileges. That's what he said. He said, well, they're saying since I'm leaving, I'm not working hard enough. I'm not doing things for them. Well, guess what? People say that about members of Parliament every single day. Some people say about every single one of us, collectively, that we're not doing that. That should not be found to be a breach of our privileges. That should be part of what it is our challenge every day in this House and outside this House to address as part of a normal democratic discourse. So, Mr. Speaker, I would caution you very strongly against taking the invitation that has been presented to you, chilling that freedom of speech that exists in our society, chilling the democratic discourse, and allowing members of Parliament to somehow be insulated from criticism of their performance, speculation on our jobs by anybody out there. That would be a decision that would be overreaching and unprecedented in my view. When this matter was first raised, I somewhat jokingly said it's quite evident the member is still here. I don't think anybody's disputing that. But I pointed out that Sir John A. Macdonald in his era faced on a regular basis almost every year publication in the Globe by George Brown, who was also a member of the legislature at that time, of story, he was the owner of it and the proprietor, stories that his departure was imminent, which obviously didn't happen for many decades, but that was what he would publish all the time. Sir John A. Macdonald, in the greatest traditions of democracy, understood that was part of normal discourse. We have seen no evidence that were any concerns raised that his privileges were offended. He was willing to go out and address it by doing his job and performing and being part of the democratic process. The fact is, this has been going on as long as politics in this country. It is a normal part of politics in this country, and it's not a kind of speech that should begin to be chilled at this point. Thank you, Mr. Speaker.
We'll allow the honourable member for Mount Royal to respond, and then I think it's time to move
Thank
forward
you,
to the debate.
Mr. Speaker. I will respond to the two intervenants on the other side. First, some reference was made to 10%ers. Mr. Speaker, your predecessor ruled that there was a prima facie breach of my privileges because of false and misleading 10%ers that were targeting households in my riding, at that time targeting only the Jewish households in my riding. It's part of a pattern, Mr. Speaker. I know they covet the riding. I know they would like to win the riding of Mount Royal, Mr. Speaker, but you have to do so on the merits. You can't do so by false and misleading and prejudicial information as took place in the 10%ers, which your predecessor ruled as was a prima facie breach of privilege, and with a repetition now with this false and misleading phone calls. Again, Mr. Speaker, this is not a question of rumours of a by-election. Right. We're all subjected to that kind of thing. People in my riding or people in any riding might be asking their member, I heard you might be resigning. I heard you might be going elsewhere or whatever. That's part of sometimes constituents asking a legitimate question to their member of parliament. But this is not what is being asked here. These are constituents who have been told in false and misleading phone calls by an agency supported by the Conservative Party that there is an imminent by-election and that the member has resigned or is about to resign. I shouldn't have to be back in my riding this weekend, not people coming up to me and saying they heard rumours. That's part of the normal give and take. But coming up and say, I was called and told that you have resigned. I've called and told there's an imminent by-election going on. That's what, under the principles of breaches of privilege, that's what is called sowing confusion in the minds of the electorate. That's what's called impeding the Member of Parliament in the performance of his duties, because I can't speak with my constituents. I can with regard to rumour, but not when they are telling me that they are getting calls making statements of fact, when these are not statements of fact, but they are false and misleading misrepresentations of fact. That's a fundamental difference. This is not a matter of chilling speech. The opposite member elevated this to absolute freedom of speech. Mr. Speaker, if we look at our whole law in this country, our whole constitutional law, there's no such thing as absolute freedom of speech. Right. You have laws with respect limitations on speech with regard to perjury so that people can have a right to a fair trial. You have limitations on false and misleading advertising, Mr. Speaker, directly on point so that the consumer can be protected against false and misleading advertising. You have laws with respect against obscenity so that people can be protected with respect to their human dignity. I can go through the whole law of free speech, Mr. Speaker. It happens to be something that I happen to have a certain degree of expertise in, having written on it, pleaded it before the Supreme Court and I. This has nothing to do with free speech. This has everything to do with false and misleading and prejudicial information held out in a representation to constituents and held out as if it were a statement of fact, clearly causing prejudice, clearly undermining the role of the member. If the members opposite say, well, they're happy to see that I'm very active and involved. Yes, Mr. Speaker, I am active and involved. That's our responsibilities as members, to be active and involved. But when the constituents believe not only that you're not active and involved, but that you're not even maybe a member anymore, that you have stepped down, that you're about to step down, this transforms the entire relationship between the member and his constituents. Equally, when I was asked this past weekend that they heard that I had stepped down, and I began to tell them about some of the things that I was doing with respect to Bill C-10 in his house, which is somewhat ironic that they're speaking on this today, because or maybe not so ironic, because we're supposed to enter into a discussion on Bill C-10. It's a nice diversionary approach on their part, but let's leave that aside. The point is that the members of my riding were not aware of the work that I have been doing, and that was precisely what I said in my point of privilege, that it is not only false and misleading, but it overtakes and overshadows and effectively obscures, if not excises, the work that I am doing and the opportunity to engage in what they have called political dialogue. I'd love to be in political dialogue. I don't mind criticism. I don't mind voters coming up and saying, your position on Bill C-10, we totally disagree with it. That's fine. That's fair comment. But that's fundamentally different from a voter coming up to me and saying, oh, how come you're not even involved on Bill C-10? In other words, you're not there. That, Mr. Speaker, is where the prejudice is. The reduction of the Member of Parliament as if he is no longer a functioning Member of Parliament. So that all the work that I've been doing in the last 2 weeks, whether it was getting up in this House, speaking on Bill C-304, Private Members' Bill, on the issue of freedom of speech and hate speech, where I thought the intervention there was important, or that I've undertaken the representation of an Egyptian blogger, a leader in the Tahrir revolution, now being played out in Egypt, who have been imprisoned for allegedly insulting the Egyptian military. A rather dramatically important case. No knowledge of that, my constituents found. When I held a press conference on that case, the questions that I was asked by journalists here is, are you resigning? Have you resigned? Is there a by-election? So it did interfere with my work, interfered in my exchanges with the media, interfered with my exchanges with my constituents, interfered in the public perception of the work in which I was engaged. And so, Mr. Speaker, I just want to conclude by saying that there is no suggestion here that any speech be chilled or suppressed. What is suggested here is that a practice, a misconduct that misrepresents matters that relate directly to the performance of members in their duties here as members of Parliament. To say that it does not address what is being done in this House, it only addresses the capacity of members, and not only me, to perform their duties in this House and as a member of Parliament when outside this House with their constituents, amongst the public, the media and the like. It has a pervasive and persistent prejudicial fallout, impeding, if not prejudicing, the member in their performance of duty. It comes directly within all the principles and precedents that I cited to you in my two statements respecting the request for a prima facie finding of a breach of privilege. Thank you, Mr. Speaker.
Thank the honourable member for his further interventions, and I will take all the points made under advisement and come back to the House in due course. Orders of the day, order du jour.
Government orders, government bills, comments.
10, Safe Streets and Communities Act.
There are 88 motions in amendment standing on the notice paper for the report stage of Bill C-10. La motion numéro 58 ne sera...
Motion number 58 will not be chosen because it requires a royal recommendation. Numbers 4, 6, 10, 12, 14, 19, 54, 60, 61, and 88 will not be selected by the chair as they could have been presented in committee. Motions numbered 3, 7, 9, 11, 13, 15 to 18, 37, 40, 42, 44, 46, 48 to 50, 52, 55 to 57, 59, 63, 72, 74, 75, and 79 will not be selected by the chair as they were defeated in committee.
Examined, and the chair is satisfied that they meet the guidelines expressed in the note to Standing Order 76.15 regarding the selection of motions in amendment at the report stage. The motions will be grouped for debate as follows. Group numéro 1, les motions...
Group number 1, motions numbered 1, 2, 5, and 8. Group number 2...
6, 38, 39, 41, 43, 45, 47, 51, 86, and 87. Group numéro 3.
Group number 3, motions numbered 53, 62, 64 to 69.
4. Motions numbered 70, 71, 73, 76 to 78, 80, and 81. Group numero 5.
Group number 5, motions numbered 82 to 85. The voting patterns for the motions within each group are available at the table. The chair will remind the House of each pattern at the time of voting.
Motions numbered 1, 2, and 5 in group number 1 to the House. Mr. Harris, St. John's East, seconded by Mr. Dubé, moves that Bill C-10 be amended by deleting Clause 1. Motion number 2. Ms. May, seconded by Mr. Plamondon, moves that Bill C-10 in Clause 2 be amended by adding after line 10 on page 3 the following. Terrorism includes torture. Torture has the meaning given to that term in Article 1, Paragraph 1 of the United Nations Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment.
Motion number 5. Mr. Kotler, seconded by Mr. Lamoureux, moves that Bill C-10 in Clause 2 be amended by adding, after line 6 on page 5, the following. 6.
Section 1. The defendant's conduct is deemed to have caused or contributed to the loss of or damage to the plaintiff if the court finds that a
listed entity caused or contributed to the loss or damage by engaging in conduct that is contrary to any provision of Part 2.1 of the Criminal Code, whether
contrary to any of sections 83.02 to 83.04, 83.08, 83.1, 83.11, or 83.18 to 83.231 of the Criminal Code for the benefit of or otherwise in relation to that listed entity. Debate. The Honourable Member for St. John's East.
Thank you, Mr. Speaker. And we are now getting down to the later stages of the bill, report stage, after having a rather short time in committee to deal with this. It could have been shorter, but as we have seen with the list of amendments here at the report stage, it's pretty clear that no party was satisfied with the bill at second reading, at committee, or here in report stage. In fact, the government itself moved a series of amendments at report stage, clearly indicating that not sufficient consideration had been given to the bill, either in the preparation of it for second reading or certainly in the committee. We had one meeting devoted to one aspect of this omnibus bill, the offences, the Terrorism, Justice for Victims of Terrorism Act, and yet none of the amendments that Mr. Kotler, that the member for Montreal, Mount Royal, moved were accepted at the committee, and yet we had 5 or 6 or 7 amendments from the government at report stage trying to fix what that could have been fixed in committee. So we've got this omnibus bill being rushed through. My amendment number 1 is to remove the short title. The short title is the Safe Streets and Communities Act. And the reason we want to remove that title is because, aside from some of the provisions to do with sexual assault and offences against children, which we supported, every single expert that came before our committee, anybody who had done any study, anybody who had any credentials based on their work, their training, whether they were professors of law, professors of criminology, people who had studied this, representatives from the Canadian Bar Association who are experts in this field, representing prosecutors and defense counsel, the people from groups who had the Barreau de Quebec was another group that came with criticisms of this bill, essentially saying that overall the provisions of this bill were going to lead to greater crime in this country and less safe streets. We had strong representations from the Attorney General of Quebec, who came and passionately spoke about the experience in Quebec over the last 40 years in dealing with young offenders and the principles which they operate on, which are being changed by this legislation. And he said quite strongly that the changes that were being proposed here were so contrary to the experience and prospects of young people in the youth justice system in Quebec that he wanted them changed. He wanted exemptions from the provinces to be able to make exemptions for the publication of young people's names, for example. He complained about the use of adult sentences. He complained about changing the principles of sentencing for the Youth Criminal Justice Act to add deterrence and deterrence, individual deterrence, and denunciation as principles of sentencing as opposed to rehabilitation. He talked about how successful that they'd been in Quebec in keeping people out of the young people out of the jails to the point that they have a greater success record than the rest of the country. And so when we hear expert after expert telling us that the results of the sentencing changes here, particularly the mandatory minimums, particularly the lack of flexibility in allowing judges to fashion sentences in extreme cases, we were overwhelmed, frankly, by the received wisdom of those who had expertise that there was something wrong with this bill. We opposed it at second reading. We tried to make substantial changes to the bill in committee, given the limited time that we had, and we were unsuccessful. Not a single amendment proposed by any opposition party was accepted in the clause-by-clause study of this bill. Yet, in fact, some of the amendments that were proposed by the member for Mount Royal are actually mirrored in the amendments proposed but ruled out of order by the Speaker by the government here at the report stage. So we've got a very difficult situation here. I realize it's symbolic in the sense of changing the name of the bill, but when you go around calling a piece of legislation the Safer Streets and Communities Act and then want to limit the debate to something in the order of we in the government are in favour of being tough on crime, and the opposition over there, they seem to love criminals and want to have things a lot easier for them. That's the nature of the debate that the government has tried to foist upon the Canadian people. But the response of the Canadian people, has been, I think, overwhelmingly critical of this government's approach to changing the fundamental aspects of our criminal justice system. There is, and there are some exceptions. And not everything in the bill, by the way, is negative or bad. We supported many aspects of it. But to say that this bill, that this piece of legislation, is something that's going to provide safer streets and communities is laughable. It's laughable because there are people, yes, who believe that people don't get heavy enough sentences for what they do, and there may be selective ways of doing that. But this bill and the way it tackles this issue has resulted in the most consistent level that I've seen of opposition from those who are concerned about the nature of our criminal justice system that I've ever seen. And even those who support the bill, the Canadian Association of Chiefs of Police, they say they support it in principle. Even those who are concerned about this issue of not having tougher sentences, and some victims of crime came forward to say that. Others say that they were more concerned about prevention and rehabilitation. But there are those who think that there should be stronger sentences, and that's something that I think our courts are in fact listening to, and our judges are listening to. And there are aspects of this bill that we support that deal with that. But to call the overall bill the Safe Streets and Communities Act, when the expert evidence has said that the effects of this bill, the overall effects of this bill, in fact, is more likely to lead to more crime, more recidivism or repeat offences, more victims of crime, and less safe streets. So therefore, our amendment number 1 is directed at doing just that. Now, we do have other aspects of this. Some of the amendments in this grouping, 2, 5, and 8, relate to the issue of the, it's called an acts of terrorism against Canadians and Canada and Canadians, but really it's the establishment of a new tort to allow victims of terrorism, acts of terrorism, to bring civil suits against foreign countries or foreign agencies. We have some problems with that bill. We don't have a problem with the approach. There's a number of amendments to try to fix it. The government itself has recognized that at this stage, but a little too late, that yes, it should have been fixed. But that's an indication of how rushed this is, how they failed to give the proper time to consider this, and yet, it underscores the fact that this bill is being lumped together with 8 other bills in this omnibus bill for clearly political reasons and ideological reasons to support their notion that they're tough on crime and somehow or other the opposition isn't, when we're actually trying to improve the bill, make the criminal justice system fairer and more reasonable, and give rise to the fact that changes had to be made in this bill, but they're not being made. In the United States is the United States, which is probably the place in the world that has the highest rate of incarceration. Even they have safety valves for mandatory minimum sentences. This bill has none. There would have been an opportunity in committee to fix this bill, and many changes would have been made in the committee if there was more time. The Speaker said that the government's amendments were all ruled out of order because they could have been presented in committee. That's what the Speaker said. In fact, they could have been fixed if we actually had more time to do a proper job. We argued for more time in the face of time allocation.
Questions and comments? Questions and comments? L'honorable député.
The Honourable Member for Saanich Gulf Islands. Thank you, Madam Speaker.
The Honourable Member from St. John's East, about his very last point, I think it's very telling and important that we examine the problem of having rushed this bill through committee and now having the government amendments ruled out of order. Were those amendments, I'd like to ask the Honourable Member for St. John's East, that opposition members would have supported? They certainly would have cleared the committee had they been presented then. And what are his thoughts as to why those efforts to fix the bill now come too late?
Honourable Member for St. John's East.
Well, I think it's pretty clear that when after the first day we heard had 2 hours of debate, and the member from Mount Royal moved a substantial number of amendments to try, as he said, we're trying to fix and improve this bill. That's what the clause by clause is for. It's clear that the government didn't really have enough time to consider the reasonable amendments because some of the amendments that the government has put forth are almost mirror or slightly different, but properly considered ways of changing and improving the bill. I'm extremely disappointed, as I think Canadians are, that parliamentarians from both sides didn't get an opportunity to do their job because we went into the second meeting with a motion saying this is going to be done between 8:45 a.m. and midnight tonight or not at all. And we ended up in I guess was called a filibuster, but an attempt to focus attention on that problem and try to solve it. Obviously, this job is rushed.
The comments, l'honorable député de...
The Honourable Member for Charlebourg-Haute-Saint-Charles. Thank you, Madam Speaker, and I'd like to thank the Honourable Member for St. John's East. This is not a bill that Quebec wants. Many provinces don't want it. We heard the protestations expressed by many provinces stating that they didn't want anything to do with it. I'd like to know whether the member for St. John's East thinks that by building mega prisons we'll make our streets safer.
The Honourable Member for St. John's East.
Thank you, Madam Speaker. Obviously incarcerating more people may keep those individuals away from society for a period of time. but people who go to jail get out. They don't stay there for the rest of their lives. The results of lengthy periods of incarceration, and because the prisons will be full, they lack the ability to have rehabilitation programs to better prepare people to return to society and be better members of society will be diminished. So that's one of the ways we're going to have less safe streets, because a young person who might otherwise be rehabilitated and avoid the criminal process may end up being a hardened criminal and have lead a lifetime of crime, inflicting harm upon society. And that's the expertise that said this is going to lead to less safe communities and less safe streets. Obviously, the costs are enormous. The provinces don't want to bear those costs, and they have their own views in many cases on how, particularly the youth justice in Quebec, or the use of adult sentences in some circumstances, is in fact contrary to the experience that they've had and the ability to have a better youth justice system than other provinces. So I think overall the effect of this is going to be less safe streets. That's what the experts tell us. I know there's an emotional reaction that some people have to crime, and lengthy sentences give some satisfaction. But there are other ways to achieve safer streets, and the government is not looking at them.
Questions and comments? A very short question. The Honourable Member for La Salle-Liban, and there's 1 minute left. Thank you, Madam Speaker, and I'd like to start by saluting the efforts of the member for St. John's East, all of the time and effort he's put into this file. My question is this. What solution does he see to achieve the objectives contained in this bill?
Well, I'll just succinctly say that greater effort on prevention, more contribution to police services and enforcement, and greater effort on rehabilitation. I think that's pretty important. And in our Aboriginal communities, we've got 6 or 7 times the population percentage of Aboriginal people in our prisons. There's something clearly wrong with that, and significant efforts have to be made to work on prevention in Aboriginal communities and fix our justice system.
Debate, the Honourable Member for Saanich Gulf Islands.
Thank you, Madam Speaker. It's with great pride that I rise today, and I know that the amendments that are being put forward today by myself on behalf of the Green Party, by other members in the other opposition benches, the official opposition, the Liberal Party, and so on, speak to a desire of the majority of Canadians to see this bill fixed. I particularly am speaking to an amendment being put forward under Part 1, the Justice for Victims of Terrorism Act. And I want to begin my brief remarks by paying tribute to one extraordinarily brave Canadian woman, Maureen Busnicki, whose great courage and perseverance in the face of losing her husband, Ken, in the disaster at 9/11 is something that I think inspires us all. I had a chance to talk to Maureen in the Justice Committee hearings during the time that we were actually transfixed by a government motion to end debate and push the whole bill through that day. And she was disheartened as an individual Canadian that so much in this bill was being caught up all at once in an omnibus bill, because as much as I support the efforts to allow Canadians such as Maureen, who ever experienced the tragedy of personal loss through an act of terrorism overseas, as much as it's quite right and appropriate that Canadians should be able to seek civil remedies overseas, there is much in this bill that changes the characteristics of Canada, changes the values of Canadians in ways that do not reflect the kind of country we are. In fact, it's one of those trite things that was said after 9/11. If we abandon civil liberties, if we change what we are as a country, we've actually let the terrorists win. If we throw people in jail on mandatory minimums without the discretion of a judge who sees the person before him, without the opportunity of the criminal justice system to work towards restorative justice, without the opportunities that a compassionate justice system has to figure out, is this person deserving of jail time, or does this person need to be in a mental health facility where this person, he or she, can get the help they need? Is this person a victim of systemic racism, or is this person someone for whom only criminal justice will work? So in putting forward my first amendment, which relates to the Victims of Terrorism Act, I want to say that I think it's an important improvement in Canadian law. I support it. And the amendment that I've added today, should it be passed, would only expand the ambit of those Canadians who have been damaged by acts that we find fall well below the rule of law. My amendment adds to the definition of terrorism that we would also recognize an act of torture to be something for which Canadians could seek redress overseas. It would apply to the case of someone like Maher Arar, who has been taken in violation of all that is decent, in violation of all rule of law, and not in recognition of his Canadian citizenship at all, and subjected to torture, that he too would have redress to these civil remedies. But since I have the opportunity to speak to the bill, and as the honourable member of the opposition party, official opposition, has done, let me also speak to the broader problems. This bill, in the view of every single criminologist, expert, academic who appeared before the Justice Committee and who has commented on this through the media and in learned articles and so on, there isn't anyone who has an experience of mandatory minimums who believes that they work, who believes that they will actually reduce crime, who believes they will do anything but drive up the cost of our system and impose on the provinces, as has been so well pointed out by the provincial justice minister for the province of Quebec, drive up their costs into what could be untold billions of dollars in the cost of new prisons. We already have overcrowded prisons. To crowd them further will, of course, impose other problems. The state of California had to actually have a court order to release prisoners because the state of overcrowding constituted cruel and unusual punishment in violation of their Bill of Rights. We don't want to be in that situation in Canada. But there's a very specific point that didn't come up in committee, and I want to raise it because it's very important, I believe, for all Canadians to recognize that every single member of the House of Commons favors law-abiding citizens. Every single member of the House of Commons supports and wants to do better than this bill does in supporting victims of crime. But that this legislation will not deliver safer streets. I can't say that forcefully enough. And one of the aspects of this, which I don't think has received adequate attention, comes from the experience in the United States, where when they've removed judicial discretion with mandatory minimums, they've given power in the hands of prosecutors to exact plea bargains. So plea bargains have become far and away more common than criminal trials, which means, of course, the presumption of innocence goes out the window. There's generally a sense that if you insist on your innocence and go to trial, you'll be punished down the road with a mandatory minimum, and that's, of course, how prosecutors exact plea bargains. To say, well, if you insist on going to trial, we're going to increase the sentence, and if you're found guilty, you're going to jail for 20 years instead of 2 years. But I found this particular aspect interesting in an article that came out in the New York Times on, its title is, Sentencing Shift Gives New Leverage to Prosecutors, September 25th, 2011, in which they quote a legal scholar who was a former conservative federal judge and prosecutor, now a law professor. And I want to emphasize this and hope that members of the governing party, members of Parliament, will reconsider this and give weight to this last moment we have at report stage to fix this bill and get rid of mandatory minimums. This is what former Judge Paul Castle said, and I quote, "Judges have lost discretion, and that discretion has accumulated in the hands of prosecutors, who now have the ultimate ability to shape the outcome. With mandatory minimums and other sentencing enhancements out there, prosecutors can often dictate the sentence that will be imposed." Close quote. The story goes on to say, without question, plea bargains benefit many defendants who have committed crimes and receive lighter sentences than they would have at trial. In other words, taking discretion away from judges does not guarantee you on the government benches who so desire to see people who are guilty of crime put behind bars. You may get the perverse result that I'm sure you do not want, that mandatory minimums drive in a completely new system in which prosecutors have the ability to plea bargain, and in that process, people who would have been found guilty before a judge and jury and be subjected to a harsher sentence get, in fact, a lighter sentence. Yes, we will overcrowd our jails, Without the safety valve provisions in the amendments that we'll be reviewing today, without an ability to say mandatory minimums should not apply here, without that we will be crowding our jails. And if we are not putting sufficient resources, which we know as of now we are not, into programs for mental health, to help people with addiction, we know that so many of the problems that occur in crimes and streets have to do with systemic problems of poverty, systemic problems of lack of access to mental health resources and treatment and care, and systemic problems of addiction. If we're not dealing with those, we are merely throwing people from the streets where there are problems into jails. And jails are not a solution to mental health problems. Jails are no solution to the absence of affordable housing. This is not legislation that will work for Canadians. It will not make safer streets. It will make meaner streets. This is not an act that deals with Canadian values. This speaks to some other country that I don't know, and I don't want to live in a country that thinks that it's better to impose stark mandatory minimums rather than have a criminal justice system rooted in the rule of law that recognizes the primacy of the value that goes back to the times of common law. Before the existence of this great country of Canada, we recognized the presumption of innocence. We mustn't lose that. We mustn't live in a country where a member of a governing cabinet can look across the floor of the House and accuse an opposition member as if it was a crime to have worked as a lawyer for the defense. The defense of people accused of crime is essential in a criminal justice system. People, as we know from Donald Marshall Jr., as we know from the Milgard case, innocent people get accused of crime. Those people who defend them in court are an essential part of the fabric of a civilized society that understands the rule of law. I don't think I've ever been so deeply shocked by anything I've heard in the House of Commons as an accusation that the honourable member, who now stands as the official opposition House leader, was somehow a bad person because before entering politics, practicing law, he defended people accused of crime. Remember that when someone is accused of crime, you don't say they're defending criminals. Their presumption of innocence is an essential part of the fabric of a civilized society. I fear we're losing that. As we go down...
Order, please. Order, please. Order, please. The honourable member may be able to continue her comments in questions and comments. Questions and comments. The honourable member for Sudbury.
Thank you, Mr. Speaker, and I'd like to thank the honourable member for her speech. She does talk about a lot of the important things that we're trying to bring forward with many of the amendments. And one of the things that caught me right off the top of her speech was relating to support for individuals with mental health issues. And in my riding of Sudbury, the Canadian Mental Health Association does great work with those individuals, but we're starting to see more and more individuals that require mental health services end up in jails and not necessarily getting the services that they need. And what we don't want our prison system to become is the next system for individuals with mental health issues to get those services there. And I'd like to hear the honourable member's comments as to what do we see coming forward with individuals with mental health issues, and how is this bill going to do anything to try and change that or even support them? Thank you, Madam Speaker.
Honourable member for Saanich Gulf Islands.
I thank the honourable member for Sudbury for his question. You know, it's very clear this legislation. There were attempts. The witnesses appearing on behalf of the Trial Lawyers Association and other members on behalf of the legal community argued that this legislation should be amended to take into account mental health issues. That wasn't possible at committee. Those amendments were not given adequate opportunity to be debated or discussed. We're bringing forward in this set of amendments a safety valve that deals with mental health issues. This legislation will, in fact, criminalize the mentally ill. That's what it will do. We are not seeing the resources that we need in prisons to help people with mental health issues, and we aren't seeing the mental health issues addressed on the streets. So if we're not dealing with it and we're not helping those individuals, we're jailing them.
Questions and comments?
The honourable member for Pierrefonds-Dollard. Thank you, Madam Speaker. We have before us a very complex bill that is an omnibus bill, in fact, of several others. We know that the Conservative government is saying that we consulted families. But did they really listen to the experts? Also, that we can't know if they did. My colleague proposed amendments, and perhaps she could remind us what she based her amendments on. Who did she listen to in order to arrive at the conclusions that amendments were needed?
Member for Saanich Gulf Islands.
Merci, Madame la Présidente.
Thank you, Madam Speaker. Yes, I listened to all experts, the witnesses, academics, legal experts.
Wealth and body of evidence that calls for this bill to be amended. There are virtually, I can say actually not virtually, every criminologist is saying that mandatory minimums do not work. Do not go down this road. And in listening to them, I put forward amendments, and I have a great hope that at this last minute, members of the governing party will literally give it every consideration and consider changing the law to make it work for safer streets.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Health. A very brief question.
Very quick question then, Madam Speaker, and thank you very much. I thank my colleague for her speech. And I did listen to her as she was saying that she has issues with the mandatory minimums. And I was wondering if she could comment that if she realizes that they are minimums, so a judge could actually decide if it was a violent repeat offender, a rapist, a murderer, that he could give them a greater sentence. And as well, if she could let the House know which ones of the mandatory minimums, which actual sentences she would be against, that she feels is too long for some of these violent repeat offenders.
The Honourable Member for Saanich Gulf Islands.
Thank you, Madam Speaker, and to the Parliamentary Secretary. First of all, the problem that I have with mandatory minimums is not personal to me. It's a universal problem among people who've seen their operation. Yes, you can go to higher sentences, but I was giving an example from the experience in the United States from a retired judge, former Judge Paul Castle, who said that what is happening, so it's not theoretical, what is happening is greater discretion to prosecutors, and that by the time, basically, these are not cases that get to court. There is a plea bargain that ends up with lighter sentences to people that, had they gotten to a judge, could have had the sentences increased. And in brief, my amendments proposed deleting all the mandatory minimums for all of the offences, not because these people shouldn't go to jail, but the judge should decide in each case how long each convicted person should go to jail.
Resuming debate, the Honourable Member for Mount Royal.
Thank you, Madam Speaker. And at this stage in the proceeding, the motions that I will be referring to relate to those grouped in number 1 and numbered 2, 5, and 8 in particular. In effect, Madam Speaker, what I will be doing is moving a set of motions that relate to one particular bill at this stage in the proceeding, which is among those being addressed, and that is the bill respect justice for victims of terror and amending the State Immunity Act. I also want to join, in the words of my colleague from Saanich Gulf Island, in her reference and paying tribute to Maureen Baznicki, Madam Speaker, as she and as a victim of terror has been advocating for this type of legislation for years, along with the Canadian Coalition Against Terrorism, and I want to reference them for their advocacy all of these years and pay tribute to them. Madam Speaker, if we look at this piece of legislation, we will see, though it may not appear to be that this is really transformative legislation. This is, I would say, Madam Speaker, historical legislation. This is not a word I use lightly, but if one looks at our laws, and particularly with respect to our laws both in the matter of giving civil remedies to victims of terror against the terrorist perpetrators, which now do not exist, and the reason that they do not exist is because we have a State Immunity Act that immunizes the perpetrators of terror from any civil suit. So we will see that this is the first time that we will, in effect, be amending the State Immunity Act to give victims of terror a civil remedy against their terrorist perpetrators. And that is why, Madam Speaker, I supported this legislation and support it in principle. And that is why I'm moving these amendments, Madam Speaker. They are not in opposition to the legislation. They are intended to help improve the legislations, to give victims a more effective voice against their terrorist perpetrators, and in fact to hold the terrorists more expressly accountable for their terrorist acts. So that's the first thing, Madam Speaker, why this is so transformative. For the first time, we will be amending the State Immunity Act to give victims a voice to hold terrorists accountable. The second, Madam Speaker, is that we will be correcting a historical anomaly in our legislation. As it now stands, there is a commercial exception in the State Immunity Act. By a commercial exception, I mean that if a Canadian victim has suffered damages by reason of a breach of contract, he or she will have a civil remedy. But if he or she is a victim of terror, he or she will not have a civil remedy. And so we have a situation here where, in effect, our legislation gives an implied preference with respect to actions taken for breaches of contract as against actions taken by victims of terror. And this brings me to the third particular transformative dimension, is that this is the first time, Madam Speaker, that we will be protecting or preferring victims of terror against their terrorist perpetrators, who up to now, Madam Speaker, have been immunized by our law for their acts of terror against Canadians. And so I've been framing this, Madam Speaker, in what, as I say, is a transformative piece of legislation for the reasons mentioned, and also the reasons why I moved the amendments in this regard. Indeed, Madam Speaker, one of the things I find ironic and really disconcerting is that such a piece of transformative legislation should have been bundled together with 8 other pieces of legislation. I would have thought that the government would have wished to highlight such a transformative piece of legislation. I would have thought that a government that purports to always be wishing to give voice to victims, and in this instance the victims of terror, would have wished to frame this as a centerpiece of its criminal justice approach, rather than bundle it together with 8 other bills. I would have thought that the government would have wished to have us consider this both in the House when the legislation was first tabled, and then in committee with all the attention and the deliberation and the discussion that it warranted for being such a transformative and, as I said, historical piece of legislation. Accordingly, Madam Speaker, as I mentioned, I supported this legislation. I even indeed had separately a private member's bill which sought to give victims of terror a civil remedy, and I was pleased, therefore, when the government introduced their legislation to do exactly that. But I found it ironic that my purported amendments would have been so summarily rejected, since they were put forward for the very purpose of improving the very legislation that the government had introduced to give victims a voice. And indeed, the representations made by the government when I put forward those amendments were, number one, this was a filibuster. Madam Speaker, we had already had an abbreviated debate in the House on the tabling of all 9 bills. We then moved to committee and had an abbreviated debate there. I moved those amendments as quickly as possible in the abbreviated time that we had, only to be told that we were filibustering, or being asked, why are we considering this legislation again in this House? Madam Speaker, it needs to be stated for the record that this is the first time this legislation is being considered in this House. It was never considered in this House. For the government to attempt to abbreviate discussion on this legislation on the grounds that it had been discussed here before, even if that were true. But it is not the case, Madam Speaker. Therefore, it warrants the fullest possible discussion. I will limit myself now to the specific amendments that I put forward, as I said, in order to improve the legislation. Madam Speaker, the first was to give effective civil remedies to victims of terror against the perpetrators of terror. As this legislation now stands, it still immunizes state perpetrators of terror from their any acts, injury, damages from any damages or injury caused by their acts of terror, let alone the wrongful deaths that ensue. I find it surprising, Madam Speaker, and another anomaly, that this legislation will give victims a civil remedy against the agents or proxies of the state engaged in state terrorism, but not against the state itself. So if you take the situation of Libya and the blowing up of the Lockerbie, it would have been okay under this legislation if we could have found an agent or proxy of Libya that carried out the act, some terrorist organization acting on Libya's behalf. But we could not have sued, and the victims could not have directly sued Libya, because Libya would be immunized under this legislation. Similarly, you could not take an action now against Iran for any state act of terror, but only against any of its agents or proxies like Hamas and Hezbollah as listed terrorist entities under Canadian law. Madam Speaker, this legislation, I put forward this motion again in order to give victims an effective voice against the terrorist state. The second thing is it does not allow for an action to be taken against a non-listed entity, terrorist entity in our law, which is functionally associated with a listed entity. We should allow for that, Madam Speaker, because terrorists can change names and therefore we would not be able to sue. The third is to give an effective remedy for purposes of execution of judgments by the plaintiff victims. We don't have the kind of effective remedies in that regard that we need. And finally, Madam Speaker, I think that giving the government the power to list the governments that will be seen to be terrorist states in this regard is an arbitrary exercise of discretion that we should not give to states. Even the government's own witnesses said, don't go there, don't give that arbitrary power, read the listing of terrorists to the government. Thank you, Madam Speaker.
Questions and comments? Questions and comments? The Honourable Member for Scarborough-Guildwood.
Mr. Speaker, I always learn something when I listen to the Honourable Member and enter into a discourse with respect to pretty well any subject. And I thought this speech was actually one of those ones where it was very, very useful and a very thoughtful approach to actually making a remedy effective. And I think the point that he was making was that essentially the remedy, a civil remedy, to be extended not simply to the agent but to the state actor. And I just, as I was thinking as formerly a practicing lawyer, that it's great to have remedies, but if there's no effective execution on the remedies, if there's no effective ability to actually secure funding to satisfy the judgment, then the entire exercise is useless and quite costly, particularly in a civil context. So I'd be interested in his thoughts with respect to what appears to be an extension of the law, i.e. extending civil remedies to an agent, when in fact suing Hamas is a total waste of time, or suing the agents of the Lockerbie catastrophe is also a total waste of time. What's useful is being able to get to the state.
Honourable Member for Mount Royal.
Yes, I want to thank the member for Scarborough-Guildwood. I always benefit from my exchanges with him, and here's yet another example, and he's exactly right. what this legislation does not do is give the victims of terror an effective remedy against the principles involved in the terrorist action. It gives them a more limited remedy only against their agents or proxies. If we really want to give the victims of terror the voice that the government purports to wish to give them, then we have to authorize a civil remedy against the state terrorist perpetrators themselves. Otherwise, we not only circumscribe but limit the civil remedy, and indeed we continue to immunize the terrorist state from liability.
Questions and comments. The Honourable Member for Saanich Gulf Islands.
Thank you, Madam Speaker. My question for the Honourable Member for Mount Royal, and again, I thank him for a very thoughtful address and focusing on his amendments. But I was taken by one thing he said, and as a shall we say, newer member of Parliament in this place, when the Honourable Member said that although it's been oft repeated that this bill has been debated in this place, and he put it forward that this is the first time this bill has come to the House of Commons. I'd be very grateful if he could expand on that, because it's so oft repeated, it's hard not to believe it's true. But I also recognize that this is new legislation and we have not had adequate time to study it.
The Honourable Member for Mount Royal.
Yes, Madam Speaker, this is the first time that it is being discussed and debated in this House. It had been a similar piece of legislation introduced in the other House and debated in the other House, but it had never been introduced and debated in this House. The last I looked, we still have two chambers. And in this chamber, in the House of Commons, this legislation was only tabled for the first time and debated for the first time in the House and committee. It is, as I said, such a piece of transformative legislation that it would have warranted debate, even if it were not for the first time, and extended debate both in the House and in committee. But it is the first time that we are debating it, and it is bundled together with 8 other pieces of legislation. And, Madam Speaker, I would say each of the 8 other pieces of legislation themselves, individually and collectively, warrant their own differentiated discussion and debate. Regrettably, we don't have that, Madam Speaker, and we are at least fortunate to be able to address this, albeit the first time in this House. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Madam Speaker. I'm pleased to participate in the report stage debate on Bill C-10, the Safe Streets and Communities Act. This important crime bill continues to attract a lot of debate, both within and outside this chamber. Often, this debate focuses on misconceptions and falsehoods that have been spread through the fear-mongering of the opposition parties. I welcome the opportunity to add my voice to this debate because I want to direct my remarks to clarify what it is in this bill, what it will do, and what other initiatives the government is taking to address the issues discussed in Bill C-10.
First of all, Bill C-10 does precisely what was promised, both during the last federal election and during the June 2011 throne speech. Particularly, it reunites 9 bills that had been tabled during the last Parliament that died on the order paper with the dissolution of Parliament for the general elections.
Its objectives, as reflected in the short title, the Safe Streets and Communities Act, are clear and, in my view, should be easy for all to understand and support. Part 1 of the bill seeks to support victims of terrorism by giving them new tools to hold those who commit acts of terrorism and those who support them, including listed foreign states holding them accountable. La deuxième partie.
The Part 2 proposes reforms that will ensure that adequate and appropriate penalties are imposed for serious crimes and that the penalties reflect the serious nature of those crimes. More specifically, it will ensure that these penalties are imposed for all sexual crimes committed against children and not only for certain crimes. It will ensure that people who commit violent offenses have to spend time in prison and not in the comfort of their own homes under a conditional sentence. Moreover, it will ensure that the most serious drug offenses, such as trafficking in cocaine or heroin, which generally involve organized crime or involve the use of violence and weapons and have a large impact on health and safety of Canadian communities, will see people given consistent penalties that include prison time.
Sentencing reforms to better support victims and to increase offender accountability and management. These reforms would include clarifying that the protection of society is a paramount consideration for the federal corrections process, the Parole Board of Canada, provincial parole boards, as well as give victims the right to make a statement at parole hearings and to receive certain information about the offender. They would also rename pardons as record suspensions, which better describes their real nature and would extend periods of ineligibility to apply for them, as well as make certain offences ineligible to receive them. Part 4 proposes to amend the Youth Criminal Justice Act to better deal with violent and repeat offenders. These reforms include ensuring that the protection of the public is always considered as a principle in dealing with young offenders and strengthening the pretrial detention provisions to enable the detention of youth who are spiraling out of control and who would pose a risk to the public safety by committing serious offences if released while awaiting trial. Importantly, these reforms would also enable a court, in appropriate cases, to sentence a youth to custody for violent offences that involve a substantial likelihood of causing bodily harm to life or safety of others, and not just where the youth attempted to cause or threaten to cause bodily harm, as is currently the case. And lastly, Part 5 proposes immigration-related reforms that would seek to protect vulnerable foreign workers against being exploited by unscrupulous Canadian employers. Madame la Présidente.
Madam Speaker, many witnesses appeared before the Standing Committee on Justice and Human Rights to express their opinion on Bill C-10. I believe that most, if not all, of the witnesses supported the fundamental principles of Bill C-10. For example, I think that all agreed that the sexual exploitation of children is serious, and those committing sexual offenses involving children should be dealt with seriously by the criminal justice system. I think that everyone agreed that trafficking in heroin and cocaine, particularly by organized crime, must be dealt with seriously as well. And I think that most included that it is inevitable to be able to use mandatory minimums and to use the drug courts. And we think that those who exploit vulnerable foreigners should be dealt with as well.
C-10 are sitting on the other side of the House. Members from the opposition have continuously demonstrated they are completely out of touch with what Canadians want. During our study in committee and during the report stage of debate, the opposition members have tabled amendments to the bill that would repeal, Madam Speaker, the 2-year mandatory sentence for the importation of the hardest drugs in Canada. They table amendments that will mean that those who bring date rape drugs into Canada will be subject to lighter sentences. They table amendments that would allow an arsonist who burnt someone's house down to serve their sentence in the comfort of their own home. They table amendments that would delete new offences which are essential to prevent child sex offences and protect children. And the list goes on, Madam Speaker.
Canadians are concerned about crime. It's one of the reasons for which they gave our government a clear mandate to keep our streets and communities safer. Bill C-10, the Safe Streets and Communities Act, will serve, among other things, to fight against pedophiles and drug traffickers who import hard drugs like cocaine, heroin, and methamphetamine into Canada. These legislative reforms are sought out, they're necessary, and they're an essential part of the solution to fight crime in this country.
Madam Speaker, I think it's important to remind members on the other side of the chamber that although the legislative changes contained in Bill C-10 are an essential part of the solution and do achieve exactly the goals I have described, they are not the government's only response to prevent some of these crimes. The government is also tackling crime through non-legislative measures, including, for example, the National Anti-Drug Strategy, launched in 2010, has invested $588.8 million in 3 areas: prevention, treatment, and enforcement, the last of which these reforms are now proposed in Part 2 of Bill C-10. Secondly, the National Crime Prevention Strategy. It is currently providing $45 million per year through the Crime Prevention Action Fund, the Northern Aboriginal Crime Prevention Fund, the Youth Gang Prevention Fund, and the Security Infrastructure Program. And thirdly, the National Strategy to Protect Children from Sexual Exploitation on the Internet that is currently providing $71 million over 5 years. That includes supporting the RCMP's National Child Exploitation Coordination Center and providing law enforcement with better tools and resources to address Internet-based child sexual exploitation. And it's supporting also the operation of CyberTip CA, that is the national 24/7 tip line for reporting online child sexual exploitation. It's being funded by the Center for Child Protection that houses CyberTip CA, and that carries out public education and awareness on these 3 issues. Madam Speaker, I think that we can all agree that the issues covered by C-10 are serious issues. Bill C-10 provides a commensurate but tailored response to these issues that build on existing legislative and non-legislative responses. It's time for the opposition to listen to the needs of Canadians from coast to coast, to stop their fear-mongering, read this bill and understand what it really does. It's time to act together to support Bill C-10 and to make Canada's streets safer.
Questions and comments? The Honourable Member for Nanaimo Cowichan.
Madam Speaker, and I want to thank the member opposite for outlining why the Conservatives think it's important to move forward with this bill. And of course, it flies in the face of any kind of evidence that is emerging from countries like the United States, where they have taken this approach and are now backtracking because it simply didn't work. And the member talked about crime prevention, and I want to reference the Institute for the Prevention of Crime out of the University of Ottawa has actually posed a number of questions, and I wonder if the member would be prepared to answer them. This institute talks about evidence-based approaches, and they have 4 questions, and I'm sure the member won't have time to answer all of them, but these are 4 questions I think we should consider before this House, and if we had full time for debate, we would have done this. What is the evidence on proven or promising practices in the area of crime prevention? What are the gaps in our knowledge, and that includes research priorities? How will the initiative be monitored and evaluated? And how will resistance to change be addressed? And I wonder if the member could address those comments in the context of crime prevention and the measures he has indicated that they are prepared to take.
The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Madam Speaker. Well, contrarily to the opposition, we don't look to the South for solutions in preventing crime and protecting the most vulnerable elements of our society. I'm always bemused by the fact that we compare the system that we're trying to put in place to protect the innocent people of Canada, the victim, to the United States of America. Madam Speaker, it's my understanding, for instance, we always compare to Texas. Texas does not have a parole system. So that's largely different from what we have here in Canada, what we're proposing here. We're not radically changing the whole system. We're trying to protect society from the most violent and repeat offenders. Also, as I understand it, in Texas, they also have a death penalty. So what can we really draw from Texas and the other 51 states of the United States of America who all have their own criminal code? We have the benefit in Canada, Madam Speaker, of having one criminal code to send a resounding message to all Canadians that we will protect them from the criminal element. And that's what we're doing, Madam Speaker, and we believe it will work.
Excellent.
Questions and comments. The Honourable Member for Chicoutimi-Les Madam Speaker, Quebec has clearly let it be known that they don't want to foot the bill for C-10, the omnibus crime bill. And indeed, when we asked the Minister's office, the Minister of Justice, and his spoke for the figure, he said that every province should take the funds from the Canada Health and Social Transfers. So what Quebec's being asked to do is to cut into education and early childhood services, for example. And these, of course, are the kinds of things that are covered by that transfer in order to pay for jails. Is that really what the Conservative government is telling the Quebec government, to cut back in those areas to pay for jails? The Honourable Parliamentary Secretary to the Minister of Justice. Well, Canada's government and the provinces all have their areas of jurisdiction, and certainly it's in their mandate to decide how they're going to allocate those funds according to their own priorities. So it's not up to the federal government to dictate to the government of Quebec what their priorities might be. We know that Quebec concentrates very much on prevention, but there's nothing in C10 that will in any way prevent Quebec from doing that kind of work within their own system. Questions and comments? A very brief question, the Honourable Parliamentary Secretary to the Minister of Human Resources.
Government focused on these serious issues, protecting victims, and this government campaigned on a promise to make sure that we'd be tough on child sex offenders and crack down on illegal drug trafficking, really unlike our colleagues across the aisle in the NDP. Can the Parliamentary Secretary please comment on what this bill does to protect children from these serious crimes?
The Honourable Parliamentary Secretary has 30 seconds to respond.
Well, thank you, Madam Speaker. Obviously, Bill C-10 focuses, as I said previously, the most vulnerable members of society, and those are the children. Everyone will agree that children must be protected by sexual exploitation, must be protected from internet crime, and obviously anyone who goes and does this type of contact will be punished severely, and they will be deterred by doing this by being placed in prison. I mean, the people of Canada have asked for this, we've responded to it, and there's no surprise that there's provisions there to very, very seriously punish people who are in this field of criminal activity.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice. The other Parliamentary
The other one.
Oops, sorry.
Thank you, Madam Speaker. I am very pleased to speak today about Bill C-10, the Safe Streets and Communities Act, to highlight that this bill is a reflection of our commitment to tackling crime, increasing public safety, and restoring the confidence of Canadians in the justice system. The people of Canada know they can count on us to deliver to our commitments. Bill C-10 includes 9 bills from the previous Parliament. Many critics of the bill argued that the bill was too big and too difficult to understand. Mr. Speaker, I would note that the bill has had a thorough review in the Standing Committee on Justice and Human Rights. There has been no difficulty at all in understanding what these reforms seek to do. While not all members share the government's approach, I think all members of the committee would agree that their voices have been heard and we have had a respectful exchange of views. As has been noted many times, all of these reforms have been previously introduced in Parliament. Many were previously studied and some even passed by at least one chamber. These bills were at various stages in Parliament in the last session, have been debated and studied in this session, and the public and stakeholders, as well as members of Parliament, are by now very familiar with these proposals. Mr. Speaker, despite this familiarity, it is worth noting the elements and the origins of Bill C-10, in other words, the 9 bills that were introduced in the last session of Parliament. As the Minister of Justice indicated at second reading debate, some changes have been made to these bills due primarily to the need to coordinate the merger of several bills into one and make consequential amendments to effect these changes. In some cases, other modifications were made, all of which are consistent with the objectives of the bill as originally introduced. The former bills now included in Bill C-10 are the following. Bill C-4, which proposed to amend the Youth Criminal Justice Act to ensure that violent and repeat young offenders are held accountable through sentences that are proportionate to the severity of their crimes, and that the protection of society is given due consideration in applying the Act. Bill C-5, the Keeping Canadians Safe, the International Transfer of Offenders Act, which proposed to enhance public safety by modifying the circumstances that would permit an international transfer of an offender. Bill C-16, which proposed criminal code amendments to prevent the use of conditional sentences or house arrest again for serious and violent offences. Bill C-23B, the Eliminating Pardons for Serious Crimes Act, which proposed to amend the Criminal Records Act to expand the period of ineligibility to apply for a record suspension, currently referred to as a pardon, and to make record suspensions unavailable for certain offences and for persons who have been convicted of more than 3 offences prosecuted by indictment. Bill C-39, the Ending Early Release for Criminals and Increasing Offender Accountability Act, which proposed amendments to the Corrections and Conditional Release Act to support victims of crime and address inmate accountability and responsibility and the management of offenders. Bill C-54, the Protecting Children from Sexual Predators Act, which proposed criminal code amendments to better protect children against sexual abuse, including by increasing the penalties for these offences and creating 2 new offences aimed at certain conduct that could facilitate or enable the commission of a sexual offence against a child. Bill C-56, the Preventing the Trafficking, Abuse, and Exploitation of Vulnerable Immigrants Act, which proposed to amend the Immigration and Refugee Protection Act to authorize immigration officers to refuse work permits where it would protect vulnerable foreign nationals against exploitation, including sexual exploitation. Bill S-7, the Justice for Victims of Terrorism Act, proposed 2 reforms to allow victims of terrorism to sue terrorists and supporters of terrorism, including listed foreign states. And Bill S-10, the Penalties for Organized Drug Crime Act, which proposed amendments to the Controlled Drugs and Substances Act to provide mandatory minimum penalties for serious drug offences, including when offences are carried out for organized crime purposes or if they involve targeting youth. The maximum penalty for the production of some drugs would also be increased. These amendments also propose to allow a sentencing court to delay sentencing while the offender completed an approved treatment program. Mr. Speaker, Bill C-10 was studied by the Justice Committee over several weeks, and over 90 motions to amend the bill were considered. While very few were passed and many were completely inconsistent with the principles underlying the bill, each motion was given due consideration. Mr. Speaker, I would also note that over 80 motions have been proposed at report stage. Many of these motions seek to completely undo or gut the proposed amendments. As I noted at the outset of my remarks, Bill C-10 reflects our government's commitment to restoring public confidence in our justice system. Clearly, the motions proposed at report stage demonstrate that this commitment is not shared by other members of this House. Mr. Speaker, there has been a great deal of discussion about the elements of this bill that provide for mandatory minimum penalties and that restrict conditional sentences. The reality is that these reforms are carefully tailored and are targeted to offenders who commit the most serious offences. Mr. Speaker, should an offender convicted of arson receive a conditional sentence, allowing him or her to serve out their sentence at home under certain conditions? Should an offender convicted of an offence with a maximum sentence of 14 years ever be permitted to serve that sentence in the comfort of the offender's home, even under the strictest of conditions? I think all Canadians would agree that no matter what the conditions of house arrest may be, house arrest is simply not appropriate for serious offences. Bill C-10 reforms will make that crystal clear. Mr. Speaker, I would note that motions to amend the proposed reforms to the conditional sentencing provisions were made at the committee and again at report stage. Without going into details, those motions sought to permit conditional sentences to be imposed without regard to any criteria to limit their imposition, as long as certain other exceptional circumstances existed about the offender. Mr. Speaker, such sentences are not appropriate for some offences, regardless of the offender's particular circumstances. Conditional sentences were never intended to be used for the most serious or violent offences. Our reforms will clarify this once and for all and will provide the clear parameters for use of conditional sentences or house arrest. Mr. Speaker, as I noted, Part 2 of the Safe Streets and Communities Act includes former Bill S-10, the Penalties for Organized Drug Crime Act. These reforms have been introduced in 3 previous parliaments and have been passed by both chambers, but never by both in the same session. Despite our repeated debates and committee study of these reforms, there still remains much misunderstanding about the mandatory minimums for serious drug offences. As noted by other speakers, the minimum mandatory penalties are tailored to serious drug offences where aggravating factors are present. Importantly, the amendments include an exception that allows courts not to impose the mandatory minimum sentence if an offender successfully completes a drug treatment program, DTC, it's referred to. The program works with individuals who have been charged with drug-related offenses who meet certain eligibility criteria to overcome their drug addictions and avoid future conflict with the law. It involves a blend of judicial supervision, incentives for reduced drug use, social services support, sanctions for non-compliance. There are currently 6 drug treatment courts in Canada: Ottawa, Toronto, Winnipeg, Regina, Edmonton, and Vancouver. The same exception applies for other programs, so that a court could delay sentencing to allow the offender to attend another approved treatment program. Mr. Speaker, this last point seems to have been overlooked by some members, and we all share the concern about need for mental health resources, but the Criminal Code already permits a court to delay sentencing to permit an offender to attend an approved treatment program. This could be a program for mental health issues, anger management, or other similar issues. This already exists in the Code. I see you're giving me my signal, Mr. Speaker, so I will conclude by saying that the government is committed to public safety and improvements to the justice system and will continue to deliver on the promises that we have made to Canadians. And I thank you.
Question et commentaire. L'honorable député de Alfred.
Questions and comments, the honourable member for Alfred Pellan. Thank you very much, Mr. Speaker. With this bill being put forth by the government, there will be an increase in the prison population. I have some questions on that because in my riding, I have several federal institutions, and the employees on site are already having a great deal of difficulty with respect to their quality of life on the job, their safety, the occupational health and safety issues with the number of inmates, and they're not running at full capacity yet, and there are already problems. So what I'd like to know, and my question for the member opposite, is this. Will the staff in the federal institutions be increased? And is there something that will be put in place to protect employees, given the fact that the prison population will increase and there'll be an increasingly large number of problems? The Honourable Parliamentary Secretary.
Sure. And I thank the honourable member for her question and her concern. One of the problems I'm finding in this debate back and forth is that everyone keeps looking within the 4 corners of this particular comprehensive legislative package for all the answers. There are ongoing programs, ongoing dialogue with our provincial and territorial partners. As we know, with the division of powers in Canada, the federal government is responsible for legislating on criminal law and the provincial governments for administering it. So the conditions in prisons, how prisons are run, how staffing is done is part of an ongoing dialogue. And these are things that continue to be worked on, and those concerns will be brought forward in those dialogues. Thank you.
Question et commentaire. L'honorable député.
Questions and comments, the honourable member for La Salle-et-Mar. My question is to the Parliamentary Secretary, who is in government, on the government side, and was elected as a member of the government. In order to make decisions informed decisions. We need to go on studies, base our views on these kinds of studies in order to make informed decisions. So my question goes back to something she said about the bill restoring the confidence of Canadians in our justice system. I'd like to know what those remarks were based on, what studies, what she's basing those statements on. The Honourable Parliamentary Secretary.
Well, I don't know that, I thank the honourable member for her question, but I don't know that one needs studies to know. I mean, I certainly heard it when I was knocking on doors during the last election campaign. And as a lawyer of 30 years, I've been hearing this for the last 30 years from members of the public, that they don't understand why the punishment for certain crimes is not commensurate with the severity of the crime. They don't understand why someone convicted, not just accused, but convicted of serious and violent offenses can serve some of that time or any of that time in a conditional sentence or in their own homes. So this is an ongoing problem in the public's mind, and one that we are adamantly seeking to address with this legislation. Thank you.
Time for a short question and comment. The Honourable Member for Mount Royal.
Thank you, Mr. Speaker. The Parliamentary Secretary, other Parliamentary Secretary, but joined him, made reference to the fact that we should be going across the country and listening to Canadians and not engaging in fear-mongering. Mr. Speaker, I've gone across the country. I've listened to Canadians, both in my former capacity as Minister of Justice and now as an MP on this bill. And I'd like to just put two questions. Is it fear-mongering to raise evidence-based critiques of mandatory minimums, some of which are based on evidence contained in Department of Justice publications themselves, as I know them to be? Second, is it fear-mongering to raise concerns about whether Bill C-10 comports with the Canadian Charter of Rights and Freedoms when the Minister of Justice, whoever he or she may be, has a constitutional duty to ensure that legislation comports with the Charter of Rights and Freedoms?
Parliamentary Secretary.
Well, I thank the honourable member for his questions. Of course, there is a duty on behalf of the Minister of Justice to put forward legislation that complies, in our view, with the Charter of Rights. But as the honourable member said himself during the Justice Committee, there is also a constitutional duty in the minister and his portfolio to protect the public, and that is exactly what these are aimed at doing. And there is a lot of rhetoric that's come from the other side, most of it hysterical, and I do mean that in both senses of that word. Mandatory minimum penalties, there were 40 of them in the criminal code before this government took office that were either introduced by the Liberal Party, which he represents, or were not repealed by that party. Thank you.
Resuming debate, reprise de débat, l'honorable député de Pierrefonds-Dollard.
The honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. The NDP supports criminals. You wouldn't be surprised to hear that. You wouldn't be surprised to hear that because that's what the members opposite keep repeating. It's an arrogant argument, a demagogic one. And I think it's because we take crime to heart that we are opposed to Bill C-10 in its current form. If one member in this House believes that I myself want to help criminals and encourage sexual attacks on children, then he needs to stand up and say it to me. Tell me directly. Because the title of this very bill is ridiculous. Keeping our streets and communities safe. Nothing indicates that harsher sentences will make our streets safer. Now, I'd like to talk about the report of the Standing Senate Committee on Human Rights, which addresses the seriousness of the dangers faced by children. This report states that the majority of children who experience sexual abuse are attacked by people they know, people who are part of their environment, people they know. And there are some solutions put forth to fight sexual offenses against children. And it says in this report that if we were to help children to denounce their aggressors, that could put an earlier end to the nightmare they're living. And it would help to prevent other crimes, sexual crimes against children as well. Now, you would be surprised to hear that we're not talking about mandatory minimum sentences in this case. This report talks about education, about awareness that can promote self-esteem among children, to help them to have the communications tools they need. There's also mention of access to teachers, to coaches, to people who are around the children in their environment, who can listen to children. Now, there's also mention made of access to services available to a child that can help a child to find his or her voice, and services before as well as services afterwards. Because after denouncing someone, the child and the family need support to help rebuild the child's confidence, to help the child. So these are some tools that could warrant the title of making our streets and communities safer. And there again, this report doesn't talk about mandatory minimum sentences. Now, there are a host of examples that I could use to emphasize the importance of prevention and assistance for children, measures that would be much more effective than mandatory minimum sentences. I'd also like to quote a strategy in an article from the Canadian Council for Social Development, which talks about preventing crime through social development. Now, what's that all about, Mr. Speaker? Well, according to the Council, it would be a more effective and less costly way of preventing crime. It would be early intervention in order to prevent crime. Now, there are risk factors. What can encourage someone to become a criminal or a victim? And there again, surprise, no one talks about mandatory minimum sentences. People don't start by thinking, well, will I get X number of years? No. These factors are drug and substance abuse, dropping out of school, mistreatment, low self-esteem. And those are the kinds of problems, among others, that need to be dealt with in order to prevent crime and to make streets and communities safer. Now, if we look at Bill C-10, on the whole, it's an omnibus bill that brings together issues that are very diversified. There is mention of victims of terrorism to take legal action. There are mandatory minimum sentences, electronic monitoring, codification of victims, rehabilitation, and record suspensions as opposed to pardons, criminal justice system for young people, working permits for foreign nationals, etc. So all of these issues are extremely important. They warrant our attention, but they're all lumped together in a single bill, which has to be dealt with all at once. So we don't have an opportunity to debate it at great length. And what about the experts who have been working in these areas, who are experts, but who can't have an opportunity, don't have an opportunity to give their views to the government which will make a decision. And so the government will not have listened to them. Now, going back to experts who appeared before the Justice Committee, I have some examples here of people who appeared on October 18th. Mr. Party, Vice President of the Criminal Law Association at the Canadian Bar Association, who says that with this bill, a flawed approach is being adopted for dealing with offenders under the criminal justice system. Once they are from the arrest right up until their treatment in the correctional services and their reintegration. So another expert, Mr. Jackson, who is a member of the National Section of the Criminal Law Section, again at the Canadian Bar Association, who says that this track record doesn't take into account the 150 years of experience at correctional service. It doesn't pay any attention to recommendations put forth previously or to the Royal Commission. This is a 200-page document, and it doesn't refer to the Charter of Rights and Freedoms, nor does it refer to Supreme Court decisions. It makes no mention of many of these issues, but this is what was used to prepare the amendments that you are dealing with and that you will need to hear witnesses on. So the witnesses who have appeared before the committee were not all in favor of what is contained in this bill. Mr. Tardy said he was very disappointed to only have 5 minutes before the committee. Imagine only 5 minutes to have an opportunity to deal with such an important bill. And Mr. Tardy, I have to unfortunately tell you that 5 minutes or 5 hours doesn't make a difference because the government simply wouldn't have listened in either case.
In fact, today there are 88 amendments, which is a significant number of amendments. What work was done in committee, what real sense of having been listened to is there? I don't know, Mr. Speaker. In conclusion, this government boasts about listening to families, and that's commendable. In fact, listening to Canadians is important, and we must react. Don't understand our justice system. Why don't we better explain it to them? They're frustrated. They're asking for justice because they feel that criminals are not in prison long enough. Is it about vengeance, pain, and suffering of the families? And perhaps we need to help them in a different way than giving them, than telling them they're right and instead imposing mandatory minimum sentences. We can also listen to the experts, Mr. Speaker, who have a lot of things to say about this. For example, Calix, which is known for fighting violence against women and domestic violence, says that they oppose the spirit of the bill because it opens the door to more repression, and repression does not really give the victims real power, Mr. Speaker. So let's listen to the experts, these people on the ground who on a daily basis are dealing with these issues of violence and unsafe streets. Let's really talk about the issues in order to come up with a bill that is more respectful of the real demands of all Canadians. Thank you.
Questions and comments? Questions and commentaires? L'honorable député.
The Honourable Member for Chicoutimi-Le-Fjord. Mr. Speaker, last Sunday, the Canadian press obtained a internal Department of Justice report under access to information. This internal report by the Federal Justice Department raised doubts about the efficiency of the imposition of harsher sentences. To quote the author of the study, Andrei Sorecki, and I quote, "There is no proof to show that the imposition of a longer sentence will impact a repeat offender and prevent them from repeat offending." So the Conservative government is not either reading its own internal reports or it is setting aside all the reports that are in opposition with what it wants to respect its own ideology and is not taking into consideration the opinion of experts which talks about rehabilitation instead of harsher sentences. The member for Pierrefonds-Devers. I want to thank my colleague for Chicoutimi-Le-Fjord for the example that he has brought forward of studies of experts who have instead asked the government to focus on prevention. I have a number of others. I talked about Calix. I talked about other reports. I could talk about studies with regard to meta-analyses which show that incarceration does not reduce the number of repeat offenses committed. I could also talk about, I'm looking for the name, the Institute for the Prevention of Crime at the University of Ottawa, which states that a number of policies and prevention practices have proven effective in fighting against crime and victimization and to improve the well-being of individuals. So we have tons of examples of people who tell us that this bill is not going in the right direction. Questions and comments?
L'honorable député de...
The Honourable Member for Chambly-Bourgeois. Thank you, Mr. Speaker. There is a term that I greatly appreciated in the speech, the commendable speech given by my colleague, and that was the term risk factors. And I think it's something very interesting because the idea here is that we are all for reducing crime, particularly violent crime, as my colleague said so well. At the same time, there are different approaches. Often we hear quoted from the Minister of Justice studies that say that Quebecers are for harsher sentences, but there is a nuance to be made to the extent that this doesn't necessarily mean that we support the approach taken in C10 because there are a number of problems. In fact, I'd like my colleague to comment on the fact that we're talking about risk factors, we're talking about risks to our society, health and education and others. So we're not targeting these areas to reduce crime, but we'll force provinces as well to pay for the costs associated with this approach. I'd like her to talk about this. The Honourable Member for Pierrefonds-Dollard. Thank you. To comment on this, I would like to say that I was a teacher at elementary school, and I want to say that if each time a teacher sees a child do something that they don't like and they make them copy something out or they punish them, perhaps that won't resolve the problem in the long run in the classrooms. Instead, we're talking about teaching young children the social skills they need, the study skills they need, how to express their frustration. And so, yes, repression is not the only means, and above all, it is not the means that has been proven as the most effective to date. So that is the comment that I would offer to my colleague. Thank you.
Resuming debate. Reprise de débat.
Resuming debate.
Well, thank you, Mr. Speaker. And I am pleased to join in today's third reading debate on Bill C-10. As you are aware, this bill has been criticized on a number of grounds. One of the most frequently recurring criticisms aimed at the bill was the fact there were several amendments proposing mandatory minimum penalties, MMPs, for serious drug offenses under the Controlled Drugs and Substances Act. No doubt, in part, as a result of these criticisms, this part of the bill was subjected to the greatest number of motions to amend. As we can see, Mr. Speaker, in the end, this part of the bill was amended only once in committee. Mr. Speaker, as parliamentarians, we have engaged in an impassioned debate on the issue of mandatory minimum penalties. In fact, for many parts of this bill, the Justice Committee has spent 67 days hearing from 363 witnesses over the course of the last 4 years. And that does not include the marathon sessions we spent at clause-by-clause consideration. I believe all members of the committee should be congratulated for their hard work. And Mr. Speaker, they put in a lot of hours and they worked very, very hard on this particular bill. As I have just indicated, the minimum penalties for serious drug offences were often criticized. Some of the criticism appeared in the media, and some were stated by witnesses appearing before the committee. I'd like to take a few moments to deal with some of these criticisms. Now, one of the recurring critiques of the mandatory minimum penalty provisions is that a person in possession of marijuana would receive a minimum penalty. Mr. Speaker, I have to say that I have found this particular criticism the most surprising. This is the fourth time that the Controlled Drug Substance Act related provisions of this bill have been before Parliament. These provisions have been exhaustively examined by the Senate Standing Committee on Legal and Constitutional Affairs and by the House of Commons Standing Committee on Justice and Human Rights, and they are clear. The Minister of Justice has appeared before these committees, and he has repeatedly stated that these proposals do not apply to simple possession. Mr. Speaker, they just do not apply to simple possession. He has frequently stated that proposed mandatory minimum penalties would only apply to the most serious drug offences. Mr. Speaker, it is difficult to make it clear as to which offences do not fall under the ambit of these provisions, and yet this particular criticism continues to reappear. At this point, I am forced to conclude that anyone who makes this criticism is of bad faith and that the criticism is only being made to suit other purposes. Mr. Speaker, another criticism that is directed at the mandatory minimum provisions is the suggestion that someone who simply gives a joint of marijuana to a friend would be at risk of receiving the minimum penalty provided by the new provisions in this bill, because of the definition of traffic in the CDSA includes giving a drug, and that as a result, giving a joint is necessarily caught by these new mandatory minimum provisions. While it is true that giving a drug is included in the definition of trafficking, the provisions of the bill are clear. In order for the mandatory minimum provisions to apply to the offense of trafficking, there must exist one of the aggravating factors listed in the new provision dealing with the trafficking. Here again, the Minister of Justice has been clear. The application of mandatory minimum penalties will occur only if one or more of the listed aggravating factors are present during the commission of the offense. A variation of this criticism has been that if a young adult were to give a marijuana joint to a friend while at school, the person giving the joint will be liable to a minimum penalty of 2 years imprisonment. The argument here is that one of the aggravating factors is present. The trafficking has occurred in a school, and therefore the minimum penalty must apply. Here again, Mr. Speaker, the criticism is misplaced. Clause 39 of the bill, at the very outset, states at paragraph 5, sub 3, sub A, that this paragraph is subject to paragraph A1. Paragraph A1 provides the penalty of anyone trafficking in cannabis in amount that is equal to or less than 3 kilograms. That penalty is a maximum term of imprisonment of up to 5 years imprisonment. The net effect of paragraphs 5(3)(a) and A1 taken together is to remove the offense of trafficking in amounts of 3 kilograms or less from the ambit of the minimum penalties for the offense of trafficking found in paragraph 5(3)(a). Therefore, Mr. Speaker, a young person who gives a joint to a person while at school, were he to be prosecuted, would be liable to the ordinary penalty found in paragraph 5(3)(a)(1 and not the minimum penalty of 2 years. Mr. Speaker, I'd also like to say a few words about one of the motions directed at Clause 43. Now, as you'll recall, Mr. Speaker, that this clause proposes a new subsection 10 sub 4 to the CDSA, which will allow a court to delay the imposition of the sentence so as to enable the offender to participate in a drug treatment program approved by the Attorney General or to attend a treatment program under subsection 722 of the Criminal Code. A significant number of individuals applying for admission into drug treatment courts are individuals who have committed prior serious drug offenses, most notably trafficking and possession for the purpose of trafficking. These offenders would receive minimum penalties if the proposed mandatory minimum penalty regime is implemented. Clause 43 creates an extension or an exemption from the application of mandatory minimum penalties in respect of offenders who participate in treatment programs. These provisions will enable judges to delay the application of the penalty while the offender participates in a treatment program and will allow the judge to impose a penalty other than the minimum penalty if the offender successfully completes the treatment program. The motion that I wish to comment on proposed adding a paragraph to Clause 43. The new paragraph would add that the judge could delay sentencing for the offender convicted of a drug offense so that he could attend and receive treatment for mental health issues or to attend a mental health treatment program approved by the Attorney General. While I believe that this motion was well-intentioned, I would like to point out that the provision being proposed in Clause 43 is not necessarily to the treatment of drug-specific problems at the exclusion of all other problems that a drug offender may have. Indeed, in my view, the reference to a treatment program under subsection 722 would allow a judge to allow the offender to attend any approved treatment program, including a program for mental health issues, provided, of course, there are treatment programs available and approved. Mr. Speaker, our government recognizes that serious drug crimes, including marijuana grow operations and clandestine amphetamine labs continue to pose a threat to the safety of our streets and communities. And Bill C-10 contains significant elements forming part of our strategy to address this problem. This bill proposes amendments to strengthen the Controlled Drugs and Substances Act provisions regarding penalties for serious drug offenses by ensuring these types of offenses are punished by an imposition of mandatory minimum terms of imprisonment. With these amendments, we are demonstrating this government's commitment to improving the safety and security of communities across Canada. Canadians want a justice system that has clear and strong laws that denounce and deter serious crimes, including serious drug crimes. They want laws that impose penalties that adequately reflect the serious nature of these crimes. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Chicoutimi-Le-Fjord.
Mr. Speaker, to my Conservative colleague opposite, he talked about treatment offered to prisoners with regard to addictions. I think this is very good that the government is hoping to include this. However, there is something that concerns me in this regard. Howard Sampers said that only 1 out of 5 offenders had access to programs in prison for anger management or for addictions treatment. So I'd like to ask my Conservative colleague opposite to tell me if the government does intend in the bill on crime to expand coverage for these programs to ensure that more individuals with addictions can have access and therefore streets will be safer.
Mr. Speaker, it's an interesting question, and I would say to my colleague across the floor, in the last session of Parliament, the Public Safety Committee toured the prisons across this country, a number of them, not all of them, but a number of them. And we found that, in fact, there were a whole raft of programs available to people in prison. Now, one of the issues that comes about, and if my colleague had had the opportunity to sit through the committee, he would have heard from other sides, not just Mr. Sapers, who I have a great deal of respect for, but we also heard from people that work inside the prison system that a number of prisoners refuse to take the treatment. So in many cases the treatment is being offered, but it has to be also accepted. It's kind of like that old story, you can lead the horse to water, but you can't make him drink. And in the case of the federal prison system, we have increased mental health treatments in the facilities, and I'm sure there's more to be done, and as we move forward, things will be done.
Questions and comments? The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Thank you very much, Mr. Speaker, and there's a lot that I'd like to say, but I know that the time is always our enemy here, and so you know, we've invested a lot, this government has invested a lot in the Skills Link program to keep youth from crime, to help to also re-educate folks who are dealing with a past conviction. Through the National Crime Prevention Center, we invest a lot. My honourable colleague just mentioned about the significant investment in the institutions themselves in order to give programs to people to help them get back on track and be contributing citizens. So on both ends, in fact, we're investing a lot of money. But the question I had for my honourable colleague who knows this file so well, and I appreciate his great work, is that even where we've clearly underlined that the minimum sentences are for serious drug crime and for serious violent crime and for repeat crime, are these people also not able to apply for parole after 1/3 of that 5-year minimum? And then, of course, they're also subject to release after 2/3 unless the parole board deems that they should not be released. Is that also not the case, Mr. Speaker?
Oxford.
Thank you, Mr. Speaker, and I want to thank my colleague for his questions. You know, in this country we do have parole systems, and we do have systems that work to try and rehabilitate those people who are sent to prison. And that's one of the interesting things. We frequently hear about the difference between what's happening in some jurisdictions outside of our borders where they don't have a parole system. And we do have a parole system that works very well. Now, in some cases, we appreciate that we do need to make some changes with respect to the parole system, perhaps to tighten it up, make the rules a little bit different, a little tighter. But people have to understand that when you're sentenced to a prison term, that there is a certain prison term there, and it's not eliminated because of extremely early parole. So although we have a parole system and it works very well, there are jurisdictions that we're frequently related to that do not have a parole system, and I think we should be proud of ours. It's to work to rehabilitate individuals who are sent to prison for serious crimes.
Resuming debate, reprise de débat. The honourable member for Nanaimo Cowichan.
Thank you, Mr. Speaker, and of course I'm rising to speak to Bill C-10, called the Safe Streets and Communities Act. And New Democrats, of course, put safety of our communities as a top priority. But I feel what gets lost in much of this discussion is there are many roots to the safety in our communities. And although this particular bill has bundled together a number of previous pieces of legislation that were before the House, and much has been made about the fact that they were before the House, but I think it's important to remind members that roughly one-third of the members currently sitting in this House today did not have an opportunity to engage in debate and discussion when those bills were previously introduced. And part of our role as parliamentarians, of course, is to practice due diligence. And part of that role is to scrutinize legislation very thoroughly that comes before us and to ensure that Canadian interests are being broadly served. I want to touch for a moment on the whole issue about safe streets and communities, and I want to refer to an article from November 14th in the Toronto Star, and this was written by the Canadian Bar Association, and they entitle it 10 Reasons to Oppose Bill C-10, and I'm not going to go over all of those reasons because I think a number of members have ably outlined them, but I want to touch on a couple of points. First of all, they start off by saying that the title of this bill is an ironic name, considering that Canada already has some of the safest streets and communities in the world and a declining crime rate. This bill will do nothing to improve that state of affairs, but through its overreach and overreaction to imaginary problems, Bill C-10 could easily make it worse. It could eventually create the very problems it is supposed to solve. Bill C-10 will require new prisons, mandate incarceration for minor, non-violent offences, justify poor treatment of inmates, and make their reintegration into society more difficult. Texas and California, among other jurisdictions, have already started down this road before changing course, realizing it cost too much and made their justice system even worse. Canada is poised to repeat their mistake. And earlier today, Mr. Speaker, I heard one of the members opposite in response to a question I had raised to say, why would we look south? We have our own justice system here and so on. And of course, he's absolutely correct. We have our own justice system here. But I would argue that actually we should look to other countries who have tried similar strategies to see what those outcomes were. And if the outcomes didn't work in other countries, I can't imagine why we would think that they would work here. The Bar Association goes on to outline their 10 reasons, and I just want to touch on a couple. It says, number one, ignoring reality. Decades of research and experience have shown that what actually reduces crime is A, addressing child poverty, B, providing services for the mentally ill and those afflicted with fetal alcohol spectrum disorder, C, diverting young offenders from the adult justice system, and D, rehabilitating prisoners and helping them to reintegrate into society. Bill C-10 ignores these proven facts. Number 4 in their list of 10 is no proper inspection. Contrary to government claims, some parts of Bill C-10 have received no previous study by parliamentary committee. Other sections have been studied before and were changed, but in Bill C-10, they're back in the original form. On number 9 in their list is victimizing the most vulnerable. With mandatory minimums replacing conditional sentences, people in remote, rural, and northern communities will be shipped far from their families to serve time. Canada's Aboriginal people already represent up to 80% of inmates in institutions in the prairies, and a national embarrassment that C-10 will make worse. Number 10, how much money? With no reliable price tag for its recommendations, there is no way to responsibly decide the bill's financial implications. What will Canadians sacrifice to pay for these initiatives, and will they be worth the cost? In their conclusion, they say that Canadians deserve accurate information about Bill C-10, its costs, and its effects. This bill will change our country's entire approach to crime at every stage of the justice system. It represents a huge step backwards rather than prioritizing public safety. It emphasizes retribution above all else. It's an approach that will make us less safe, less secure, and ultimately less Canadian. And I think the Bar Association very ably outlines the concerns of certainly many in the opposition and many people across this country. There was a rally held outside of my constituency office in Nanaimo last Thursday, and I was here in the House, so wasn't able to speak to the people who were meeting. But contrary to what the Conservatives say, there are many Canadians who are absolutely concerned about the repercussions of this bill. And this rally was about supporting people who are actually speaking up in opposition to Bill C-10. And I would suspect I've had hundreds and hundreds of emails as well, because I know in some of the side conversation that goes on to this House, I heard Conservative members say they've had virtually no opposition to this bill. Yet I can tell people that I have received hundreds of emails in opposition to this bill. I want to touch for a moment on crime prevention, Mr. Speaker, because that is also one element that is lacking in this bill, not only the crime prevention, but the funds for crime prevention. And I heard a previous member rhyme off a number of programs, but the reality of it is that although not everybody who's poor, that there is a link between poverty and crime, not to say, but I don't want to underestimate the fact that there are many people who are not poor who commit crimes. I think we've got some fairly high-profile Canadians, one in particular who's been doing time in a U.S. jail for white-collar crime. And I just want to point out that poverty doesn't necessarily mean that you're going to end up committing a crime. However, under the there is an article that was put together about child and youth crime prevention through social development. And what this paper does is urge very strongly for the Government of Canada, for this Parliament, to invest in children and youth as a crime prevention strategy. And this paper was developed through the CCSD, the Canada Council on Social Development. And what they say is crime prevention reduces the risk for future crime and victimization. But many of the assumptions we make about what works to prevent crime are ill-founded. A landmark report prepared for the U.S. Congress concluded that some of the most common efforts to stop crime, such as boot camps, police neighborhood watch programs, drug education classes for children, don't even come close to reaching their objectives. However, interventions focusing on changing the underlying social conditions of children and youth, such as nurse visits to at-risk families with parents, with infants, parenting classes, availability of recreational programs, and a focus on social competency skills in school, to name just a few, were found to decrease crime. This kind of approach is called crime prevention through social development. It's a very lengthy report, Mr. Speaker, so I don't have time to read all of it into the record, but I just wanted to read some excerpts from it. And they've got another section titled, When Kids Flourish, Crime Doesn't. Social conditions such as housing, family income, and education leave their deepest marks on children and youth. Improvements in these social conditions have been shown to open up new vistas for young people who might otherwise end up behind bars. Evaluations done in Canada, the U.S., Europe, and other countries demonstrate that certain social interventions work. They are cost-effective and they provide social benefits. Researchers now conclude that social intervention can yield positive results measurable to benefits within 3 years, with reductions in crime of 25 to 50% within 10 years. I'm going to say those numbers again, Mr. Speaker, because I think that's important. An investment in children and youth can result in crime reduction rates of 25 to 50% within 10 years. And surely, Mr. Speaker, rather than subjecting people to crime, victims of crime, and families to all of that chaos that results when a family member commits a crime, surely that investment will be worth it for the health and safety and overall well-being of our communities and our country. One study found that it costs taxpayers 7 times more to achieve a 10% reduction in crime through incarceration rather than through a social development approach. And, again, they go on to list the fact that if we invest in housing, education, clean drinking water, all of those things that people, I think every member of this House would acknowledge, that if people have safe, clean, affordable housing, if they have good employment, if they have access to education, if they have all of that kind of social capital that we talk about, that their chances of getting into trouble are greatly reduced. I just, in my closing minute, I just want to touch on the fact that one of the other places where we need to invest is early childhood education. And the University of British Columbia has a study that says for every $1 we invest in early childhood learning and care, we save $7 in the long run. And that $7 is saved in the criminal justice system, in education, in income assistance, and health. So, Mr. Speaker, it's unfortunate that what we're doing is we're having a conversation in this House about a tough-on-crime bill that purportedly is going to make our community safer when all of the evidence flies in the face of that. And I would urge this House to reconsider this action, that we talk about these investments in our communities instead, so that we can actually prevent crime from happening, and that our communities do become safer, healthier, happier places to live. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Saanich Gulf Islands.
Speaker, and I thank my honourable friend from Nanaimo Cowichan for her thoughtful comments on Bill C-10. In particular, I'm wanting to expand how this bill protects children or fails to protect them. I note that some of the strong critics of the bill with concerns have included the Canadian Pediatric Society, the Canadian Council of Child and Youth Advocates, particularly looking at the changes that are within the Youth Criminal Justice Act. How do we ensure that we protect our young people? Because everyone here wants to. We don't want children at risk from sexual predators. We don't want children at risk from exploitative child pornography. But neither do we want to have a bill passed that the experts in child welfare find so badly wanting.
Nanaimo Cowichan.
I want to thank the member from Saanich Gulf Islands for that question. And, of course, I just want to quote again from this report about early childhood and education. It says that studies have repeatedly shown that high-quality ECE, that's early childhood education, reduces the delinquency rate amongst disadvantaged children and increases their success rate in completing high school and obtaining employment. In fact, quality ECE benefits all children, regardless of social class and parental employment. One reason for this is that ECE provides the opportunity for early identification and intervention in cases of children with special needs. So, Mr. Speaker, again, what we need to be talking about is the root causes of crime, which doesn't seem to be on the government's agenda. We need to talk about that early intervention. We need to talk about providing those supports to children, special needs children, children who perhaps have learning disabilities, children perhaps who haven't had all the supports that they need at home. We need that early intervention to actually help these children stay out of the criminal justice system. And again, as this article points out, this is for children from all social classes. This isn't just poor children. Thank you, Mr. Speaker.
Questions and comments? L'honourable député.
The honourable member for Laurentides-Labelle. Thank you, Mr. Speaker. There are aspects of this bill that don't seem to have been really thought through. I would like my colleague to give me her opinion on this. For example, the provinces who are going to find themselves with overcrowded prisons and justice systems that no longer work because of the thousands of people who will be caught up, unfortunately, and will find themselves becoming career criminals. The local municipalities and provinces are looking for techniques to get control of this situation, and the Crown attorneys are going to be tempted to drop certain charges that are quite serious. We're going to see charges laid that are perhaps lesser charges than might have been laid in order to avoid these people finding themselves facing charges that are overly severe. So perhaps the system itself will try to reduce the impact, as I said, by looking to lay charges that won't involve too serious or overly long sentences. So I don't know how we're going to come out of this.
Thank you, Mr. Speaker. That's a very complex question, and I sadly probably only have about a minute to respond. So I'm actually going to focus on, well, even less than a minute, focus on just one brief aspect of it. The Parliamentary Budget Officer has estimated that cost for prison construction and cost for actual cost per cell is going to rise substantially over the coming years. And with this legislation, of course, it's anybody's guess about how much it's actually going to cost. What I've heard members opposite say is, well, we already provide money to the provinces through the Canada the social transfer, And unless there's going to be a significant boost in that social transfer, what provinces are actually going to have to deal with is they're going to have to make decisions about whether they pay for health care, whether they pay for education, whether they pay for some of those other social benefits in their provinces, or whether they build prisons. And that again, in the context of what I talked about prevention, that simply doesn't make any sense. What we need to do is rethink the impacts of this piece of legislation and invest in those kinds of prevention strategies which I mentioned. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Kitchener Centre.
Thank you, Mr. Speaker. I'm honoured to speak today in the debate over Bill C-10, the Safe Streets and Communities Act. I'm going to limit my remarks to the changes this bill makes to the Youth Criminal Justice Act. These changes were previously incorporated in Bill C-4, or what was known as Sebastian's Law. And those proposals are now in Part 4 of Bill C-10, clauses 167 to 204. The former Bill C-4 was first introduced on March 16, 2010, and was being reviewed by the House of Commons Standing Committee on Justice and Human Rights when the opposition caused Parliament to dissolve on March 26, 2011. 16 meetings had been held to study Bill C-4. Over 60 witnesses had already appeared before the committee. The problems with our current youth criminal justice system were recently highlighted by the results of 4 months of observation by the Toronto Star of a typical Canadian youth court. I'm going to briefly quote the conclusions reached. Quotes, changes to our sentencing law in 2003 were supposed to fix an over-reliance on custody. Instead, serious offenders are thumbing their noses at the courts because they know they will be treated lightly. Victims feel their voices are not heard. Kids who violently break the law, many from broken homes, are reoffending. Mr. Speaker, our government invests significantly in crime prevention, in rehabilitative measures, and in restorative justice. But a balanced approach to criminal justice requires that we also pay due regard to protecting the public and victims of crime against violent youth offenders and repeat youth offenders. And this is what Bill C-10 targets. A number of amendments to the youth justice provisions of Bill C-10 were tabled both by NDP and Liberal members of the Standing Committee during clause-by-clause consideration, and I'm going to comment on some of the more significant of those. One proposed amendment relates to protection of the public, specifically calling for the reinsertion of long-term ahead of the phrase protection of the public in the overarching principles of the Youth Criminal Justice Act. Mr. Speaker, in highlighting protection of the public in the Youth Criminal Justice Act, the government has responded directly to Recommendation 20 of the Nunn Commission report. The Nunn Commission was a Nova Scotia public inquiry which examined the circumstances surrounding the tragic death of Teresa McAvoy, who was struck and killed by a youth driving a stolen vehicle. Justice Nunn concluded that highlighting public safety as one of the primary goals of the Act was necessary to deal with the small group of repeated offenders who were spinning out of control. Mr. Speaker, we agree with the conclusion drawn by Justice Nunn that the current provisions of the Youth Criminal Justice Act are not sufficient to deal with this small group of dangerous and repeat offenders. Now, it's simply wrong to suggest that by removing the adjective long-term from ahead of the phrase protection of the public, we're forbidding consideration of long-term factors. No, Mr. Speaker, by removing a restrictive adjective, we're merely restoring the phrase protection of the public to its true meaning. In doing so, we're allowing judges to consider all factors relating to public protection, including short-term and long-term considerations. It's also very important to note that, just as it was before Bill C-10, protection of the public will continue to be simply one principle of the Act, alongside and equal to other principles such as emphasis on rehabilitation in Section 3.1b, fair and proportionate accountability in Section 3.1c, and special consideration for young persons in Section 3.1d of the Youth Criminal Justice Act. Now, another motion to amend called for the removal of specific deterrence and denunciation from the sentencing principles in the Youth Criminal Justice Act, and that's proposed by Clause 172 of Bill C-10. Mr. Speaker, by allowing judges to consider specific deterrence and denunciation in sentencing, and I say only allowing, not requiring, but allowing them, we increase confidence in the youth justice system. We simply give judges the right to choose the tools they feel necessary to deal with the needs of the differing young persons that come before them. In proposing this amendment, the government is not abandoning the current sentencing principles in the legislation. It is instead giving judges an additional tool to help deal with that small group of repeat and violent offenders where it's reasonable to consider specific deterrence or even denunciation for the benefit of the young person and in order to maintain the public's confidence in the administration of justice. Mr. Speaker, even this provision is limited in its effect because the application of these provisions, specific deterrence and denunciation, is subject to the principle that the sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Another of our proposals that was discussed quite extensively at the Justice Committee was the test for publication in Clause 185 of Bill C-10. The opposition proposed to amend this clause to basically make this test optional rather than mandatory. Now, the wider circumstances under which publication bans may be lifted, proposed by Clause 185, fulfills our government's commitment to Canadians to ensure that young offenders will be named when the circumstances of their offence requires it. In our view, it would be inappropriate for this provision to be optional when the very purpose of the amendment is to protect the public, and that is not optional. The government is not calling for unlimited publication, but merely equipping judges with an additional tool for circumstances that require it. In fact, it should be noted that this provision only makes it mandatory for judges to consider, to think about publication. They are not required to order publication in any particular case. The threshold for this is also significant. The judge is required to consider the purpose and principles set out in Section 3 and 38 of the Youth Criminal Justice Act. And the judge must decide that the young person poses a significant risk of committing not just any offense, but a violent offense, and also must decide that the lifting of the ban is necessary to protect the public against that risk. If there is no significant risk of violence, or if any other solution makes publication unnecessary, then publication remains banned. Furthermore, the onus of convincing the court of these matters remains on the prosecutor. Mr. Speaker, our government recognizes the importance of our youth criminal justice system, and as such, we propose changes in Bill C-10 to address the many concerns that Canadians have expressed about the shortcomings of the current system. Our government responded to calls for change from several provinces asking for modifications to the former Bill C-4. Manitoba, Alberta, and Nova Scotia officials appeared before the Commons Committee in June 2010 and subsequently provided suggested amendments in relation to pretrial detention, adult sentencing, and deferred custody and supervision orders. Our government considered these submissions and made changes to the applicable provisions found in clauses 169, 174 sub 2, 183 sub 1 of Bill C-10. These changes, Mr. Speaker, have been well received by the provinces that proposed them and will ultimately strengthen the youth justice system. Le gouvernement a également déplacé à l'étude article.
The government also moved at clause by clause to amend clause 168, replacing the verb encourager with the verb favoriser in the French version of subparagraph 31A(ii) of the Act. This is a change that Minister Fournier of Quebec had requested.
This government is committed to the protection of our communities and to tackling crime committed by young persons. Our view is that this can be achieved without compromising the use of measures outside the judicial process and while still preserving non-custodial sentences for the vast majority of cases where such measures are appropriate. Part 4 of Bill C-10 provides judges and others working in the youth justice system with tools needed to deal appropriately with the differing needs of young people who come before them, including the needs of repeat and violent offenders who have not responded well under the current system. Such changes will restore public confidence to our youth criminal justice system. I invite all the members opposite to join us in these efforts by supporting this bill. Let us join and together take arms against a sea of troubles and by opposing, end them. Thank you very much, Mr. Speaker.
Question and commentaire.
Questions and comments? The Honourable Member for Charlesbourg, Haute-Saint-Charles. I would like to ask a question regarding a press release that was put out earlier stating that several sections of the bill put forth, including mandatory minimum sentences, incarceration, and constraints on judges, are sources of concern. Does the government intend to listen to the Canadian Bar Association, which put forth these comments?
Sure. Mr. Speaker, thank you very much for the question from my colleague across the way. What one would find if one examines this act is that mandatory minimum penalties are required only in cases which are particularly egregious. For example, there will be a mandatory minimum penalty for drug traffickers who engage people under the age of 18 in their business of trafficking drugs. There will be a mandatory minimum penalty for drug producers who set up shop in a residential neighborhood, a grow-op, and thereby cause danger of fire or otherwise to communities. There will be mandatory minimum penalties for drug traffickers who are engaged in organized crime. These are all very specifically targeted. They're offenses where Canadians would want us to impose jail sentences, and the government is going to pursue those remedies.
Questions and comments? The Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. Mr. Speaker, what is very clear is in regards to the government's agenda behind Bill C-10 is to try to give Canadians as a whole that the government is concerned about crime, and they're bringing in this bill, and it's going to put a lot more people in jail, and somehow it's going to have an effect in terms of minimizing the amount of crime on our streets. And I believe that if you check with people, whether they're in Winnipeg North or anywhere in Canada, that the priority should be how do we prevent crimes from taking place in the first place, Mr. Speaker. That should be the government's #1 priority in terms of addressing the crime front. And I ask the member, to what degree does he believe if the government was to invest some of the resources that they're going to be allocating for these super jails modeled after the United States, to take some of those resources and invest them in things such as community policing, after-school hours programming for young individuals? Would he not think that that would have more of an impact in terms of getting young people more involved in more positive things in our communities, thereby reducing the amount of crime at our local streets?
Member for Kitchener Centre.
Well, Mr. Speaker, I should begin by saying that one thing is for sure, and that is the money that we're going to save on the wasteful and ineffective long gun registry that member supports is going to be put into policing and into things which really will make our communities safer. But beyond that, Mr. Speaker, I happen to know from my own riding the amounts of money that our government does continue to devote to rehabilitation and prevention. For example, just to name one or two programs, our government has invested heavily in an anti-gang strategy. My own community received $3.5 million under that. It is in one community after another all across this country with a view to keeping vulnerable young people from being lured into gangs. We also, in my community of Kitchener, developed a program, a curriculum called the High on Life curriculum, which is being used in schools now, at least all across Ontario, if not Canada, to help convince young people that they don't have to do drugs to get high on life. There are other measures that our government has promoted and will continue to promote, but it's simply not enough that we only do that. And in fact, we're the only government that has a balanced approach to crime, balancing prevention, rehabilitation, with also appropriate respect for law and order.
Reprise de débat.
Resuming debate. The Honourable Member for Notre-Dame-de-Grâce-la-Chine. Thank you, Mr. Speaker. I stand here to voice my opposition to the proposed omnibus bill in its current form. Just a few years ago, these same measures were voted down, and in a moment of hubris and zeal, the Conservative government has brought forward and already defeated bills back with this. Now, for weeks now, we've been hearing that everyone agrees with this bill, but I'd like to take a few moments to read some comments that I have received from people of my riding. A few days ago, I received an email which really puzzled me. It says, I'm a former inmate. I'm on the verge of obtaining a pardon. Legislation like this one would reduce my opportunities for getting things back in order. I haven't committed any crimes in over 10 years. Do you think that I should be considered a criminal my entire life? I earn my living and I have a family. My past is behind me. This is a progressive country, and we need to remain that way. And I'd like to thank the members of my people in my riding to send in comments like this, to contact their members of parliament to tell us what they think of legislation. I have another email. I think we need a fact-based approach which has stood the test of time. We need to be committed to preventing crime. We need to support reparative, restorative justice and contribute to the well-being of society. It goes on.
Evidence-based approach to justice. We should be committed to preventing crimes and to restorative justice that meets the victim's needs and help the community to heal. We need to focus on the causes of crime instead of paying endlessly for the consequences. J'ai reçu des centaines.
And I've received hundreds of emails like that, as my colleagues have, which tell us why we should be opposed to this bill in its current form. Neither my party nor myself have anything against punishing wrongdoing. I have great respect for our justice system and the individual judges who do great work every day. I worked in prisons. I taught French and mathematics there, and I firmly believe that our justice system, as it stands, is good. We are elected as members of parliament to make our systems work more effectively, not to destroy an established system that functions. No fair-minded Canadian wants an ideological law that is not supported by the facts. We're not elected to ignore the facts and simply do as we please. It's extremely crucial that this important debate is not carried out behind ideological lines. I'm convinced of that because I want our society to be just, safe, and equal. I also believe that we can make this happen by building our laws of our society on truth and fairness. This omnibus bill is a step backwards for our country, or if you will, a step towards the failed penal system of the United States. It should be noted that our crime rate in the country is at its lowest in 40 years. Doesn't this show that our system is working? Why aren't the programs in place, programs that we should reinforce and strengthen? Mr. Speaker, if our approach is working and the crime is lowest and it's been in 40 years, we should come up with a way of strengthening the system instead of changing everything. It's unacceptable to vote for legislation when they have proven ineffective in fighting crime. In 2006, the Department of Justice prepared reports for the former Minister of Justice on minimum sentences. They indicated that minimum sentences have no deterrent effect nor educational effect, nor were they more effective than less harsh sanctions. The Department of Justice indicated that mandatory minimum sentences have no perceptible advantage in terms of public safety. The former Minister of Justice stated that all proof showed that mandatory minimum sentences were what's best. However, studies conducted for the Department of Justice showed that in Australia, the UK, in the state of Michigan, and South Africa, they've moved away from harsher sentences and mandatory minimum sentences. In Australia, the prison population has gone up 42% since mandatory minimum sentences were put in place, and crime rate didn't go down. There are too many people in prison. We are living in fragile economic times. My friends opposite continue to say that. Canada will be moving into a difficult situation in the months to come, and people are losing jobs. It is unacceptable to simply rest on our laurels and state that we're the best country in the G7. Does it really help people who are unemployed in our country by simply saying that they're better off than in the United States? The Minister of Finance has accused us of wanting to increase taxes to spend extravagantly. What this bill will do is cost taxpayers millions of dollars. Many provinces have also refused to pick up the tab for this bill. We're not paid to simply create diversions and so that we can hide large problems. This omnibus bill will not help, and it's proof. There is no proof that safety will be increased. The government, by repeating history, will not help. The Minister of Justice, in an interview with a journalist, didn't want to disclose the costs associated with adopting this bill. Why isn't he willing to tell people where their their hard-earned tax dollars are going? Senator Boisvenu, a Conservative senator, estimated the cost at $2.7 billion over 5 years. It's a major expenditure that won't create jobs, nor will it stimulate our economy. It will put more people behind bars. I hope sincerely that it's not the government's plan to reducing unemployment in the country. I don't understand why we're moving towards a U.S.-style justice system. Mr. Speaker, why should the United States be a model for crime prevention? The number of people incarcerated in the United States is extremely high compared to Canada. There are 760 people in prison for each 100,000 inhabitants, whereas in Canada, at present, there are only 116 per 100,000 inhabitants. Mr. Speaker, I don't want to see the government wasting massive amounts of money on a system that doesn't bring crime rates down. Do we want to live in a society rather, that is unduly harsh, where we're doing nothing to prevent crime? The reason why we are debating this bill is to keep people safer. Everyone in the House wants greater safety in our society. However, it's not by putting people in prison that we will achieve that. There's nothing in this bill that will prevent crime. It's difficult to find funding for our public broadcaster. However, here they've got billions of dollars for ineffective ideological prison-based programs. I'd like to go back to the mandatory minimum sentences that I talked about earlier. They will reinforce a trend that targets Aboriginals and other minorities, as we've seen in other places like the United States, where minorities represent higher populations in prison. We need to help people overcome poverty. We need to help single-parent families, poor people, minorities, people who are facing mental disease and illness. There's nothing in this bill that will help to prevent crime, nothing that I can see. Allow me to tell you about or list off a few facts to explain why, in fact, I can't support this bill in good faith. A wide-read study prepared by the Canadian Review of Criminology and Criminal Justice states that prisons are schools, where people learn about crime. That's where they learn it, and especially when you put young people in an adult prison. Now, I worked in an institution for some time, and if someone goes into prison for a minor offense, they will be in contact with people who've committed crimes that are much more serious, and that's where they learn. What we need to do is listen to the amendments that have come forth by the other parties in the House so that we can do something to prevent crime, help people who are in need before they're sent to prison. Thank you very much, Mr. Speaker.
Questions and comments.
L'honorable député de Beauharnois.
The honourable member for Beauharnois-Saint-Verny. Thank you, Mr. Speaker. I want to thank our colleague from Notre-Dame-la-Chine, Notre-Dame-de-Grâce-la-Chine. I stand corrected for this speech about prevention. And as a former teacher, I think that we can testify as to the positive support by social workers, community organizations, the CLSC, psychologists, educators, and others who help those with problems. So often these are people who are the most vulnerable, who have problems. They don't know how to channel their energies, and this sometimes results in minor crime, petty crime being committed. I'd like my colleague to explain how these people can help to reduce the number of crimes committed, the number of victims, and the number of people put in prisons. The honourable member for Notre-Dame-de-Grâce-la-Chine. Thank you, Mr. Speaker. I want to thank my colleague for that question. In fact, as a former teacher, I can say that I have seen this. When I read the section on drugs, I'm surprised to see that the government is proposing legislation that will put individuals who abuse drugs, marijuana or others, in prison, when I know that in the classes I taught, there was about 1 out of 5 children who had access to an addiction specialist, a specialist who could say, here is what you should do, here is what you need to do to reduce consumption, here is the assistance you can have access to, here are the specialists you can access. And this is one case, one example, which represents many others, because I think that there are specialists that work in prevention instead of on healing. And I think we absolutely need to put money into prevention to ensure that there are specialists who can help people in need rather than sending those people to prison and sending the taxpayers the bill. Thank you.
Questions and comments? Question or commentaire?
The honourable member for Alfred Pelin. Thank you very much, Mr. Speaker. I would like to thank my colleague for her speech, which is very close to the reality of what is happening in her riding, but also close to what is happening in Quebec. As you know, in Quebec, with regard to the law, we have a different approach. And last week, the Minister of Justice for Quebec came to see the federal justice minister to put forward amendments with regard to C10, and unfortunately, they were not taken into consideration. The issue that I'd like to, or the question rather, that I'd like to ask my colleague is that we see that the Quebec justice system is working well at present, and since the crime rate is dropping, I would like to know what she thinks about the relationship. The Minister Fournier presented evidence to support his opinion. On the other side, they're talking about personal opinion. I'd like to know what she thinks about this way of this approach to C10. The honourable member for Notre-Dame-de-Grâce-la-Chine. Thank you, Mr. Speaker. I want to thank my colleague for that question. In fact, the Minister Fournier last week came to express to us to talk about the amendments Quebec would like to put forward, because Quebec is refusing to pay for this bill. And there are amendments. So there are more than 50 amendments to say that we should really focus on the facts, the evidence. I was not at the Standing Committee on Justice. I did not attend all the meetings. I was at 2 of them. But I know that there have been witnesses who have come to present evidence and who have said, well, increasing mandatory minimums will not prevent crime. It will not make our communities safer. There are many specialists that have come to provide their opinions based on scientific fact, and the government continues to say, based on our experience, we believe that we should do this. So to respond to the question by my colleague, I think that it's high time for the government to base itself on facts and accept the amendments being put forward in this regard.
Resuming debate, reprise le débat, the honourable member for Brampton West.
Thank you very much, Mr. Speaker, and once again I'm pleased to rise in the House today to continue debate on Bill C-10. It was my pleasure to be a member of the Standing Committee on Justice and Human Rights and extensively review this legislation in committee, and I'm pleased that it's now coming back to the House. I do want to point out that while the bill's provisions dealing with amendments to the Controlled Substance Act was only amended once in committee, there were a considerable number of motions by members of the Liberals and the NDP that attempted to weaken sentences that we had targeted at organized crime. I'm pleased to say that members of our caucus in the committee worked very hard, and I have to say that in the waning hours of the committee's discussions, government members treated us to some of the most cogent, informative, and at times passionate debate that has been seen in our committee. And in this regard, I want to congratulate all of my colleagues on the committee for their passionate debate. This bill proposes a number of amendments to strengthen the Controlled Drugs and Substance Act's provisions regarding penalties for serious drug offences by ensuring that these types of offences are punished by an imposition of mandatory minimum terms of imprisonment. With these amendments, Mr. Speaker, we are demonstrating the government's commitment to improving the safety and security of our communities across Canada. During review of the bill, the Standing Committee on Justice and Human Rights heard from the Minister of Justice, the Minister of Public Safety, government officials, and a range of stakeholders, including many representatives of law enforcement who repeated over and over again to the committee how long they have been calling for these types of measures. As I have mentioned before, Mr. Speaker, our government recognizes that not all drug offenders and drug trades pose the same risk and danger of violence. That is why Bill C-10 provides a focused and targeted approach. Accordingly, the new proposed penalties do not apply to possession offences, nor will they apply to offences involving all types of drugs. And that is contrary to what you hear from the members opposite. What this bill does is focus on the most serious serious drug offences involving the most serious drugs. Overall, the proposals represent a tailored approach to the imposition of mandatory minimum penalties for serious drug offences such as trafficking, importation, exportation, and production. It would operate as follows. For Schedule I drugs like heroin, cocaine, or methamphetamine, the bill proposes a 1-year minimum for the offence of trafficking or possession for the purpose of trafficking in the presence of certain aggravating factors. These aggravating factors are the offences committed for the benefit of or at the direction of or in association with organized crime. The offence involved violence or the threat of violence or weapons or the threat of the use of weapons, or the offence is committed by someone who is convicted in the previous 10 years of a designated drug offence. If youth are present, or if the offence occurs in a prison, the minimum sentence is increased to 2 years. In the case of importing, exporting, and possession for the purpose of exporting, the minimum penalty is 1 year if these offences are committed for the purposes of trafficking. Moreover, the penalty will be raised to 2 years if these offences involve more than 1 kilogram of a Schedule I drug. A minimum of 2 years is provided for a production offence involving a Schedule I drug. Again, Mr. Speaker, we are talking about drugs such as heroin, cocaine, and methamphetamine. The minimum sentence for the production of Schedule I drugs increases to 3 years, where aggravating factors relating to health and safety are present. These factors are the person used real property that belonged to a third party to commit the offence, the production constituted a potential security, health, or safety hazard to children, who are in the location where the offence was committed or in the immediate area, the production constituted a potential public safety hazard in a residential area, or the person placed or set a trap. For Schedule II drugs, marijuana, cannabis resin, etc., the proposed mandatory minimum penalty for trafficking and possession for the purpose of trafficking is 1 year if certain aggravating factors such as violence, recidivism, or organized crime are present. If factors such as trafficking to youth are present, the minimum is increased to 2 years. For offences of importing or exporting and possession for the purpose of exporting marijuana, the minimum penalty is 1 year imprisonment if the offence is committed, again, for the purpose of trafficking. For the offence of marijuana production, the bill proposes mandatory penalties based on the number of plants involved. Production of 6 to 200 plants, again, if the plants were cultivated for the purpose of trafficking, 6 months. Production of 201 to 500 plants, 1 year. Production of more than 500 plants, 2 years. And production of cannabis resin for the purpose of trafficking, 1 year. I should mention that the government amended Clause 41, which deals with a 9-month mandatory minimum penalty for the offence of producing 1 to 200 plants inclusively, where the production is for the purpose of trafficking and where there are certain aggravating factors. The adoption of this motion narrowed the offence such that the mandatory minimum penalty would now apply to instances where more than 5 plants but less than 200 plants are produced, where the production is for the purpose of trafficking and where there again are certain aggravating factors. The minimum penalty would no longer apply to the production of 5 plants or less. If there are aggravating factors relating to the health and safety of the production of Schedule II drugs, the mandatory minimum sentences are increased by 50%. Mr. Speaker, the maximum penalty for producing marijuana would be doubled from 7 to 14 years imprisonment. Amphetamines, as well as date-rape drugs, GHB, and Rohypnol would be transferred from Schedule III to Schedule I, thereby allowing the courts to impose higher maximum penalties for offences involving these drugs. Mr. Speaker, I am pleased that Bill C-10 has been thoroughly examined by the Justice and Human Rights Committee and that we are rapidly approaching our goal of seeing this legislation passed into law. Our government's message is clear. Drug lords should pay with jail time. And, Mr. Speaker, Canadians can count on us to continue to stand up for law-abiding citizens. I want to finally add that there are provisions in this legislation for this legislation to be reviewed, and I know the members opposite have been voting against this consistently. I would invite them to reconsider that position based on the fact that there are review provisions in this legislation. Mr. Speaker, I hope we have their support when we vote on this later.
Questions and comments? L'honorable député.
The Honourable Member for Beauharnois-Salaberry. Thank you, Mr. Speaker. I would like to ask the member opposite question as to whether if he would be able to tell us at least 2 expert studies that prove that this bill will clearly decrease the crime rate, which is already at its lowest in 40 years in Canada, more effectively than a prevention program.
Brampton West.
Well, Mr. Speaker, I think the question actually presents the opportunity to explain and contrast clearly the differences between the members opposite and the members on this side of the House. What we heard in committee, and I know, Mr. Speaker, I was there, I sat through every piece of testimony from every witness. The people who are on side and support this bill and say it's necessary are people like chiefs of police, victims organizations, victims themselves. Those are the people that think this legislation is going to make a difference, and those are the people that we're proud to stand with and present this bill.
Questions and comments? Question and commentaire. The Honourable Member for Winnipeg North.
Yes, Mr. Speaker, the member was making reference to minimum times, and it was interesting in reading an article in which it made reference to it, and I'll just quote right from the paper. It says that a pedophile who gets a child to watch pornography with him, or a pervert exposing himself to kids at a playground, would receive a minimum 90-day sentence, which is half the term of a man convicted of growing 6 pots of plants in his own home. Ask him to provide a comment on that particular thing, but also, Mr. Speaker, to acknowledge that many states in the Deep South really felt that the best way at one point was to build more prisons, keep people in jail longer. And now most of the advocates for that system and that style of fighting crime are now on the other side, saying that, look, we made a mistake. And it seems to me that the Conservative government in Canada is the only one in North America that is really putting all of its marbles on in the area of getting tough on crime by putting people and keeping people in jail.
For Brampton West.
Well, Mr. Speaker, I'm pleased to be able to rise to educate my friend on a couple of points that he's raised today. First of all, dealing with mandatory minimum sentences with respect to drug trafficking. And again, my friend doesn't talk about that. The section is trafficking. It's production of marijuana plants for the purpose of trafficking. What I can tell you, Mr. Speaker, is that police chiefs came and spoke at our committee. They were begging us to get this legislation passed because they need to get these people off the street and off the streets longer so they're not poisoning our children with their drugs. The other fallacy that we've heard today is that the U.S. and that we're somehow following the U.S. model. But my friend opposite knows exactly that the incarceration rates, even as they are reducing sentencing in the U.S., is nowhere near what it is in Canada. It's far higher because their sentences are still far longer for every single offence than they are here in Canada. So there's no comparison. And people on that side of the House that to continue to stand up here and say that know that they are not telling the truth, and they should be ashamed.
Questions and comments? L'honorable député.
The honourable member for Charlebourg, Haute-Saint-Charles. Thank you, Mr. Speaker. With regard to this bill and the part on drugs, the member talked a long time about marijuana in particular. He said the drug lords. He talked about the drug lords. There are a lot of drug lords in Canada. We see them on a daily basis, really. And when we think about the drug lords, which normally come from other countries rather than Canada, and this bill contains all kinds of elements because, in fact, it is an omnibus bill that has nothing to do with drugs. But let's come back to the drugs. Marijuana, criminalizing people who use a minimum, who have 6 marijuana plants and reselling it. We're talking about small offenders. We're not talking about drug lords. Drug lords, we're talking about coke. We're talking about much harder drugs than marijuana, Mr. Speaker. We mustn't exaggerate.
For Brampton West.
Mr. Speaker, once again, I'm happy to be able to stand to provide some information for the members opposite that don't seem to have a clear understanding of this legislation. When we are talking about dealing with people who are growing 6 plants, it's for the purpose of trafficking. Somebody is producing 6 marijuana plants in their basement. That will produce hundreds of marijuana joints. This is not some poor individual who is growing plants in their basement for personal use. This legislation is targeted for people who are trafficking in drugs. And I hope with these explanations, the friends on the opposite side of the floor can rise and support this legislation when it comes back to this House.
Resuming debate, the honourable member for Markham Unionville.
Well, thank you, Mr. Speaker, and I'm pleased to add my voice to the rising opposition to this Bill C-10, which perhaps is best characterized as the Conservatives' most recent piece of dumb-on-crime legislation. Mr. Speaker, our understanding of crime and the appropriate way to handle those who transgress the rules of our society has evolved over the past 400 years. We've moved from a time when criminality was commonly associated with witchcraft to a society that far better understands the root causes of crime and better ways to handle criminals. And I am truly dismayed to see our government completely ignore the work being done on these important topics. They seem to be taking us back to the Middle Ages. And, Mr. Speaker, that's not just empty rhetoric. Why do I say they're taking us back to the Middle Ages? Well, first of all, it's obvious that they care not a whit about policies to fight the ultimate cause of crime. Second, they don't care about deterrence. If they did, they would have paid attention to a recent study by their own Department of Justice that was released a week or so ago, which provided evidence that longer sentences are not an effective deterrent to crime. And indeed, the results from that study are consistent with international evidence on the topic. So if they don't care about fighting the ultimate cause of crime, if they don't care about deterrent, what's left? The only thing they care about is the principle of retribution or vengeance. And that is why I make the statement that they are taking us back to the Middle Ages. Ou en français,
or in French, what we can say is that the principle of fighting against the ultimate causes of crime, this is not at all important to the Conservatives, and at the same time, for the reasons that I've just expressed, the principle of deterrence is not important to the Conservatives. All that is important is the principle of vengeance or retribution, and that is in this direction that the bill is a return to the Middle Ages.
Would deny that protecting the citizens of Canada from harm is the most important objective of government. In fact, the government is granted a monopoly on the use of force for just that purpose. But with that power comes the responsibility to act in an appropriate manner that benefits society. Our country was founded on the principles of peace, order, and good government. And, Mr. Speaker, good government means examining all the facts, all the opinions. It means talking to experts and making public policy decisions that are based on evidence, not knee-jerk ideological desires. Good government also means respecting Parliament's role in public policy debates. My opposition to this bill stems from its ineffective and ideological nature and from this government's inability or unwillingness to work with Parliament on this major issue of public policy. I can already hear that familiar refrain from the other side, soft on crime, soft on victims' rights. Victims' rights and crime are very important, and I find the constant use of victims as a shield for this ideologically driven agenda to be offensive. I believe nobody in this House is opposed to supporting victims of crime. To suggest otherwise is simply insulting to the intelligence of Canadians. And indeed, I might mention the case earlier today, my colleague, the member for Mount Royal, when he has presented amendments that would strengthen the provision in this bill to support victims of terrorism and add to the remedies that they have against those who committed terrorism. It seems the government is not going to accept that amendment, but that's a concrete example of Liberals supporting remedies for those who are victims of crime or victims of terrorism. But I think, what does it mean to support victims of crime? It must certainly mean doing our best to ensure that crime doesn't happen in the first place, or that those who break our laws should be treated in a way that will minimize recidivism. That's how we stand up for victims, by working to ensure that we reduce crime as much as possible, and also through measures such as proposed by my colleague from Mount Royal. I've spoken about the Conservative crime agenda in general, but I also want to spend some time on this bill in particular. My primary concern with this bill, Mr. Speaker, is that it's fundamentally ineffective. According to Statistics Canada, crime is going down, both in volume and severity. This should be trumpeted as a success, Mr. Speaker. Crime is going down. Isn't that our objective? When the government should be standing up and saying, the evidence is saying our policies work. They instead say that they don't believe the statistics. They claim the numbers don't matter. But they do matter, Mr. Speaker. So here, for the benefit of my colleagues on the other side of this place, I will go over a few of the facts that they choose to ignore. As I said before, crime is down. Locking people up for longer doesn't necessarily make them less likely to reoffend. As I said just a few minutes ago, that is confirmed by a very recent study by the Department of Justice that was acquired through access to information. When we are dealing with young offenders, the negative effects of prison are only multiplied. What the government needs to understand is that this is not just liberal nonsense or lefty soft on crime rhetoric. Look at our neighbors to the south. The U.S. incarceration rate is 700% higher than ours. 700%, Mr. Speaker. They very nearly reached a point where fully 1% of the U.S. population was in prison. And what did that mean for the U.S.? They continue to have higher crime rates than we do. They continue to spend billions more on prisons than we do. Some states, such as California, actually spend more on prisons than they spend on schools. Prisons are not the perfect solution to crime, Mr. Speaker. That is simply outdated 18th century thought and nothing more. For many criminals, prisons have not proven the palaces of reform that the Conservatives promise they will be. For many, it is simply a school for crime. Our prison system is already at its limit. This plan to dump thousands of new offenders into the system will simply break it. Low-level offenders will enter the system after convictions for petty crimes, and they will leave having made new criminal connections and having learned the skills of the trade. That should never be the outcome of our justice system. And despite all of this tough talk, one of the things you won't hear the Conservatives talking about during this debate is the mental health of our prisoners. It's widely understood by those who study crime that mental health issues are one of the biggest driving factors of criminal behavior. Taking care of the mentally ill among us has been a failure of all levels of government for decades now. As of 2007, 12% of the federal male prison population had a diagnosed mental illness. That's a 71% increase over 1997. And those figures are even worse for female inmates. Our prisons are not supposed to be substitute mental hospitals, Mr. Speaker. In fact, I struggle to find a worse place for a mentally ill person. Currently, Aboriginals are incarcerated at a rate 9 times that of non-Aboriginal people, and that, I believe, is simply unacceptable. Like most prisoners, they are in prison for nonviolent property or drug offenses. Time and time again, we've seen that the solution to this vicious cycle is not more prisons. Mr. Speaker, I've covered some of the negative social costs of this dumb on crime agenda, but it's also important to talk about the fiscal costs. As you know, the opposition has been asking the government for detailed cost estimates for their crime agenda. We've received nothing from the government except empty rhetoric. This is unacceptable, Mr. Speaker. Parliamentarians are both policymakers and the ultimate keepers of the public purse. We have a right to know the costs of the legislation that we are asked to support. And there's another consideration, and I will borrow a term from American politics, unfunded mandate. Yes, there will be significant federal costs, but we can't ignore the impact these changes will have on provincial governments. These legislative changes, taken in concert with previous changes, will lead to many new provincial inmates, a cost borne solely by the provinces. So this government has shown little respect for Parliament and its role, and it is also showing very little respect for provincial governments and their budgets. Thank you very much, Mr. Speaker.
Questions and comments? Questions et commentaires?
The Honourable Member for Alfred Perrin. Thank you very much, Mr. Speaker. I thank my colleague for having shared his thoughts with us on the Conservative government's bill that they are presenting to amend the criminal code. I'd like to add my colleague, because we heard a bit earlier, according to my colleague across the way, on legislation and the marijuana plants. It was said that 6 plants could be the equivalent of hundreds of joints, and therefore that could be major smuggling. And so when people have when they sell to others, usually it's in bulk. So, I mean, I'd like to know what he thinks about that part of the legislation. In his opinion, is it logical to consider that 6 plants would be the equivalent of that kind of an offense?
Merci, Mag.
I thank my colleague for her question. And I'd make 2 points. First of all, in theory, there's the principle, rather, of mandatory minimums, and it's scattered throughout this bill because people think that some people think, like as I do, that the judge should have the discretion. But this mandatory minimum really can have, indeed, the opposite effect as that intended. So we oppose that principle in the case that she mentions, but also in general. In my opinion, 6 marijuana plants is not a huge amount. But in more general terms, as I said, we oppose mandatory minimums in general. Thank you.
My comment there. The honourable member for Fort McMurray, Athabasca.
Thank you, Mr. Chair. And I listened to my friend across the way intently. I am a part of the Justice Committee, and I want him to know that I am interested in what he has to say. But for the most part, he's talking about costs to implement the bill. And I'm wondering if he has had the opportunity to speak to victims and to ascertain the costs if this bill is not imposed, if we continue to have the high amounts of violent crimes in this country, if we continue to have loss of property through damage committed by youth, if we continue to have psychological damage to individuals for treatment. And Mr. Speaker, the cost to society as a whole when some crime gets out of control, has he looked at those costs, the real costs that victims are concerned with? They're not concerned with the cost of implementing this bill. The only time they're concerned with that cost, Mr. Speaker, is when they aren't actually affected by any crime. And, Mr. Speaker, we've heard from Canadians. They're impacted by crime, they want it to stop, and they want this bill and these laws to go forward.
Member for Markham Unionville.
Mr. Speaker, I don't accept this principle that the Conservatives have a monopoly about caring about victims. Our view is that this bill will create more victims, because when you send young people into jail, they learn to become criminals. They go out, they're more likely to reoffend. The Department of Justice has itself said that longer sentences don't deter crime. So the best way to help victims is to reduce crime. And the central point of my remarks is that this law will not reduce crime. It is more likely to increase crime, and that cannot be good for victims. And finally, my colleague from Mount Royal has proposed amendments to this legislation which would strengthen the provisions that would help victims from terrorism. So if the government cares about victims, I hope they will accept the amendments proposed by the member from Mount Royal.
Hear, hear. We have time for one short question. L'honorable député.
The honourable member for La Salle-et-Mar. Thank you, Mr. Speaker. I would like to ask my colleague from Markham Unionville to talk to us a little bit about the situation in the province of Ontario in terms of crime, because we have heard from government members about what's happened in their ridings. They testified as to what they heard from various Canadians. But I'd like to hear what he's heard in Markham Unionville and also from Ontarians in general.
Merci,
I thank my colleague for that excellent question. I'm very lucky in the sense that Markham is a part of the region of York in Ontario, and we have a crime rate that is one of the lowest in all of Canada. The police are very effective, and this is a very multicultural community that I have in my riding. The chief of police has many connections with the various cultural communities, and therefore I believe that it's a system that works very well now. Certainly in my riding, we don't need this bill.
Before we resume debate, I'll need to tell the honourable member for Fort McMurray, Athabasca, that I'll need to interrupt him in about 7 minutes into his speech, This is for, of course, statements by members. The honourable member for Fort McMurray, Athabasca.
Thank you, Mr. Speaker, and thank you for the advance warning of my cutoff. I will tell you before I start, Mr. Speaker, that I have had an opportunity to practice for some period of time in criminal law in Canada under the Criminal Code. In fact, over 10 years in Northern Alberta, a very busy criminal practice indeed. So I speak from this matter firsthand, and I want to let the previous member know that I saw these individuals going through, and I saw the rotating door of the criminal justice system in Canada, especially in relation to youth offences. And I take exception to his statements relating to more crime, and quite frankly, Mr. Speaker, we heard some witnesses give testimony to say that, and I think it's utterly ridiculous that if we send people to jail for more time, that there's going to be more crime. It's just absolutely ridiculous, and I don't think any normal Canadian would accept the premise of that member's comments in that. But, Mr. Speaker, I will say that I'm very pleased today to talk about the important changes to the Youth Criminal Justice Act that are included in the Safe Streets and Communities Act. And I would like to say, Mr. Speaker, that I think the name itself, the title of this particular bill, the Safe Streets and Communities Act, is exactly the purpose of this bill and exactly what this bill will accomplish once it becomes law, and I'm very proud to be part of that. The proposed amendments to the Youth Criminal Justice Act are found in Part 4 of Bill C-10, with a few exceptions. The proposals that are in this bill very much mirror the changes that were proposed in the former Bill C-4, Mr. Speaker. And of course, you're familiar with that. That was known as Sebastian's Law, and this was introduced in the House of Commons on March 16, 2010. It was before the Standing Committee on Justice and Human Rights when the Parliament was dissolved just prior to the May 2011 election. And, Mr. Speaker, the proposed changes with the Youth Criminal Justice Act reflects the concerns that I hear clearly in committee, and I've heard for years from Canadians that have expressed concern about violent young offenders. And that's right, Mr. Speaker, violent young offenders. And when we think of our youth, we don't usually think of violence, but there are a certain minority of the population under the age of 18, Mr. Speaker, youth, as our court sees them, that do have no concern for society as a whole and do commit very violent offences without thinking about the ramifications of them. It also deals, Mr. Speaker, with youth who may be committing non-violent offences, but frankly are spiraling out of control. And I saw this time and time again. When you see a docket in Fort McMurray on a Wednesday, you would see the same names, not just 1 week or 2 weeks, but it would be a constant situation, Mr. Speaker, of young adults or young people that would be before the court on a continuous basis over the same issues. And I don't think that's acceptable. And I think, Mr. Speaker, clearly Canadians don't find that acceptable because we continue to hear from that. The package of Youth Criminal Justice Act amendments also responds to some other issues, Mr. Speaker, particularly those issues that other Canadians and provincial attorney generals raised with the Minister of Justice on his cross-country consultations. And I want to take a moment to compliment the Minister for that, Mr. Speaker, to go door to door throughout the country, city to city, and talk to Canadians firsthand to find out exactly what they're interested in so that we as a government, Mr. Speaker, can do exactly what we're supposed to do, and that's to reflect the priorities of Canadians, and this bill does exactly that. Now, these amendments, Mr. Speaker, also take into account that and are responsive to key decisions of the courts, and these are courts right across Canada, provincial courts, territorial courts, and of course superior courts, depending on the provinces, and the Supreme Court of Canada. Because, of course, the courts are to reflect that too, Mr. Speaker, but it's ultimately our job as legislators to do that. These positions also reflect what witnesses told us, Mr. Speaker, and victims groups came forward and victims came forward and applauded this government on this bill and specific things that we are bringing about in this bill. Now, I will say, Mr. Speaker, that the reforms reflect the widely held view that while the Youth Criminal Justice Act is working well in dealing with the majority of youth who commit crimes, there are concerns about the small number of youth, and it is a small number, Mr. Speaker, but it doesn't mean it's any less serious. In fact, even more serious, because if we have an opportunity to deter these people early on in life, then they can go back to society as a whole and become good citizens and contribute to society. But these are people who, as I mentioned before, repeat offenders and commit serious violent offences. The proposed changes to the Youth Criminal Justice Act, Mr. Speaker, will do several things. Firstly, it will amend the Act's general principles to highlight protection of the public. And that's very, very important, Mr. Speaker, so that judges, when they look at the Act themselves, they can see that one of the primary concerns, which would seem fairly trite, but would be to protect the public. The second is to clarify and simplify the provisions relating to pre-trial detention, which of course is very, very important as well, Mr. Speaker, but has become quite cumbersome and complicated in the past. years. The third is to revise the sentencing provisions to include specific denunciation and deterrence factors as sentencing principles. And that means sentencing principles, Mr. Speaker, that the judge takes into consideration in the totality of the evidence put before him or her. And this will actually broaden the range of cases for which custody will be available as well, Mr. Speaker. And again, we heard clearly from Canadians that that's what they want. Fourthly, Mr. Speaker, it will require judges to consider allowing publication. That's right, Mr. Speaker, publication in appropriate cases where young persons are found guilty of violent offences. And, Mr. Speaker, if you read the specific statute regarding this, you will see it's very difficult indeed for a judge to make that decision, but it is available to him if he feels it's in the public policy to do so with some other criteria set out in the Act itself. Fifthly, Mr. Speaker, to require police to keep records of any extrajudicial measures they use in response to alleged offences by young persons. Sixthly, to define violent offence as an offence in the commission of which a young person causes, attempts to cause, or threatens to cause bodily harm and includes conduct that endangers life or safety. And, Mr. Speaker, it's hard to believe that it wasn't there before, these particular factors as set out in the Criminal Code. But indeed, Mr. Speaker, that this adds that criteria to the sentencing provisions of the judge and the considerations for him. And sixthly, Mr. Speaker, and only one left after that, respond to the Supreme Court of Canada's 2008 decision in R and DB by removing the presumptive offence and other inoperative provisions from the Youth Criminal Justice Act, and by clarifying the test and the onus requirements related to adult sentences. And finally, Mr. Speaker, seventh, require that no youth under 18 sentenced to custody will serve their sentence in adult prison or penitentiary. Very important, Mr. Speaker, and I see my time's up, and I'll see you after question period.
The honourable member for Fort McMurray Athabasca will have 3 minutes remaining for his speech and 5 minutes for questions and comments when the House resumes debate on the motion. Statements by members. Déclaration des députés. L'honorable député.
The honourable member for HoC. Mr. Speaker, Amnesty International reports that there's an assimilation policy in the Xinjiang of northwestern China. All attempts of the Uyghur to assert their rights have been violently repressed. The Uyghur community in Quebec and Canada have informed me that the Chinese government banned their language, and a Canadian citizen of Uyghur origin is apparently detained currently in China. He has no access to his family, to a lawyer, or consular assistance. The World Congress of the Uyghur would like to meet the Prime Minister to inform him about the conditions of his community, but nothing seems to be happening. I would invite all members to support this people and raise awareness about this unacceptable situation. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. A number of constituents from Souris Moose Mountain visited Parliament Hill yesterday to witness the historic vote ending the Canadian wheat board monopoly and allowing freedom to Western Canadian grain farmers. Dale Monell, who farms thousands of acres of land near Weyburn, Saskatchewan, was delighted with the outcome. He, along with his wife Dina and family, carry on the tradition of hard work and enterprise of their parents Jerry and Orlando Monell. With him was Herb Axton of Minton, Blair Stewart from Fillmore, and Ellen Johnson from Wellowan. They all see the great potential and opportunity that was released by freeing up farmers from being compelled to sell to the Canadian Wheat Board. Blair Stewart, with experience as a processor of specialty crops, and Alan Johnson, a grain and specialty crop broker, see great potential for increased returns and value-added opportunities. To them and the many others that supported the cause, I hope and trust that the next generation of young farmers will be able to reap the benefits of your action and unwavering determination. Thank you, Mr. Speaker.
Honourable member for Nanaimo Cowichan.
Mr. Speaker, 22 years ago this month, Mr. Ed Broadbent introduced a landmark motion to end child poverty by the year 2000. His motion received unanimous support in this House, but over 2 decades later, the number of children living in poverty today is at almost the same level as it was in 1989. In fact, out of the 24 richest nations in the world, Canada ranks 17th in caring for its children in poverty, and 38% of food bank users are children. There are more food banks in Canada today than there are McDonald's. 1 in 9 Canadian children live in poverty. My own province of British Columbia just took the dubious honour of having the highest rate of child poverty in Canada for the 8th year in a row. Research by the Canadian Centre for Policy Alternatives in BC shows the cost of poverty is between $8.1 and $9.2 billion every year. Investing in poverty reduction plan would cost only half of that. This holiday season, I urge all members to support organizations of their choice, such as local food banks or the United Way. But if we want to give true meaning to the spirit of Christmas, then we need to act here in Parliament right now to end poverty.
The honourable member for London West.
Mr. Speaker, Canada's 10th largest city is home to the London Knights hockey team and their legendary coach Dale Hunter. The London Knights have long been a cornerstone of both the London community and southwestern Ontario. Head coach Dale Hunter is a name synonymous with the triumphs of the Knights. Today rated the #1 hockey team in the Ontario Hockey League. He led the team to their 2005 Memorial Cup win, 4 straight season titles, and has the distinction in his era of coaching more players who have gone to the NHL than any other junior coach. They've included Corey Perry, John Tavares, Rick Nash, Pat Kane, and Nazem Kadri, to name but a few. Dale himself is a former NHL superstar who, as team captain, brought the Washington Capitals to the Stanley Cup Finals. And now, after 11 years with the London Knights, Dale returns to the Capitals as head coach. We will miss Dale behind the Knights bench, and Londoners wish him every success. It's just one more example of a great Canadian export to help the United States. On behalf of all Londoners, thank you, Dale Hunter. It's been a great ride.
Honourable member for Scarborough-Guildwood.
Mr. Speaker, I rise today to place in our national record my commendation of a very extraordinary Canadian, a man who not only is a champion of justice and a voice for the voiceless, and a man of deep and compelling faith, but a mentor and cherished friend. His name is Jerry Van de Zanny. Sadly, Jerry passed away on July 16th. The catalogue of his achievements and contributions to his community and his country is far too long to list in a short time. He was called Canada's unassuming prophet. He was a founder of a faith-based organization known as Citizens for Public Justice, a group which advocates for those in our society who are easily forgotten, children, the poor, and on many other issues of social justice to which our faith in God and faith in the dignity of humankind calls us to act. In his book, Justice, Not Just Us, Jerry explains on the intersection of faith and politics. For his work, Jerry received the Order of Canada and the love and incredible respect of his friends and colleagues. Jerry loved the prophet Micah. Seek justice, be merciful, and walk humbly with your God. On behalf of all parliamentarians, I offer my love and condolences to Jerry's wife and his family. Thank you, Mr. Speaker.
Honourable member for Nipissing-Temiskaming.
Mr. Speaker, Lieutenant General Charles Bouchard, commander of the NATO military mission in Libya, is living proof that we have some of the best military personnel in the world.
Real hero.
Besides their military responsibilities, our people in uniform contribute so much to their communities across this great nation. Such is the case with Warrant Officer Dale Keane from my riding of Nipissing-Temiskaming. 20 years ago, he established the 22-wing CFB North Bay Music Band, a group of 65 military personnel and auxiliary volunteer musicians. This talented group has performed in over 1,000 military ceremonies and events across Canada. He and the 22 Wing do this for the love of music, the love of our people, the love of our community, and their love of Canada. Warrant Officer Keane is a shining example of the community spirit in our Canadian military. On behalf of the people of Nipissing, I salute him and his band for the wonderful work they do. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. Today I'd like to point out that it's Canadian HIV/AIDS Awareness Week from November 24th to December 1st, which is World AIDS Day. This is an opportunity to recognize the indispensable work of organizations like COCQ Quebec and the Canadian AIDS Society in raising awareness among Canadians of the dangers of this devastating illness and in preventing its spread. Despite that, there are still 3,000 new cases a year in Canada. We must accordingly build on the tremendous contribution of community organizations in supporting positive people, their families, and loved ones. It saddens me to learn that on account of this government's inaction, the funding for these organizations is in jeopardy. Many won't be able to continue their work or pay staff after March 31st. We have to keep up the search for a cure and support people working around prevention and awareness raising. HIV is avoidable. I hope the government will step up to the plate.
Calgary West. Mr. Speaker, I may not agree with what you say, but I will defend to the death your right to say it. These were the words of Voltaire, and it is in this spirit that I would like to voice my support for Private Member's Bill C-304, titled An Act to Amend the Canadian Human Rights Act, put forward by the member for Westlock St. Paul. Similar private members' bills have been introduced in the past. Keith Martin and the Member of Parliament for St. Catharines deserve note. Freedom of speech is a fundamental right that all Canadians should be able to exercise without a government watchdog. Many Canadians in the past have fought and died for our free speech. Many have already criticized Section 13 of the Canadian Human Rights Act for its subjective and ambiguous nature. Therefore, I encourage all parliamentarians in the House of Commons to support Bill C-304 and allow for true freedom of speech.
Member for Calgary Centre North.
Mr. Speaker, as the Durban Climate Change Conference begins, let's review the NDP and Liberals' record on climate change policy. Under the Liberals, Canada's GHG emissions increased by 27%. Canada's carbon dioxide emissions rose between 1997 and 2005. And they proposed a carbon tax on everything, which was rejected by Canadian voters. The NDP support a tax scheme which would hike gas prices by 10 cents per litre, and they voted against investing hundreds of millions of dollars to support tangible action to address climate change. In stark contrast, our government is balancing the need for a cleaner environment with protecting jobs and economic growth. We are taking action to reduce Canada's GHG emissions by 17% below 2005 levels by 2020. And, Mr. Speaker, we're making good progress.
The honourable member for Halifax.
Mr. Speaker, I'm so proud to represent the wonderful riding of Halifax, a hub of creativity and innovation. Investing in cities like Halifax makes good economic sense, and it's an essential part of our long-term plan for community development. Beyond wanting to ensure that our cities are vibrant, green, and healthy places to live for future generations, infrastructure investments in our cities create jobs and increase our quality of life through increased public transport, better housing, and the green projects needed to transition Canada to the economy of the future. And the numbers prove it. While corporate tax cuts result in only a 30-cent reduction, or 30-cent return on the dollar, infrastructure investments contribute more than $1.50 in additional GDP for every dollar invested. Public consultation is an indispensable part of determining what investments should be made, and I'm proud to point to the consultations carried out in the design of Halifax's new public library that have resulted in a multi-purpose, forward-thinking, community-designed hub that meets our community's needs. Mr. Speaker, it's time to invest in Halifax, and it's time to invest in our cities.
The honourable member for Brampton West.
Mr. Speaker, Canada and the world are marking 16 days of activism against gender violence. Gender-based violence has many faces. Anyone can be a victim regardless of their age or income level or where they live. It can be verbal, physical, emotional, psychological, sexual, or financial. Physically, it can be a threat or a slap, being choked or beaten. The effects can be bruises, broken bones, or worse, even death. Other injuries, while hidden from view, are no less devastating. Our government is taking concrete steps to help improve the safety of women. This includes actions against human trafficking, providing support to its victims, the majority of whom are women and girls. Stopping violence against women and girls is up to all Canadians. By working together, we can all be part of the solution.
The honourable member for Rivière. The honourable member for Rivière du Nord. The Laurentian Sexual Assault Centre in my riding, Mr. Speaker, is celebrating its 25th anniversary. I'd like to declare my support for staff at the centre and their efforts to combat sexual assault and its impact. When these highly skilled responders express their indignation to me about the scrapping and trashing of the firearms registry, I listen to them. and so should the government. This government is not listening and is completely deaf. Congratulations to the Centre for its essential work.
Mr. Speaker, the NDP again voted against marketing freedom for Western Canadian farmers. Shame. This comes on the heels of the NDP voting against helping the manufacturing sector, against small businesses hiring more people, against new tax credits for families like the Family Caregiver Tax Credit and the Children's Arts Tax Credit, and against the Volunteer Firefighters Tax Credit. The NDP is opposed to mining, sealing, forestry, auto manufacturing, and trucking. The NDP also even go abroad to attack hundreds of thousands of Canadian jobs in the energy sector. The NDP oppose creating jobs and then drive the point home to go abroad and attack Canada. The NDP chooses to side with a small group of radical activists protesting against our energy resources. Mr. Speaker, the NDP also want to hit families and job creators with the job-killing tax hike that will kill jobs, hurt our economy, and set families back.
Whose side are they on? Etobicoke North.
Mr. Speaker, almost 3 years ago, the Toronto Foundation for Student Success asked staff and principals of schools in an at-risk community what help they want to deal with issues that were the result of poverty and gun violence. The Foundation expected requests for after-school activities and security supports, but the unanimous request was food for kids. Really, it was simple. Hungry children cannot learn. Hungry children have concentration issues. Children with concentration issues have behavioral issues, and hungry children have a myriad of health issues. Right across the country in provinces and territories, communities are asking for federal leadership to develop a comprehensive pan-Canadian child and youth nutrition strategy and to fully fund on-reserve Aboriginal student meals. This makes good economic sense from the perspective of reduced health costs, lowered crime rates, and increased revenue for Canadian farmers. Let's stand together and take care of Canadian children.
Honourable member for Leeds Grenville.
One of Canada's female political pioneers, Order of Canada recipient Jean Castleman-Watts of Prescott in my riding of Leeds Grenville, passed away November 25th. Mrs. Castleman-Watts became an MP in a by-election following the death of her husband, A.C. Castleman, who was MP from 1921 to 1958. She and her father, the Honourable Earl Rowe, remain the only father and daughter ever to sit as MPs in the same session. Castleman-Watts became the first woman in Canada to be a parliamentary secretary. She was the first woman appointed by the Canadian government as a delegate to the United Nations, and in 1979 was the first woman appointed Canadian High Commissioner to Great Britain. Prime Minister Trudeau credited Castleman-Watts as one of 3 key women responsible for the repatriation of the Canadian Constitution, along with Queen Elizabeth and British Prime Minister Margaret Thatcher. Mr. Speaker, she was always kind to me, and I offer my condolences to the family of Jean Castleman-Watts, her daughter Nancy, and son Claire, and the community that she served so well for so long.
The Honourable Member for Manicouagan. Mr. Speaker, today we're witnessing the danger of an out-of-touch Prime Minister who feels that his government is not responsible for helping Canadians get out of poverty. A month ago, the community of Attawapiskat asked for emergency help to house families with winter approaching. The situation is terrible. Families are living in tents, some in shelters without insulation or running water, or in trailers without washrooms. And what is this out-of-touch government doing? Blaming the community. If the Prime Minister is wondering what to do, he should follow the example of our leader, the member for Hull-Aylmer. She's currently in Attawapiskat with the member for Timmins James Bay. She's meeting members of the community, she's listening, and she's looking for solutions. She's showing them that there are some people in Canada who are standing with them in a crisis like this. And this is what the Prime Minister should be doing, but he refuses to. Why, Mr. Speaker? Because that's true Canadian leadership.
The Honourable Member for St. Boniface.
Thank you, Mr. Speaker. The interim Liberal leader has called for an end to tax credits for children, transit users, and workers. The Liberals also continue to call for higher taxes on job creators, despite the current global economic uncertainty. The member for Vancouver Quadra is calling for Canada to impose European-style carbon taxes, and the member for Saint-Laurent-Cartierville wants a global carbon tax. If the Liberals had their way, Mr. Speaker, Canadians would be paying substantially more for gas for their cars, electricity for their homes, and everything else that they have to pay for. Le Plan Libéral.
The Liberals' scheme of a job-killing carbon tax on everything will hurt Canadian families and job creators. It's clear that the Liberal Party still has no new ideas other than higher taxes for Canadian families. Mr. Speaker.
Oral questions, questions orales. The honourable member for Burnaby, New Westminster.
The OECD warns that troubled global financial markets and family debt levels of Canadians are bad news for our economy. They say the outlook for the Canadian economy has worsened significantly. OECD predicts growth for next year almost 1 full percentage point below budget projections and below the minister's recent revision. Canada lost 72,000 full-time jobs last month. Canadians have plummeting wages. How much more evidence does it take for this government to act? How much more evidence does it take to make the next budget an investment budget for Canadians?
The Right Honourable Prime Minister.
Well, first of all, Mr. Speaker, the OECD's projections are actually very close to the government's in the economic and fiscal update. Following the policies that we followed have created nearly 600,000 jobs in Canada. It's one of the best records in the world, and that includes some significant investments that the NDP voted against. Let me be very clear, Mr. Speaker. The things the NDP advocates for the Canadian economy, raising taxes, shutting down industries, blocking trade, they will never be the policies of this government.
The honourable member for Burnaby, New Westminster.
Bogus figures don't help, Mr. Speaker, and slumping growth isn't the only wake-up call today. Canada has a whopping record deficit in its balance of payment, among the worst of all industrialized countries. This is evidence of a failed export strategy. Canadians have already borrowed more than $39 billion from offshore this year to finance that deficit, and this government does little to boost our value-added exports to create good jobs right here in Canada. No wonder we're in trouble, and Canadians work longer for less under this government. So where's the plan to turn things around? When are they going to learn from their mistakes instead of covering them up? Where's the jobs plan? Where's the value-added?
The Right Honourable Prime Minister. Oh, sorry. The Honourable Minister of State.
Well, thank you, Mr. Speaker. In fact, there actually was a plan. I would remind that honourable member that he voted against that. In fact, every time we bring a plan forward to help create jobs, to help reduce taxes for businesses that actually do create jobs in this country, Mr. Speaker, the NDP stand up and vote against it. Then they stand up and ask us to extend the programs that they voted against, Mr. Speaker. I'm a little unsure of what they're going to ask next.
Well, we certainly voted against the failures of this government, Mr. Speaker, and there are a great many of them. Under the Conservatives, the trade deficit of Canada went from $16 billion to $81 billion. That's a failure. Household debt has attained new records. Failure. 62,000 new jobs lost last month. Failure. 2 million unemployed Canadians. Failure. Lowering salaries. Failure. Will the Prime Minister hear the alarm? Will he stand up and look after Canadian families? And will he table a plan for jobs and make it a success instead of all this government's failures? The Honourable Minister of State for Finance.
The alarm that Canadians are hearing is when the opposition vote against things like they voted against 2 Mondays ago. They voted against job creation tax credits for small businesses, Mr. Speaker. That's a failure. They voted against the family caregiver tax credit, another failure of the NDP. They voted against the children's arts tax credit, Mr. Speaker. I could go on and on and on of all the things that the NDP has voted against, Mr. Speaker. There's almost 600,000 more Canadians working than there were at the end of the recession, Mr. Speaker. That's success for those people.
The honourable member for Windsor-Tecumseh.
Thank you, Mr. Speaker. It's taken a month-long state of emergency for the government to finally wake up to the crisis in Attawapiskat. Children and entire families are living in tents and dilapidated sheds with no heat, now exposed to dropping temperatures. Mr. Speaker, Attawapiskat families have lived like this for years. They need more than Band-Aid solutions. Why won't the government work with the community on a long-term infrastructure solution before winter sets in, right now? Why is it letting the Red Cross do the job?
The Honourable Minister of Indian Affairs.
Mr. Speaker, reasonable Canadians agree that the people of Attawapiskat deserve warm, dry and safe shelter. Since coming to office, our government has invested over $92 million in Attawapiskat. That's $52,000 for every man, woman and child. And we are not getting the results that we thought we should get. I have officials in the community, and they are making progress to ensure people are appropriately housed. Thank you, Mr. Speaker.
Well, last week, that minister was blaming the Attawapiskat community for the problems. Monsieur le Président, la crise...
Mr. Speaker, the crisis in Attawapiskat is simply one example of what happens when the government turns its back on First Nations. 2 million people live on reserves, and many of them don't have running water or heating. The AFN says that $160 million are needed per year. Why this deficit? Where is the plan to help the community of Attawapiskat and all other First Nations?
The Honourable Minister of Aboriginal Affairs.
Mr. Speaker, we have invested in water infrastructure across the country in an unprecedented fashion. We've spent $2.5 billion since we formed government on water and wastewater systems. We are going to be tabling legislation in this House to make sure we have enforceable standards and regulations for water and wastewater. And, Mr. Speaker, we are developing a plan that will take care of people in Attawapiskat in the short term, and that's what's needed.
Member for Toronto Centre.
Mr. Speaker, when we find that there are 19 families that are living in tents and sheds with no running water, 122 families are living in condemned housing, 96 people are living in a large trailer, the Red Cross has now been up there and is due to arrive in the community, is going to be providing generators, heaters, winter clothing and insulated sleeping equipment. The Government of Ontario has sent teams from its emergency management scheme in the province. I'd like to ask the Prime Minister, how does he feel about this complete failure of federal responsibility with respect to the people who are living in Attawapiskat? Mr. President.
Right Honourable Prime Minister.
Mr. Speaker, as the Minister already pointed out, this government has spent some $90 million since coming to office just on Attawapiskat. That's over $50,000 for every man, woman and child in the community. Obviously, we're not very happy that the results do not seem to have been achieved for that. We're concerned about that. We have officials looking into it and taking action.
The fact that the number the Prime Minister is describing also includes the cost of all education in Attawapiskat. And it would seem that the implication of what the Prime Minister is saying is that it's the people of Attawapiskat who are responsible for the problems that they're facing. That response is a disgraceful response from the Government of Canada. When is the government going to start taking responsibility for this deplorable situation, which is an embarrassment to the reputation of the entire country?
The Right Honourable Prime Minister.
What I'm saying, Mr. Speaker, is the Liberal Party's suggestion of simply throwing money is not the solution. That's clearly the government. This government has made significant investments, has taken its responsibility seriously. This government will continue to. We will make sure we get the results we need.
The Honourable Member for Toronto Centre. Mr. Speaker, a government that wastes money, like the Conservative government, wasting money for... It's regrettable that you can talk about that, and whereas there are people who have no housing, no heat, no work, and they don't even have the basic conditions they need to live in. So when will the government take responsibility under the Constitution and its moral responsibility for the conditions existing in this country? The Right Honourable Prime Minister. Mr. Speaker, when this government spends $50,000 per person in Attawapiskat and over $90 million in total, that is not waste, Mr. Speaker. We expect results. and we are going to work with the communities to ensure true results.
Order. The honourable member for Halifax.
Mr. Speaker, yesterday the South African High Commissioner spoke about the reports that Canada may be withdrawing from Kyoto, and she called the move disturbing and disappointing and said it will undermine the negotiating process at Durban because Canada has not only planned a withdrawal, but they've actively lobbied other countries to do the same. The minister has admitted he has no intention to negotiate a new climate deal, and he has not denied his intention to withdraw from Kyoto, and at the same time the minister said that his intentions in Durban aren't to derail the negotiations on climate. So will the minister tell us what his intentions really are?
The Honourable Parliamentary Secretary.
Instead of talking about intentions, let's talk about real action with regard to climate change. $252 million to support regulatory activities to address climate change. $86 million to support clean energy regulatory reforms. They voted against it.
Wow. The honourable member for Halifax.
So why don't I take a crack at deciphering what the intentions are? Because, Mr. Speaker, we know that the Conservatives are waiting until the 23rd of December to announce their withdrawal from Kyoto. If a country withdraws from the agreement, it doesn't take effect for 1 year, so that means that Canada can try and sabotage the negotiations this year in Durban, and next year in Qatar. So, Mr. Speaker, it's this kind of behaviour that denigrates and undermines Canada's reputation internationally. So will the minister admit that this is his plan?
The Parliamentary Secretary to the Minister of the Environment.
Mr. Speaker, agreements that do not include major emitters like Canada or like China and the United States, therefore will not work. That's why we remain committed to reducing Canada's greenhouse gas emissions by 17% below 2005 levels by 2020, and we're making good progress through tangible action that we've created here at home. We're proud of this record.
The Honourable Member for la Rivière-des-Mille. By neglecting the environment, this government is threatening the health of our families and of the economy. The Conservatives are turning their backs on the international community so they don't have to account for their greenhouse gas emissions. Mr. Speaker, reneging on commitments to Canadians and other countries is a strategy that harms everyone. Why is the government refusing to present a credible plan that takes into account both the environment and the economy? The Honourable Parliamentary Secretary.
I'm glad my colleague opposite has acknowledged a fundamental basic point. We need to balance our environment and the economy. This is what we're doing. This is a principle that the opposition would gladly throw to the wind when they denigrate our oil sands sector. Our government's sector-by-sector approach, which is being developed by a robust consultation process, is designed to meet a tangible target of reducing greenhouse gas emissions by 17% below 2005 levels by 2020, while being cognizant of Canada's economic growth. This approach is prudent and action-focused, and we're proud of it.
The Honourable Member for Rivière-des-Mille. Because they've seen the Conservatives dragging their feet for 6 years, major trade partners are closing the door in our faces. They disapprove of the choices of this government in terms of the environment. In addition to isolating us from the rest of the world, the Conservatives' inaction is costing us jobs here in our country. Why does this government refuse to understand that it is possible to create quality jobs while investing in clean energy, just like our partners do? The Honourable Parliamentary Secretary.
$40 million for Sustainable Development Technology Canada was included in this year's budget. Again, when we're talking about clean energy, our government is committed to this, and they keep voting against measures to support it.
The member for Windsor West.
Conservatives are not only dropping the ball internationally, but also here at home. Under the secret deal the government is negotiating, Americans will be able to have new powers to track Canadians. This government is keeping us in the dark about what this means for Canadians' privacy. The Privacy Commissioner is calling for more transparency, saying we should enter into the border deal with, quote, both eyes wide open. But this government is pulling the wool over the eyes of Canadians. When will they tell us what's on the table?
Good question. The Honourable Minister of Foreign Affairs.
Mr. Speaker, work is in progress with the Obama administration to try to establish an agreement where we can help protect and promote jobs in this country, where we can try to see more economic growth, where the border doesn't become a wall, so that we can have more trade and more jobs here in Canada. That is important for every part of this country, but no area of this country is it more important than in Windsor, Ontario, where the auto sector desperately needs to have less congestion at the border. We're committed to continuing to fight for jobs in Canada, and we're committed to work with the Obama administration.
The honourable member for Windsor West.
But we all know when this government negotiates with Americans, there's Canadian families and jobs that were lost. Mr. Speaker, protecting Canadians doesn't mean hiding the truth from them, but that's what this government is doing. Softwood lumber, Buy America, thickening the border, the list goes on and on and on. Now our privacy is at risk. Mr. Speaker, why can't this government come clean with Canadians and show what's being negotiated away in this secret deal?
The Honourable Minister of Foreign Affairs.
I say to my colleague opposite, this is a work in progress. Work continues, and when we have an announcement to make, we'll certainly do that, Mr. Speaker. But let me say this. We believe strongly in the rights of Canadians. We believe strongly in Canadian sovereignty, and we believe in privacy, Mr. Speaker. And these are the type of values we bring to the negotiating table. What is beyond dispute is we have to protect Canadian jobs. We have to promote policies that will help job creation and economic growth. That's why this government is focused, like no other government among the G7, that is getting results for the economy. We're going to continue to work hard to protect Canadian jobs.
The member for St. John's East.
Mr. Speaker, this government's prisons agenda in C10 is being rammed through despite overwhelming opposition from, it turns out, all sides. Police chief say it's unbalanced. The Canadian Bar Association, the Crown Prosecutors say it will overload our justice system. Provinces are unable to pick up the tab. Even the government itself recognised flaws and proposed amendments here today, which were ruled out of order. Why the go-it-alone approach? Why do the Conservatives refuse to work with others on crime prevention and insist on rushing through this flawed bill?
And the Honourable Minister of Justice.
Well, first of all, Mr. Speaker, when we want to talk to police officers, we only have to consult with our own caucus here because of all the police officers who are part of the Conservative caucus. That being said, as long as the honourable member is raising the matter, I see Chief Vernon White from the Ottawa Police Services. We do believe that minimum sentences in relation to the charges or the offences identified in this legislation would assist us. Superintendent Spicer from the Halifax Regional Police, the current sentencing norms simply do not reflect the public's expectations, and the only way for Parliament to achieve that balance is through mandatory minimums. This should have the support of the honourable member and everyone in this House, Mr. Speaker.
Honourable member for St. John's East.
Mr. Speaker, the opposition has put forth practical amendments that will make our communities safer. Why won't the Conservatives vote for these? Why is it barrelling ahead on this unbalanced go-it-alone approach? Where's the commitment to the police chiefs who are calling for balance, to our provincial partners, to families that want to see more frontline police to keep our streets safe? How much are taxpayers going to have to pay for this prisons agenda just because the Conservatives are incapable of working with others?
The Honourable Minister of Justice.
The honourable member never asks what victims will have to pay if we don't change the laws, Mr. Speaker. You know, the NDP has a trouble with going after violent criminals and child pornographers and those who molest children, Mr. Speaker. Why don't they stop attacking farmers who want to sell their wheat or have a long gun? Why don't they start attacking violent criminals just to mix it up for a change?
Why not Deputy Gatineau?
For Gatineau. Well, the government will say absolutely anything. We've already voted in favor of harsher sentences for pedophiles, but by going against the advice of provinces and experts, the Conservatives are about to throw hundreds of millions of dollars out the window and just as many people into prison. By doing so, they are ignoring 40 years of expertise in Quebec in terms of rehabilitation. For a government that claims to be tough on crime, imposing this kind of bill will only worsen the situation and pass the buck to the provinces. When will this government realize that it is not its money, it belongs to families? The Honourable Parliamentary Secretary to the Minister of Justice. Mr. Speaker, we recognize Quebec's ability in terms of rehabilitation. Minister Fournier came, he made 3 recommendations, and we accepted one of them. But what is more interesting, Mr. Speaker, is the fact that Premier Charest sent 2 of his ministers to try to discuss amendments that were necessary. Why didn't he listen to the NDP opposition?
Member for Etobicoke North.
This fall, the minister said inaction on greenhouse gas emissions would lead to a, quote, cataclysmic day. Despite this understanding, all this government has done on climate change is slash programs and take Canada backwards. Now we learn that the government is signaling its withdrawal from its international climate obligations. If the minister accepts climate change is real, as he claims, and the government promises accountability and transparency, why is it planning to withdraw after the Durban conference?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Let's talk about something that's cataclysmic. Signing on to an international accord with no plans to implement it. That's what the Liberal government does figure. And let's talk about their record. Under the Liberal government, Canada's carbon dioxide emissions rose between 1997 and 2005. We have a plan, an action plan, and it's working.
The Honourable Member for Papineau.
Mr. Speaker, to distract us from the lack of confidence of its minister and its pathetic environmental record, this government has announced with great pomp a meager $121 million per year to fight climate change in Canada. However, for the past 3 years, Quebec alone has invested almost the double, that is $200 million per year. Do they really think that such a laughably small sum will make us forget their 6 years of inaction, obstruction, ignorance, and bad faith? The Honourable Parliamentary Secretary.
I'd encourage colleague opposite to actually read the budget before voting against it, because what's included in the budget is $252 million to support regulatory activities to address climate change and air quality. I could go through the list of the hundreds of millions of dollars that we've prudently invested to take care of Canada's environment, a record we're proud of.
The Honourable Member for Malpeque.
Mr. Speaker, disturbing details indeed are emerging about the perimeter security deal that the Prime Minister will sign next week with President Obama. Reports show data on the travel movements of Canadians will be routinely shared with United States authorities. Personal information on Canadians will be in fact given over to a foreign country. Will the Minister confirm that if John Doe from Hunter River PEI travels from Charlottetown to London, England, that this information will indeed be shared with the United States? Will he be honest and confirm that that is in fact true?
The Honourable Minister of Foreign Affairs.
You know, Mr. Speaker, work is still underway with regard to this issue, and there's an announcement to be made on an agreement to protect Canadian jobs, to promote economic growth. We'll certainly make that. As far as Canadians traveling abroad, obviously, whenever we travel to a foreign country, you have to bring your passport. And that is important for international security. And I can assure the member opposite that we'll work to protect Canadian sovereignty, to protect Canadian privacy, and to ensure that we do the best thing for the Canadian economy to help create more jobs, more hope, and more opportunity.
For Vancouver, Kingsway.
Mr. Speaker, the former chair of the Immigration and Refugee Board is pointing to an alarming trend in tribunal decisions. 90% of appointees were made by the Conservatives, and now we have the lowest rate of refugee approvals in Canadian history. Refugee cases should be based on merit and need. But, Mr. Speaker, the former chair is accusing the minister of injecting partisan politics into the judicial process. Why is this government tainting a system that should be independent and fair?
The Honourable Minister of Citizenship and Immigration.
To the contrary, Mr. Speaker, this government put in place the most rigorous pre-selection and screening process for appointees to the IRB by far in the history of our asylum system. In fact, Mr. Speaker, only 10% of the people who apply for membership of the IRB make it through the pre-screening process, which is independent and arm's length. And, Mr. Speaker, I can attest to the quality of those individuals. We've done I have been responsible in recommending over 140 appointments or reappointments. And, Mr. Speaker, all of these individuals have made it through this rigorous, independent pre-screening process.
Bravo. The member for Vancouver Kingsway.
Mr. Speaker, maybe the minister should stop recommending, because more than half of current IRB members have either failed the qualifying exam or been screened out for incompetency. This is a former chair of the IRB who's speaking out, Mr. Speaker. He said the IRB is, quote, not fully independent, and the minister's improper criticism of refugee claimants is, quote, unprecedented. And their rulings are causing division in the federal court. Mr. Speaker, when will the minister start doing his job, put competence ahead of politics, and ensure that we have a fair IRB process?
The Honourable Minister of Citizenship and Immigration.
Well, again, Mr. Speaker, 90% of people who apply for membership in the IRB don't make it through the pre-screening process. Only 10% are recommended. That's 1 out of every 10. And no, Mr. Speaker, they're not. In fact, I'm aware of, I think, 2 out of 140 who have any association with the Conservative Party. Unlike the Liberals, Mr. Speaker, who appointed the spouses of members of Parliament, the spouses of Liberal senators, failed campaign managers. Mr. Speaker, the Liberals used the IRB as a partisan dumping ground. We have respected its role as an independent quasi-judicial organization, Mr. Speaker.
The honourable member for Scarborough, Rouge River.
Thank you, Mr. Speaker. On Friday, we learned that this government plans to slash $31.5 million from immigration settlement services in Ontario. Community organizations are already struggling from similar cuts last year and the year before. Ontario remains the #1 destination for immigration in Canada. Why is the government making it harder for newcomers to access the services that they need?
The Honourable Minister of Citizenship and Immigration.
To the contrary, Mr. Speaker, we are now providing 3 times more in funding for immigrant settlement services in Ontario than was the case when we came to office under the previous Liberal government, Mr. Speaker. We have tripled. Next year, Ontario newcomers will be receiving 3 times more than was the case back in 2005. It is true, however, that the number of immigrants settling in Ontario has declined quite significantly, from 64%, I think, to 52% of newcomers, and they're going to other provinces. And it's only fair, Mr. Speaker, that the settlement dollars follow the newcomers, and that we have fair funding across
British Columbia. The honourable member for Scarborough, Rouge River.
Mr. Speaker, he says that he's doing better than bad. Oh, well, I guess that's their level that they set for themselves. But this shuffling of funds, we're still looking at an overall cut of $6 million and $45 million of cuts from 2 years ago, Mr. Speaker. But the number of newcomers is at an all-time high. Pitting province against province is not going to solve the deficit. This decision to cut services in Ontario was done without planning and with no warning. New Canadians are a huge contributor to prosperity in this country, Mr. Speaker. Will the minister maintain the key supports and services they need to thrive in this country?
The honourable minister.
Again, the premise of the question is completely inaccurate. There's been a great deal of planning by my officials over the course of 2 years to ensure that the adjustment in funding from Ontario to provinces with growing immigration numbers happens in an orderly fashion. And in terms of giving people a notice, Mr. Speaker, we just gave notice this week to organizations, a small number in Ontario that will be affected beginning of the next fiscal year. We're giving them several months' notice. But, Mr. Speaker, the question is, why does she think that newcomers to Ontario should be receiving $4,000 per capita in settlement services, but those in the rest of the country only $3,000? We believe that newcomers all across Canada deserve the same support.
The honourable member for Yorkton Melville.
Thank you, Mr. Speaker. Our government has always believed that Western Canadian grain farmers deserve marketing freedom, and we've always believed in property rights, that farmers deserve to determine how and when they will market their produce. Yesterday was third reading of Bill C-18, the Marketing Freedom for Grain Farmers Act. Mr. Speaker, farmers want freedom. Could the Parliamentary Secretary for the Canadian Wheat Board please inform the House how our government is delivering on its promise to bring marketing freedom to Western Canadian grain farmers?
Honourable Parliamentary Secretary for the Canadian Wheat Board.
Mr. Speaker, I thank my colleague from Yorkton Melville for his great work on this issue. Yesterday, history was made in this House when members of Parliament passed Bill C-18, Historic Marketing Freedom for Grain Farmers Act. Once Bill C-18 receives royal assent, Mr. Speaker, Western Canadian grain farmers will be able to determine where and when and to whom they sell their grain. They will finally have a choice of a voluntary Canadian Wheat Board or the open market. Mr. Speaker, Bill C-18 is now with the Senate. Senators know its swift passage will finally grant Western Canadian grain farmers the free marketing freedom they so richly deserve.
The honourable member for Surrey North.
Mr. Speaker, this government's out-of-touch management has brought the RCMP to a crisis point. Bullying the provinces in contract negotiations, allegations of pervasive sexual harassment, and now questions about whether or not there are enough frontline officers to protect Canadians. The RCMP's annual budget has doubled over the last decade. RCMP headquarters is bursting at the seams. So my question to my colleagues is, why has the growth in the frontline officers not kept pace?
The Honourable Minister of Public Safety.
Well, actually, Mr. Speaker, I might remind the member that it was our government that hired 1,800 new frontline RCMP officers and provided $400 million to provinces to recruit officers. The former Liberal government actually took the irresponsible step of shutting down the RCMP depot in Regina. We are examining all government spending across the board, particularly headquarters staff, to ensure taxpayers get the best value for their dollars, and the RCMP is no different in that respect.
The Honourable Member for Châteauguay-Saint-Constant. The lines prepared for the Minister do not hide the reality. The government's plan calls for cuts to the RCMP. The Auditor General has confirmed that the government's aggressive approach has already forced the RCMP to cut investigations into organized crime, drug traffickers, and white-collar criminals. The government's plan for the RCMP is completely incoherent, does not make any sense. Why sacrifice the quality of service in Canada? Why ask the RCMP to do more with less? The Honourable Minister.
Perhaps I could repeat again, it was our government that in fact hired 1,800 new frontline RCMP officers. We provided $400 million to provinces in terms of their responsibilities to hire and recruit officers. And as I pointed out, it was the former Liberal government that shut down the RCMP training depot. When we came into office, we went from 300 officers a year in terms of training to 1,800 a year. We are committed to frontline policing.
Hamilton Centre.
Mr. Speaker, Conservatives' lack of transparency on spending reached a new low this week. When the media asked how much the Department of National Defence's HQ renovation would cost, the government responded by saying, go file an access to information request. Now we find out that this paranoid government had the number of $623 million all along, but wouldn't release it to the public. So I ask the Minister, what could possibly be the justification for keeping this number secret?
The Honourable Minister of National Defence.
Yes, in fact, Mr. Speaker, the Department of National Defence and Public Works are collaborating to consolidate the workforce of national defence here in the nation's capital. We are moving forward with a plan to have those consolidated workforce go from 48 different buildings to 7 in the national capital. An independent third-party analysis has looked at this plan, has come back with the numbers that will be a cost saving on a long-term ongoing savings estimated at around $30 million a year. This is good news for taxpayers, and I know the member opposite will want to support it.
Mr. Hamilton Centre.
Well, Mr. Speaker, we'll deal with the issue of whether or not we're getting value for dollars afterwards. But right now, I would like an answer to the question of why the government felt it was necessary to keep a number that they already had secret from the media, secret from the public, and secret from this Parliament. What's the justification for the secrecy?
Minister of National Defence.
I thank my friend for his question, albeit in a rant, Mr. Speaker. I'll answer the question again that this is a good move for the Department of National Defence. It will see us consolidate our headquarters at the Nortel campus, which was purchased, I again repeat, to save money, Mr. Speaker. And this was done looking at the spending levels that were reported. And where were they reported, Mr. Speaker? At a Senate hearing some 9 months ago. Where were they reported, Mr. Speaker? I spoke about this in transcript at the Standing Committee on Government Operations and Estimates, of which the member opposite was a member.
Royal. Order. Order. The Honourable Member for Mount Royal.
Mr. Speaker, all available evidence, including the Justice Department's, show that mandatory minimum sentences are excessive, ineffective, disproportionate, costly, and they result in higher incarceration rates. Will the Minister of Justice table in the House the evidence he used to justify mandatory minimum sentences? Thank you, Mr. Speaker. The Honourable Parliamentary Secretary. Mr. Speaker, this question has been broadly debated not only here in the House but also in committee. We have indicated costs. The victims, however, are the ones that have the bulk of the costs, and 80% of the costs are carried by the victims. This is what we are working on. The Honourable Member.
Mr. Speaker, the Justice for Victims of Terrorism Act gives victims of terror a civil remedy against their terrorist perpetrators, but it limits the remedy by immunizing the state perpetrator of terrorism, allowing the remedy to be used only against proxies or agents of the state sponsor. Why is the government denying Canadians an effective remedy against states that support terrorist proxies or commit the terrorist acts themselves? Thank you, Mr. Speaker.
The Honourable Minister of Public Safety.
Thank you, Mr. Speaker, and I want to thank the member for his question. I know he has been working on this file for a long time, and we appreciate the support that he has provided in giving us advice. We have proceeded in the way that we have in the bill because of the advice that we have received from various organizations. We believe that this is the most effective way to ensure that terrorists are held accountable and that victims have a remedy in situations where they would otherwise not have a remedy.
Member for St. John's South, Mount Pearl.
Mr. Speaker, 17 people died on March 12, 2009 when Cougar Flight 491 went down after loss of oil pressure. Less than a year before, the same thing happened to an Australian helicopter, but Transport Canada failed to take action. After the Newfoundland tragedy, the Transportation Safety Board recommended all Cougars must be able to run dry for 30 minutes. But the Sikorsky still fails the test. Mr. Speaker, why are we giving the Cougars a free pass at the risk of the lives of offshore workers?
The Honourable Minister of Transport.
Mr. Speaker, this was a very tragic accident, and my thoughts are with the victims and their families. My department continues to work towards addressing the recommendations of the Transport Safety Board. We will also continue working with our international partners to develop a coordinated approach that helps prevent these accidents from occurring in the future. Thank you.
Families of the victims who died in the Cougar helicopter crash off Newfoundland want to know why the faulty Cougar gearbox was certified. The minister won't answer. The sole survivor of the crash wants to make sure all helicopters in the air now can run dry for 30 minutes. And the Transport Safety Board agrees with that recommendation. So why does the minister continue to allow these faulty, unsafe helicopters in the air? And why is the minister ignoring the safety of Canadians?
The Minister of Transport.
Mr. Speaker, the safety of population is very important for us, and we don't use these events to make politics with. This is a very tragic accident. Our condolence continues to go out to the victims and their families, and I can confirm that Transport Canada has received notification that the litigation against its relating to this accident has been discontinued. Thank you very much, Mr. Speaker.
Member for New Brunswick Southwest.
Excuse me, Mr. Speaker. Canadians gave our government a strong mandate to end the wasteful and ineffective long gun registry once and for all. And that's exactly what we're going to do. Yet today, the members from Western Arctic and Skeena Bulky Valley caved to pressure from their big city elite union bosses and showed up at the Public Safety Committee to attempt to gut our legislation. Could the Minister of Public Safety please comment on the action of these two members of Parliament?
I'm afraid that question has nothing to do with the administration of government. So we'll move on to the Honourable Member for Vancouver Project.
You used to be one of the good guys. Sell out.
Mr. Speaker, the government said it did not order public servants to replace the term Government of Canada with the Prime Minister's own name. But records show that's just not true. As one Industry Canada official noted in an email, he was forced to use the PM's name, quote, as per our directive from PCO. This Soviet-style politicization of Canada's bureaucracy is unethical and it breaks government's own rules. Why force neutral public servants to do the Prime Minister's partisan bidding? Why cover it up?
The Honourable President of the Treasury Board.
Speaker, I've been called a lot of things, but never Soviet style, so this is a first for me. But I want to assure the honourable member that, in fact, there is no need for a directive that she seems to believe in, Mr. Speaker, because this has been long-standing practice across various governments. In fact, when they were in government, Mr. Speaker, they used the terms Chrétien government, Martin government, and similar variations in official government communications. Mr. Speaker, the proof is in the pudding. This terminology is widely used by journalists and by the opposition parties, and Mr. Speaker, if the circumstances permit, that's the circumstances that we would use that term.
The Honourable Member for Hamilton East, Stoney Creek.
Well, Mr. Speaker, the government says it is still committed to improving the Canada Pension Plan, Quebec Pension Plan, because that's the favourite option of Canadians. Unlike the government's pooled pension scheme, the CPP-QPP is inflation-proof, it's a guaranteed defined benefit, and it costs less. Mr. Speaker, Canadians aren't that concerned with voting records. What they want to know is, will the Finance Minister guarantee to this House that the CPP expansion is on the agenda for the upcoming December meeting of the Finance Ministers of the Federal, Provincial and Territorial?
The Honourable Minister of State for Finance.
Well, thank you, Mr. Speaker, and indeed continued talks between our partners on Canada Pension Plan, that would be the provinces. We continue to discuss any enhancements that may be appropriate at this time, but I would remind that honourable member there was consensus, there was unanimous support amongst the federal, provincial, territorial finance ministers to pursue the framework for a pooled registered pension plan. That's why we tabled it in this House. We continue discussions. We continue to develop the regulations around it to make an effective retirement plan for the 60% of Canadians, Mr. Speaker, in the workforce that don't have a pension plan right now.
Member for Niagara West, Glanbrook.
Mr. Speaker, small and medium-sized businesses employ nearly half of all working Canadians. Our Conservative government recognizes that when we create new opportunities abroad, we create jobs and prosperity for Canadian small businesses and their workers and families. That's why our government is moving forward on our job-creating pro-trade plan. Can the Minister of International Trade tell the House about the recent report it received from the Small and Medium-Sized Enterprises Advisory Board?
The Honourable Minister of International Trade.
Well, Mr. Speaker, I'd like to thank the member from Niagara West, Glanbrook, for his hard work on behalf of businesses in his riding. And this morning I met with small and medium-sized business leaders, and they strongly support our pro-trade plan. And here's what Canadian Federation of Independent Business President Catherine Swift had to say, quote, "It is encouraging to see the government taking small business issues into account when negotiating trade agreements. The government's pro-trade plan will benefit not only Canadian SMEs looking to expand into new markets like Europe, but also the Canadian economy as a whole." End quote. Mr. Speaker, this Conservative government is working hard.
Honourable Member for Vaudreuil-Soulanges. The Conservatives are threatening the fragile economic balance in the regions. Job cuts in a number of post offices across Quebec are completely destroying service in rural areas. Postal services are essential to rural communities, and they contribute to their economic development. So, will the government finally take its responsibilities seriously and find ways to develop postal services in rural areas instead of eliminating them?
The Honourable Minister of State for Transport.
Thank you, Mr. Speaker. I'd like to thank the member for his question. In fact, Mr. Speaker, the volume of mail fluctuates from province to province, from year to year. Canada Post makes decisions on the number of hours worked based on those fluctuations. Anyone who has a permanent job with Canada Post will keep their job with Canada Post. There are no job reductions, as the member has stated. We are committed to ensuring that all Canadians get the postal service they deserve.
The Honourable Member for Saanich, Gulf Islands.
I'd like to ask the Honourable Prime Minister if he recalls being present when former Prime Minister Brian Mulroney cited the scientific consensus on climate change that, quote, "humanity is conducting an unintended, uncontrolled, globally pervasive experiment whose ultimate consequences are second only to global nuclear war." The Environment Minister says that Kyoto is in the past. I'd ask this Prime Minister not to leave Canadian leadership in the past and show one fraction of the commitment of former Prime Minister Mulroney to address this crisis.
The Honourable Parliamentary Secretary to the Minister of the Environment.
Well, Mr. Speaker, one thing is for sure. We do need to have leadership in the economy, and that is what this government stands for. We balance the economy with environmental protection. That balance is achievable, and we have a plan to achieve that. That is why Canada has a very strong action plan that is focused on reducing our emissions by 17% by 2005 levels by 2020. That is real leadership.
Absolutely. That concludes question period for the day. On a point of order, the Honourable Member for Toronto Centre on a point of order.
Speaker, yesterday we all participated in a vote in which there was a very substantial demonstration on the side of the government, as well as a very substantial demonstration in the gallery, which was not, and I can see the demonstration hasn't entirely stopped, Mr. Speaker, which was not in, well, that's right. Somebody just said I've got that right. I think I do have it right, and that's why I'm asking the question. I want to ask, Mr. Speaker, if you would take note of the extent of the demonstration. I also think it's fair to say that the member for Churchill was excoriated by the members opposite because of the fact that there was one sole demonstrator on the other side in the other part of the House with which he had nothing to do. But the demonstrators, to my rear...
Order. 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 The Honourable Member for Toronto Centre has the floor. We'll have a little order. The Honourable Member for Toronto Centre.
Thank you, Mr. Speaker. The people who were demonstrating throughout the vote, who are members of Parliament who were demonstrating, were encouraging the others with respect to their own response to the vote that was taking place. Exactly. All we're asking for, Mr. Speaker, is fair with respect to how the conduct of votes takes place, and what demonstrations are permitted by the Speaker and what demonstrations are not permitted by the Speaker. We think it's time, if there's going to be decorum on one side of the House, there has to be decorum on every single side of the House, and that has to be the rule that prevails.
Order. On the same point, the Right Honourable Prime Minister.
Mr. Speaker, I listened to the leader of the Liberal Party. I think we must have been in a different chamber yesterday. I did witness a number of people in the gallery. They were peaceful, law-abiding people, which is all you would expect from people seeking their basic freedom and rights.
The Honourable Member for Acadie Bathurst, and I think we'll move on after that.
Well, I wish that the Prime Minister will respect the rule of the House. And the rule of the House, if we go by the rule of the House, the invited guests that come in the gallery are not supposed to get up and slap in their hand. And he's approving what they have done. And this is the rule of the House. If you want to go with the rule of the House, it's the rule of the House. And then the Prime Minister should respect the rule of the House.
In light of the events over the last few days, the Chair will come back to the House with an analysis of both what happened last week and yesterday. Orders of the day. Order du jour.
Government orders, Ways and Means. Consideration of Ways and Means motion number 6. Motion to introduce an act to amend the Financial Consumer Agency of Canada Act.
Mr. Van Loan, seconded by Mr. O'Connor, moves that a Ways and Means motion to introduce an act to amend the Financial Consumer Agency of Canada Act be concurred in. Plaît-il à la Chambre d'adopter?
Is it the pleasure of the House to adopt the motion?
Agreed? No? On division? On division? I declare the motion carried on division. I am now prepared to rule on the question of privilege raised on November 23, 2011 by the Honourable President of the Treasury Board concerning modifications made to the transcript of the November 2, 2011 meeting of the Standing Committee on Public Accounts and the impacts these changes have had on his ability to perform his duties.
I'd like to thank the Minister for having raised this issue, as well as the Honourable House Leader of the Official Opposition for his intervention. The Minister explained that allegations that he and his staff had caused changes to be made to the published committee evidence of his testimony to the committee were false, as his office had made no such requests for the committee transcript to be altered. He claimed that these allegations were a breach of his privileges and impeded his work as a member and a minister.
So let me begin by making a few comments about the production of the debates and committee evidence. First, it is important to note that debates and committee evidence are not, in fact, verbatim transcriptions of what is said, but rather a report of the proceedings that House of Commons editors have edited for clarity, grammar, and syntax. There is, however, a distinction between the processes followed for the production of the debates as opposed to committee evidence. In the case of the debates, there is a formal process in place for individual members to consider corrections and minor alterations to their interventions as transcribed in the unedited version of the debates, commonly referred to as the blues. There is, however, no exactly comparable process in place for individual members to review the transcripts of committee evidence. This does not mean that members do not have an opportunity to propose changes to the unedited transcript. À la page
House of Commons Procedure and Practice, Second Edition, at page 1219, clearly sets out how corrections and alterations are made to committee transcripts. Quote, unedited transcripts of committee proceedings, known as the blues, are made available to users of Parliament's internal website, usually within 24 hours after a committee meets. Traditionally, minor corrections can be effected by submitting the proposed change to the editors. Corrections of a more significant nature are made by the committee itself as a corrigendum. Should this happen, the electronic version is expeditiously updated, unquote.
When this question of privilege was raised, the Chair asked for a report on the editing process followed on the particular transcript now at issue. I can assure the House categorically that no members or members' staff submitted proposed changes to the transcript. The changes made were the result of normal editing protocols being followed, and I'd like to explain. Due to stringent timelines and voluminous amounts of text, the technical task of editing is frequently parceled out to multiple editors, whose collective work for a given meeting is then reviewed by a senior editor. These senior editors look at the full context of the preliminary verbatim transcript, including the intonation of the person speaking, in order to accurately convey the intended meaning in the final transcript. Thus, they routinely authorize the removal of redundant words, false starts, hesitations, words that might lead to confusion as to the true intent of the statement, and so on. Sometimes entire sentences are restructured for clarity. Even within the testimony of a single witness or member speaking, it is not unusual for words to be removed in one place and retained in another if the editors judge that, in the latter case, the words do not lead to confusion or convey an unintended meaning. Il va sans dire.
Needless to say, the editing of the transcripts of proceedings, whether in the House or in committee, is a difficult and demanding task that our editors and senior editors take very seriously. Ultimately, however, authority for the final version, as I've just indicated, rests with the committee, and it is, of course, free to issue a corrigendum if it so wishes.
The question remains whether the rendering of the transcript in the manner shown has, in and of itself, impeded the President of the Treasury Board in the performance of his duties to the point of warranting a finding of prima facie privilege. The Chair must remind the House that the Speaker generally does not rule on matters relating to proceedings in committee. As this matter deals with the committee evidence of a meeting of the Standing Committee on Public Accounts, and in the absence of a report from the committee on the matter, it would be premature for the Chair to make a determination on the matter at this time. The Chair will leave it to the committee to determine how to address any issues arising out of the manner in which the testimony of the Minister has been transcribed. There can be no doubt that the Minister feels aggrieved by the interpretation being given to these events. However, as presented to the Chair, and again, in the absence of a report from the committee on the matter, I cannot find that this is sufficient grounds to establish that the Minister has been impeded in the performance of his parliamentary duties. Therefore, I cannot find that a prima facie question of privilege exists.
I thank honourable members for their attention.
Orders of the day, order du jour. Sorry, point of order. The Honourable President of the Treasury Board.
Thank you, Mr. Speaker. I want to thank you for your careful review of this matter, and I'm pleased that you have been able to clear up this controversy and for the helpful information that you have provided. I would say, Mr. Speaker, it's very unlikely the NDP did not know that the House of Commons transcription services routinely make inconsequential amendments to the official report. Many of those members have been around for many years.
Does the Honourable President Treasury Board have a point of order to make? Is there a point of order?
Yes, Mr. Speaker, I will make that point of order now. With your ruling today, I would sincerely hope that the member for Timmins, James Bay, will reflect on his actions, and he made these accusations against me both inside and outside this place, and I request that the member for Timmins, James Bay, apologize for his baseless smear of my reputation as soon as possible.
I didn't hear a point of order in that. Orders of the day, order du jour.
Government orders, government bills, Commons, resuming debate at report stage, Bill C-10, Safe Streets and Communities Act. And number one group of amendments.
Athabasca has 3 minutes left to conclude his remarks.
Yes, thank you, Mr. Speaker. I appreciate the opportunity to conclude my remarks because, of course, this is a very important bill for Canadians, and they've expressed their desire to have us pass this into law as soon as possible. I do want to address something that I've heard recently, Mr. Speaker, in particular in relation to complaints from some quarters, in fact the opposition primarily, that there has not been a sufficient time to study Bill C-10 in its entirety. And, Mr. Speaker, if you look at the history and examination of the charges as they relate to the Youth Criminal Justice Act, you will see how very wrong that is. In fact, as I briefly outlined a minute ago, the proposed reforms to the Youth Criminal Justice Act that are contained in Part 4 of Bill C-10 being made after consultations with a broad range of stakeholders and members of the public as well, Mr. Speaker. This is in response to key court decisions, the Nunn Commission of Inquiry, the extensive parliamentary study, and indeed input from provincial and territorial partners. Firstly, most of us will know that the former Bill C-4 was extensively studied by the House of Commons Standing Committee on Justice and Human Rights. Prior to the dissolution of the previous Parliament, the committee actually held 16 meetings, Mr. Speaker, on that bill and heard from over 60 witnesses. So I don't know how anyone in this place or elsewise can say it wasn't properly consulted. Secondly, prior to introducing the former Bill C-4 in March 2010, the Minister of Justice undertook a comprehensive review of the Youth Criminal Justice Act. And in February of 2008, Mr. Speaker, the Minister of Justice launched that review with a meeting he held with provincial and territorial attorney generals, who I would suggest, Mr. Speaker, know much more than the opposition do in relation to Youth Criminal Justice Act. And they discussed the scope of the review to encourage provincial and territorial ministers to identify the issues that they had and that they had heard from their Crown prosecutors and others relating to the youth justice system, and that they considered, Mr. Speaker, the most important. And of course, that is very, very important. And finally, Mr. Speaker, in May 2008, the Minister of Justice, as I said previously, undertook a series of cross-country roundtables, usually co-chaired by provincial and territorial ministers, in order to hear from youth justice professionals, frontline youth justice stakeholders, and others around this country about areas of concern and possible improvements regarding the provisions and principles of the Youth Criminal Justice Act. So to say it wasn't properly consulted and that we didn't spend enough time is simply ludicrous, Mr. Speaker. We have heard from Canadians. They've clearly outlined what they wanted us to do. We have consulted with stakeholders, including the provinces and members of the government and members of the public, and most importantly, Mr. Speaker, victims. We are listening to victims. And, Mr. Speaker, the Nunn Commission itself convened on June 29, 2005 and heard from 47 witnesses with over 31 days of testimony. So, Mr. Speaker, what we are doing here is listening to Canadians, reflecting the society and what they want, and, Mr. Speaker, moving forward to keep all Canadians safe.
And comments, questions et commentaires. Questions et commentaires.
The Honourable Member for Pierrefonds de l'Art. Thank you, Mr. Speaker. My colleague said that victims groups like this bill, C-10, and yet I have a letter here before me from a Sexual Assault Support Center from the West Island, and they say that Quebec sexual assault centers prefer prevention over detention. So can the member say that he hasn't explained? Has he just not heard from enough Canadians? Or does he just not listen to anyone who differs from him?
Tabasco.
Well, I appreciate the member's concern with this, Mr. Speaker, and I agree. Prevention is very, very important. That's why we're going to make sure that people that do crime and serious crime actually do time, and we keep them in jail where they won't be predators of sexual offenses on minors, Mr. Speaker, where they won't be able to do the things that they are doing because the parole system in this country is not working properly, Mr. Speaker. What we're going to do is make sure, Mr. Speaker, that Canadians are listened to, that victims are listened to, and indeed that people that do crimes, especially violent sexual offenses, actually do the time. Stay in jail. We have an opportunity to rehabilitate them, Mr. Speaker, but they don't have a chance to reoffend.
The questions and comments, the Honourable Member for Winnipeg North.
You guys will. Yes, thank you, Mr. Speaker. My question to the member is that will he not recognize and acknowledge that it's only the Conservative government here in Canada that seems to take this approach that the best way to prevent crimes from happening is to build on mega jails? It's something in which, Mr. Speaker, has not worked in the States. In fact, what you see now in the States is that they want to be able to try to get more people back into the communities. And the best way to prevent crimes from happening is to put into place programs, Mr. Speaker, that will ensure that there's alternatives for youth to participate outside of gangs and things of that nature. And I wonder why it is the government hasn't recognized the value of crime prevention, preventing crimes from taking place in the first place. And I would ultimately argue that that is indeed what is the greatest priority that Canadians have, more so than keeping people in jails for extended period of times where it is not justified. We understand and appreciate that at times there is a need to keep people in jails, but more often than one would think, Mr. Speaker, quite often we would be better served by having more programs that will facilitate individuals from being able to be full participants in society in a positive way.
Honourable Member for Fort McMurray, Athabasca.
Well, Mr. Speaker, I know that some people actually have expressed that, that indeed, as the member says, that it's not justified. But, Mr. Speaker, that's a small minority of people. That's criminals and the Liberal Party of Canada. I don't agree with that, Mr. Speaker. I think, frankly, that people that do time that do crimes that are serious should do time that's serious, because they have taken away something from people. They have violated, quite frankly, society as a whole and public policy. Mr. Speaker, there's no question in my mind that criminals in this country, first of all, a small minority of them get caught, but when they are caught, most of the punishments are quite frankly laughable. I've had an opportunity to see it firsthand, and we're not going to take the laughable position of the Liberal Party of Canada or the laughable position of criminals for that matter.
Right on. The Honourable Member for Malpeque.
Fact that the member opposite lumped us in with criminals and not worrying about this subject. I'm a former Solicitor General, and we worried about it. But we look at facts when we're trying to rehabilitate people, and just throwing people in jail doesn't make them better. Just penalizing them doesn't make them better. They need programs to be rehabilitated, and that member should not lump Liberals in with criminals in his statement. It's wrong, and he should apologize.
The Honourable Member for Fort McMurray, Athabasca.
Thank you, Mr. Speaker. And I, too, take offence that this member would take the position of criminals instead of law-abiding citizens and the Conservative Party of Canada, who wants to protect Canadians and society as a whole.
I'll take a look at what was said. I didn't hear exactly what the exact wording was, but there have been rulings before about members implicating other members being supportive of criminals or criminal actions. So I will take a look and come back to the House. There's enough time for a very brief question or comment. The Honourable Member for Sandwich Gulf Islands.
Thank you. My question to the Honourable Member for Fort McMurray, Athabasca. He's made reference, as many Conservative members have, to the report of Justice Merlin Nunn of Nova Scotia. Is he not aware that Merlin Nunn spoke to the press in Nova Scotia and said he is troubled by the fact that this bill moves away from the principle that jail should be a place of last resort for young offenders? He's also troubled by provisions that would allow teenagers as young as 14 being tried as adults.
I'll have to stop the Honourable Member there. The Honourable Member for Fort McMurray has less than 20 seconds left.
I do appreciate my friend's intervention, Mr. Speaker, but I will say that the Nunn Commission actually called on 47 witnesses over 31 days of testimony, Mr. Speaker, and I agree with the member. We do want to prevent crimes, and that's exactly what we're going to do with this legislation. We're going to make sure we send a clear message to people that would commit crimes to let them know if they're going to commit crimes, Mr. Speaker, they're going to do serious time.
Resuming debate, the honourable member for St. John South, Mount Pearl.
Thank you, Mr. Speaker. I stand in the House today in opposition to Bill C-10, the Omnibus Crime Bill. As I stated in a September speech in this House, I do not stand in opposition to every part of the bill. Indeed, some parts of Bill C-10 are worthwhile. As a father, Mr. Speaker, I have no objection with protecting children against pedophiles and sexual predators. Of course not, even though the Conservative government would have you believe otherwise. But then that's the rub with Bill C-10, which throws so many pieces of legislation, 9 bills, aboard the one bus, aboard the one omnibus bill. I may agree with coming down hard on pedophiles, but I don't agree with filling prisons with people who probably shouldn't be there, like the student who gets caught with 6 marijuana plants. What will throwing that student in jail do for him or her, or for society in general, besides costing us a fortune in new human cages? My answer, Mr. Speaker, is nothing. It will do absolutely nothing. Steve Sullivan, an advocate for victims of crime for almost 2 decades, wrote a piece earlier this month for the National Post, and a particular quote stuck with me. Quote, "Few of us lose sleep over child sex offenders spending more time in prison, but some of the reforms will toughen the sentences for low-risk offenders with low risks of reoffending. They won't make children safer, but will cost 5 times more than was being invested in child advocacy centers that support abused children." End of quote. Bill C-10 is also known as the Safe Streets and Communities Act, but mandatory minimum sentences aren't so much tough on crime as tough on Canadians suffering from mental illness, addictions, and poverty. In fact, poverty will be punished even more than it is now. The bill targets youth for harsher punishments and will put more Aboriginal people in prison. One of the pillars of the Omnibus Crime Bill are mandatory minimum sentences. The Conservative Omnibus Bill will dramatically expand mandatory minimum sentences, limiting judicial discretion to levels unseen before. Experts say taking away discretion from judges clogs up the judicial system. That's not all that it will clog up. The provinces are practically rebelling against this new crime bill. They charge it will clog up the prison system. The provinces say it will put increasing pressure on a prison system that is practically busting at the seams. Experts say the Omnibus Crime Bill will increase the country's prison population by untold thousands. As for the cost of housing that many more inmates, estimates range up to $5 billion a year. That's more than double the current expenditures for the corrections system alone. And that's a Conservative estimate, not a Conservative government estimate, mind you. The Conservative government hasn't put a price on the Omnibus Crime Bill, which makes no sense. On Monday, yesterday, I stood in this House and debated the bill to kill the Canadian Wheat Board, which ended up passing even though the Conservative government failed to carry out a cost-benefit analysis. How is that good governance, good fiscal governance in these scary, unpredictable times? I don't get it. Canadians don't get it. Ontario Premier Dalton McGuinty has warned the Conservative government that provinces across the country will not pick up the tab for any new costs associated with the Omnibus Crime Bill. Quebec has essentially said the same thing. In my home province of Newfoundland and Labrador, the main prison is Her Majesty's Penitentiary in my riding of St. John South Mount Pearl. Her Majesty's Pen dates back It dates back to Victorian times. The original stone building first opened in 1859. The pen is an aging fortress that has been called an appalling throwback to 19th century justice, which sounds like Bill C-10. Felix Collins, the Justice Minister for Newfoundland and Labrador, the progressive conservative Justice Minister for Newfoundland and Labrador, I might add, has had this to say about the Omnibus Crime Bill. I'll quote him. Most groups, most experts, and most witnesses who have given presentations on this bill would advocate that the federal government is proceeding in the wrong direction and that this procedure has been tried in other areas and has proven to be a failure. Incarcerating more people is not the answer. End of quote. That quote pretty well sums it up. Let me say it again for effect to hammer home the point. Most groups, most experts, and most witnesses who have given presentations on this bill would advocate that the federal government is proceeding in the wrong direction and that this procedure has been tried in other areas before and has proven to be a failure. Incarcerating more people is not the answer. When Felix Collins, Newfoundland and Labrador's Justice Minister, speaks about the procedure being tried in other jurisdictions and failing in other jurisdictions, he's probably talking about Texas. Conservative Texas has warned us not to follow a failed fill-in-the-prison approach to justice. And the Canadian Bar Association, representing 37,000 Canadian legal professionals, has said that the bill would, quote, move Canada along a road that has failed in other countries at a great expense. The Vancouver Sun ran a story yesterday, headlined, Conservative Crime Bill is a costly mistake for Canada. The story reads, when Canada has some of the safest streets and communities in the world and a declining crime rate, why is the Prime Minister pushing his omnibus crime bill in such a Machiavellian way? Many jurisdictions, including Texas and California, have warned this crime agenda not only doesn't work, but it doesn't make economic sense. Costing roughly $100,000 per year to incarcerate a person, mandatory sentences will raise taxes, increase debt, or force us to cut spending on essential programs like health and education. Bill C-10 arrogantly ignores proven facts from decades of research and experience. End of quote. Again, that about sums it up. Here's a quote from a constituent that I received. Who is helped by having a student, a future doctor or engineer, thrown in jail for a year and a half because they decided to make some hash for their own personal use? In what universe does that make sense? Stop wasting money on cages and start spending it on hospital beds and textbooks. Now that's a line that sticks, Mr. Speaker. Stop wasting money on cages and start spending it on hospital beds and textbooks. If the Omnibus Crime Bill goes through, provinces like Newfoundland and Labrador will have less money to spend on health and education, let alone rehabilitation and preventative programs. Let me quote from an editorial in the St. John's Telegram, the daily newspaper where I come from. Quote, the provinces have been raising two kinds of concerns. One is that tough on crime laws don't actually achieve their stated ends because rehabilitation actually decreases crime rates in the way that longer incarceration does not. The second concern is far more pragmatic. While the federal government is making laws to extend prison terms, it doesn't seem to be in any rush to help with the additional anticipated provincial costs connected to longer sentences and increased court time. Increased court time, listen to this, because it will be less attractive to criminals to plead guilty at the early stage of prosecution. That's from the St. John's Telegram. Who's going to say, yes, I'm guilty, if they know that mandatory minimum means they will definitely be going to prison? Mr. Speaker, I say Bill C-10 will not make Canada a better place to live. It will change Canada. It will change how we see ourselves as Newfoundlanders and Labradorians and Canadians, and how we're seen on the world stage. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Thank you very much, Mr. Speaker. I listened to the other member. I'm not certain whether he's ill-informed or needs some more research, but we heard the member from Oxford earlier who talked about his committee traveling to different institutions across the country and how there's a robust offering of different programs for those convicts, those inmates who are willing to reform and to be contributing citizens. I mentioned here earlier, Mr. Speaker, about a number of programs that are outside of this bill through HRSDC, Skill Links, through the National Crime Prevention Centre, where we have programs for to keep youth from crime, to help them stay away from gangs, etc., for gang prevention. And yet all of this seems to be outside of the purview of the opposition when they address these issues in the bill. But here's the real thing that I want to question the member about, Mr. Speaker. He talks about these minimum sentences. Is he aware that a prisoner only has to serve 1/3 before he's eligible for parole, and in 2/3 it has to be released unless the National Parole Board says that he should stay confined? Is he aware of that, that this 5-year minimum is quite possibly only 20 months when applying for parole?
The honourable member for St. John South Mount Pearl.
Thank you, Mr. Speaker, and I thank the honourable member across the way for the question, but the question was a two-parter. I'm not going to have time to answer both parts. I'll answer the first part. He mentions a committee that travelled to Oxford. My recommendation is that a Conservative committee should travel to Newfoundland and Labrador. I gave a quote from Newfoundland and Labrador Justice Minister, and I read it twice. I'm not sure if the honourable member actually listened. I'll read it a third time. Maybe I'll read it a little slower. From Newfoundland's Justice Minister, most groups, most experts, most witnesses who have given presentations on this bill would advocate that the federal government is proceeding, slower now, in the wrong direction, and that this procedure has been tried in other areas before and has proven, slower again, to be a failure. Incarcerating more people is not the answer. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire.
The honourable member for St. John's East.
Oh, I'm sorry.
Thank you, Mr. Speaker. And I wonder if the member for St. John's Mount Pearl would like to comment on the fact that one of the aspects of this bill is to remove the possibility of a pardon from everybody. And it does that by getting rid of the name pardon, and it calls what used to be a pardon, I think it's called record suspension. And it seems to me that that removes the possibility of redemption or the interest that someone might have in clearing their name with a pardon and taking away from the rehabilitative effects. Does he have any comments on that?
The honourable member for St. John's South Mount Pearl.
I thank the honourable member for the question. The honourable member for St. John's East. A very good question. Of course, I don't agree with that. I think removing pardon is the wrong way to go. I believe in judicial discretion, and I think this omnibus, I know that this omnibus crime bill takes away judicial discretion. That is the wrong way to go. What this omnibus crime bill is missing is common sense. There is no common sense. Thank you, Mr. Speaker.
I'm sorry I didn't recognize the honourable member for Charlottetown earlier. The honourable member for Charlottetown.
Thank you, Mr. Speaker. My question for the member relates to his comments with respect to the impact on provincial treasuries. What will invariably happen is we're going to have more people in provincial institutions. That will result in charter challenges based on the overcrowding of jails or a dramatic strain on provincial budgets. The charter challenge will result in guilty parties going free. So what we're faced with in terms of the downloading is the exact opposite of what the Conservatives intend, or tough choices within provincial governments. I wonder if the member could comment on that, please.
The honourable member for St. John South Mount Pearl.
Thank you, Mr. Speaker, and I thank the honourable member for the question, and it's a very good question as well. Again, my home province, Newfoundland and Labrador, the Justice Minister has come out and said if this omnibus crime bill passes, our prison capability with Her Majesty's Penitentiary in St. John South Mount Pearl, it cannot handle the increase in prisoners. It cannot, the system cannot handle an influx of more prisoners. So on the one hand, we've been after this Conservative government for years for a new prison for Newfoundland and Labrador. The answer has been no. And then on the other hand, they're pushing through this omnibus crime bill that's going to increase the number of prisoners into Newfoundland and Labrador's prison system. That makes no sense. Is my province going to find it hard to pay for this? Of course. My province doesn't know where the money is going to come from. That's the question that the Conservative government has yet to answer. Thank you, Mr. Speaker.
Resuming debate, reprise de débat. The honourable member for Edmonton St. Albert.
Thank you very much, Mr. Speaker. It's indeed an honour for me to rise and speak to Bill C-10 at report stage, a bill that I've become quite familiar with as a member of the Justice Committee, and as the House knows, the Justice Committee vetted this bill for many hours in the last few weeks. I am pleased to speak specifically with respect to the victim of terrorism aspects, supporting victims of terrorism aspects of Bill C-10. However, and before I talk about a couple of amendments at the committee stage, I would like to review the essential thrust of the bill as it relates to victims of terrorism. The focus, reducing domestic crime, is important, Mr. Speaker, and is part of the strong mandate that Canadians gave to our government. However, our desire to keep our streets and communities safe from criminals, we must not overlook the need to protect Canadians from the dangers of terrorism. Those dangers are very real. A few months ago, Canadians observed the 10th anniversary of September 11th, 2001, where 24 Canadians lost their lives on that terrible day that will live on in infamy. Suddenly, terrorism had struck close to home. It was no longer a distant threat that could be ignored. Yet the reality, Mr. Speaker, is that terrorism has never been far away. Let us not forget that the plot that took the lives of 329 passengers on Air India Flight 182 was planned and executed in Canada. So we are not immune from terrorists, nor have we ever been. We must always stay vigilant of the threats that lapping at our shores. That is why our government carefully studied the Commission of Inquiry's final report into the Air India bombing. And in response to that report, the government released the Air India Inquiry Action Plan last December. This plan, Mr. Speaker, will help us address the outstanding security issues highlighted by the Commission. Certainly the Commission of Inquiry illustrated that time does not diminish the demand for justice. The victims of terror and their families need to see that justice is served. They need to know that terrorists cannot pursue their radical goals with impunity. The notion of accountability, Mr. Speaker, lies at the very heart of Bill C-10. To put the proposed amendments in context, let me highlight the provisions that relate specifically to the fight against terrorism. First of all, the proposed legislation would give victims of terror a greater voice. By their very nature, Mr. Speaker, acts of terrorism often have victims feeling powerless. All too often, they are effectively silenced. Our government is determined to give victims back their voice. Bill C-10, Mr. Speaker, would empower victims to take the perpetrators of terrorism and their supporters to court. In practical terms, this means that victims could file a civil suit against those who committed terrorism. This would include individuals, terrorist entities listed under the Criminal Code, or listed states that supported a terrorist act. If the act of terrorism has taken place outside Canada, victims will either need to be a Canadian citizen or a permanent resident, or will need to demonstrate a real and substantial connection between the incident and Canada. In support of this provision, Mr. Speaker, the bill would amend the State Immunity Act to create a list of states that support terrorism. Lifting the immunity of a state is a serious matter, Mr. Speaker. The bill proposes a robust process whereby the Minister of Foreign Affairs and the Public Safety Minister would have to satisfy the Governor and Council that the state should be listed as a supporter of terrorism. Furthermore, the state's alleged support for terrorism must be in relation to a listed entity pursuant to our criminal code. The evidence must be weighed carefully and set against the diplomatic consequences that may come from lifting an immunity. At the same time, the list should always be a work in progress. So every 2 years, the two aforementioned ministers would examine the list to carefully determine if new states ought to be listed. By the same token, if listed states can show that they have ended their support for terrorism, then we should remove them from that list. However, if a state is removed from the list while litigation is ongoing, the state would not benefit from the immunity in such case. Mr. Speaker, it is not enough to give victims their day in court, nor is it enough to enable victims to become successful plaintiffs. If the court's judgment is against a foreign state, then the plaintiffs need additional support to ensure that justice is served. For that reason, Mr. Speaker, Bill C-10 would empower the Minister of Finance and Foreign Affairs to help identify and locate the property of that foreign state. To sum up, then, Bill C-10 would give the victims of terrorists back their voice. It would support legal redress against terrorist entities, and it would offer support to successful plaintiffs. At the same time, it would weigh the consequences of these actions carefully to protect Canada's relations in the global community. Mr. Speaker, I would now like to turn my attention to two amendments at committee, which I referenced at the beginning of my remarks. And I would suggest to the House that the amendments made at committee will make this bill even stronger. Members will know that our government has already passed these amendments related to the Justice for Victims of Terrorism Act. The first amendment our government passed will help to lighten the burden of victims of terrorism. Defendants would be presumed to be liable if they supported a listed entity that caused or contributed to the loss or damage subject to a cause of action. The defendant could always refute the claim. The second amendment passed the committee would make it possible for a court to hear a matter based solely on the plaintiff's Canadian citizenship or permanent residency. This would hold true even in cases where there is not a real and substantial connection between the action and Canada. So it is the government's hope that this bill will be passed at report stage, that the amendments made at committee can be approved by the House, and in so doing, all parts of C-10, including the victims of terrorism, the offences with respect to organized crime, with respect to sexual predators, with respect to drug offences, that all of these matters can be passed because Canadians, my constituents, all Canadians, police officers have asked for this type of legislation as part of the toolbox in their ongoing fight against crime. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. L'honorable député.
The Honourable
Southwestern.
Thank you, Mr. Speaker. The reference the Honourable Speaker made at the beginning of the comment was to such terrorist acts as the Air India disaster, and I'm wondering if this law had been in place then, what would have been different for those victims of the Air India disaster today?
The Honourable Member for Edmonton St. Albert.
Well, the Air India disaster, of course, was a black mark in not only Canadian history but also in global history. And in many ways, as I indicated in my opening comments, the resulting inquiry after the Air India incident formed the impetus for this part of C-10 with respect to victims of terrorism. So as the Honourable Member will know from his review of the legislation, this bill gives victims of terrorism a cause of action against terrorists that they can prove caused the damage, caused the losses to their family. So this type of legislation would have been of great value to victims of terrorism, such as those that suffered severe losses during the Air India incident. Thank you.
Questions and comments? The Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. Mr. Speaker, I'm sure the member would recognize that there is a substantial cost to the implementation if Bill C-10 passes, and it's a very substantial cost. We don't actually know what those costs are going to be. There's been an attempt from the Liberal Party to try to flush out those actual costs from the government, but to begin to believe that they have no idea of the cost. We do know that there are provinces that have great concerns in regards to the implementation costs and the ongoing costs of Bill C-10. I'm wondering if the member can provide any comment in terms of what he feels, no doubt, what he would be suggesting to provinces that are having a difficult time trying to meet and provide program services that are going to prevent crimes from taking place when they're being imposed by Ottawa initiatives that is going to cost them a great deal of money in order to implement their build prisons, large jail plans that they're proposing here in Canada.
Honourable member for Edmonton St. Albert.
Well, thank you, Mr. Speaker, and I thank the member for Winnipeg for his good question. He'll be happy to know that with respect to the provisions of C-10 that deal with amendments to victims of terrorism and state immunity, there are no costs to the government. But with respect to his broader question, what members of the opposition are fond of is talking about the costs of implementation of our Safe Street and Safe Community agenda. But they fail to realize the cost of crime which is borne by victims. And victims bear the majority, I think it's 80% of the estimated $100 billion of cost of crime to Canadians annually. Those costs are costs in terms of increased insurance premiums, in terms of lost wages, in terms of lost property, and of course the immeasurable damages when an individual loses his life. So the costs of crime are much broader than simply the cost of the justice system, and I think that the portions of the cost of crime that are borne by victims is often lost on the opposition, Mr. Speaker.
Questions and comments? We have time for a short question and response. The honourable member for St. John's East.
Thank you. So if my insurance goes up because someone steals your car, that's part of the cost of crime in your calculations. That's interesting. I wonder if the member can the biggest criticism, and he talked about the anti-terrorism legislation, the biggest criticism is the state lists. And we know, for example, that the Americans took Libya off the states list when they were rebuilding their relationship with them. Isn't that a problem with our bill too, that the state list depends on the politics of the government of the day?
The honourable member for Edmonton St. Albert.
Well, as the honourable member knows, and I thank him for the question, and I enjoy working with him on the Justice Committee. As the honourable member knows, the issue of listing the states on the list is complicated in that you have to balance the evidence of terrorism versus what it will do with international relations with respect to those countries. So the remedy, as I indicated, is that the list will be reviewed every 2 years by two ministers, the Minister of Public Safety and the Minister of Foreign Affairs, to make sure that the list is updated periodically every 2 years to make sure that it adequately reflects the risk of certain states and in their promotion of terrorism.
Resuming debate, reprise de débat. The honourable for Edmonton Strathcona.
Thank you, Mr. Speaker. Mr. Speaker, I'm rising to speak to the matter of Bill C-10, described as Safe Streets and Communities, and I'm rising today in my role as the critic for Aboriginal Affairs and Northern Development. This approach has been raised by a number of the members in speaking to this bill, in raising concerns that it doesn't fully address or respond to the issues and concerns that have been raised over the decades by the courts, by corrections officers, by legal experts, by corrections experts, and by the Aboriginal community itself. The Aboriginal community in Canada is less than 3 to 4% of the population, yet tenfold more Aboriginal Canadians are incarcerated. As National Chief Sean Atleo has pointed out, Aboriginal youth are more likely to be incarcerated than to graduate from high school. The number of Aboriginal women prisoners is growing more than other Canadian women. 46% of women in maximum security are Aboriginal. There has been a 20% increase in the incarceration of Aboriginal women over just the last 5 years. To give examples at the provincial level, in Saskatchewan provincial jails, 87% are Aboriginal. In Manitoba, 83% are Aboriginal. In Alberta, 54%. This is absolutely reprehensible. Surely they should have raised a red flag with this government in coming forward with these proposals to address crime and to reduce crime and to consider victims. Surely they should have given consideration to this. But it doesn't seem apparent on the face of the bill and doesn't seem apparent in the debate. Why are Aboriginals a higher rate of incarceration? Well, the reasons, as I mentioned, have been reiterated in countless studies, decisions of the courts, determinations by coroners, and so forth. The Auditor General has raised concerns about this and about the discriminatory treatment of Aboriginals in more than 30 reports over a decade. The coroner's report on the sad rate of suicides at Pikangikum, the coroner's report there raised the broader issues of concern of why it is that we're having suicides, why we're having a high rate of crime within the Aboriginal community. The reasons are commonly stated and have been stated decade after decade. Discrimination against Aboriginals in education, housing, sanitation, rate of poverty, opportunities to engage in the economy, which has resulted in despair, gang membership, domestic disputes, and intoxication-related crimes. The cost of Bill C-10 for Canadian Aboriginal communities is far greater than just the price of expanded jails. The price to the Aboriginal community is an increasing loss of opportunity for Aboriginal youth to participate and have community support, to continue their education, to participate in the economy, to have the support of their families, to become contributing members of society. Particular problem that has been raised by a good number of the witnesses on this bill have raised the concern of the blanket policy of minimum sentences. Many legal experts have testified in both the past bills by this government in the last Parliament and the current bill. And they have stated that the threat of minimum sentences will have negligible deterrent effect for the majority of Aboriginal offenders. Why? Because the majority of offences are related to addictions, violence associated with intoxication, interpersonal violence, a sense of hopelessness, the legacy and the impacts of residential schools and adoptions away from their community, and have been the unwitting victims of either committing the crime or victims of the crime related to street life. Minimum sentences, the experts are telling us, will do nothing to address the root causes of Aboriginal offences. So if the very purpose of this bill, as the government professes, is to deter further crime and to avoid further victimization, then clearly, if the majority of those in our prisons are Aboriginal, there's a problem. Where is the analysis of whether or not these measures will genuinely deter Aboriginal criminals and, in fact, reduce their crime rate? The only predictable result of these measures is increased percentage of Aboriginals in our jails, the increased probability of denied pardons, as they are currently called, and more Aboriginals being outside the economy. This government speaks all the time of the need to get our Aboriginals engaged in the economy. Well, this will have the opposite effect. But the Supreme Court of Canada has made very strong observations through their decades of experience in the courts of hearing cases involving Aboriginal offenders. And they raised very serious concerns with the overrepresentation of Aboriginals in Canadian courts. Where do I have this quote? I don't seem to have the quote. Anyway, they expressed very grave concerns with the inability of the current court system to be addressing Aboriginal offenders. As legal and correctional experts have testified, Aboriginal overrepresentation speaks to the failure of the Canadian criminal justice system to address the root causes of Aboriginal offending. The point made is not that no Aboriginal should ever be jailed. The point is that due consideration should be made to any evidence of inequitable effect of any laws or policies on Aboriginal Canadians. And where found, those policies should be adjusted. Well, this government, a year ago, finally signed on to the UN Declaration on the Rights of Indigenous Peoples, and thereby committed that they would ensure that they would remove any discriminatory policies and practices, laws, which would discriminate against Aboriginal Canadians. Well, there is no evidence of giving due consideration in this bill that they have brought forward. There is no evidence that they have given consideration to experts' testimony and submissions made on this aspect of their bill. So study after study, Royal Commission reports, judicial inquiries, reports by correction services, coroner's report, the Auditor General reports, and recommendations by decisions at all levels of the court have urged action on overrepresentation of Aboriginals in Canadian prisons. More Aboriginals will be removed from the influence and support of their families and communities. We only need to look at the case of these measures on the community of Nunavut. Those who are automatically incarcerated under the minimum sentence will be moved a long distance from their community. There has been evidence brought forward that the prisons are already overcrowded. They will be moved to communities far from their community. And so it removes any potential for family or community support or rehabilitation. And of course, we've heard about the cuts over time in the last Parliament and in this Parliament to community support programs. There have been cuts to the healing centres and cuts to rehabilitation, the closure of the prison farms. Nowhere is this mistaken path more evident than for the Samson Band in Alberta. The Samson Band have come to the federal government begging for support to build a centre for their youth, so that the youth will be diverted away from the increasing engagement in gang violence. There have been sad cases over the last several years of children and community members being killed. And they undertook the effort to do a major review with the RCMP, with the police, with community leaders outside of the community as well. And the top recommendation was to build a centre, to put the programs in place, to get the kids off the street, to divert them from crime. And yet, instead, very close to them is a prison, and that is simply where the youth will continue to be diverted and the crime will continue in their community. We even have the United Church of Canada calling for greater attention to the discriminatory effect of this law on Aboriginal Canadians. So I call upon this government to rethink and give consideration. The federal government has unilateral responsibility for First Nation Canadians, and I believe that it is incumbent upon this government to give closer consideration to what the discriminatory effect of their measures will be on Aboriginal Canadians. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Thunder Bay Superior North.
Thank you very much, Mr. Speaker. I've been reviewing some of the costs of that we're coming to now. A single new low-security cell will cost $250,000. A single new medium-security cell, almost $500,000, and a high-security cell, $600,000. The total annual cost per woman inmate, $343,000, and for a male, it's almost $225,000. When we could be investing in children. And as you may know, Mr. Speaker, and I know the honourable member from Edmonton knows, that we're spending less than half on each Aboriginal student in Canada. Certainly that's true in Ontario, less than half. And so does this make any sense when for a small investment in education, for a small investment in feeding programs in the schools, we could be preventing future costs of such magnitude?
Honourable Member for Edmonton Strathcona.
Thank you, Mr. Speaker, and I'd like to thank the Honourable Member for his astute question. We heard only today in the House during question period the reply by the Minister of Aboriginal Affairs and Northern Development when concerns were raised at the slow pace of response to the crisis in Attawapiskat. His response was, he's concerned we're spending a lot of money in this community, why haven't they solved the problems? Well, the amount of money that the Minister raised pales in comparison to the money that is being spent on the imprisonment of our Aboriginal population, pales in comparison to the monies that we were spending on the education of our Aboriginal youth. And as the national leader of the Assembly of First Nations has pointed out, if we don't turn the corner, we're still going to be incarcerating more youth, and we're going to be graduating them from high school. And if I could share the quote of the Supreme Court of Canada in the Gladue case, these findings cry out for recognition of the magnitude and gravity of the problem and for responses to alleviate it. The figures are stark and reflect what may be fairly termed a crisis in the Canadian criminal justice system. The drastic overrepresentation of Aboriginal peoples within both the Canadian prison population and criminal justice system reveals a sad and pressing social problem.
Questions and comments? Question and comments. The Honourable Member for Charlottetown.
Mr. Speaker, and I thank the honourable member for her presentation and the focus on the impact on our Aboriginal communities. it strikes me that when the only implement you have in your toolbox is a sledgehammer, everything starts to look like a rock. My question for the honourable member is to seek her comments on a more sophisticated approach to reforming our criminal justice system, as opposed to the one that is put before us in this bill, and in particular her comments with respect to the misplaced emphasis on retribution versus crime prevention and a focus on the root causes of crime. Thank you.
Member for Edmonton Strathcona.
Thank you, Mr. Speaker, and I'd like to thank the honourable member, Charlottetown, for his question. Mr. Speaker, his question sums up basically the concerns that have been raised on this side of the House. Canada has been renowned for having a justice system which in fact tries to balance the scales. And in fact, what is more important, if as the government professes that they are concerned about the victims of crime, then surely our focus should be on the prevention of crime and the prevention of victimization of youth. One part of this bill, which, Mr. Speaker, you're aware, our party our members on this side of the House fought very hard to have separated out from this bill and expedited, in fact, in the last Parliament, and that was the sexual exploitation of children. I noticed that Senator Patrick Brazeau has authored a piece talking about the fact that nowhere is the devastation of sexual exploitation more pervasive than among Aboriginal children, and that they represent as much as 90% of those being exploited. And Senator Brazeau is calling for programs to deal with this and prevent the sexual exploitation. Surely that makes sense. Surely we need to pool our resources and move towards addressing this critical discrimination, which is the victim being our Aboriginal children.
Before resuming debate, I have the honor to inform the House that the Senate has conveyed a message that it has passed the following bill, C-16, an act to amend the National Defense Act, military judges.
We'll see.
Also,
pursuant to Standing Order 38, to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Beauharnois-Salaberry on health, the Honourable Member for Halifax on the environment, and
the Honourable Member for Cardigan on fisheries and oceans.
Debate. The Honourable Member for Kootenay, Columbia.
Thank you very much, Mr. Speaker. It's my privilege to speak in favour of Bill C-10, the Safe Streets and Communities Act, during this report stage. And I'm particularly pleased to support the amendments which strengthen this important bill. Before speaking to the proposed amendments, I would like to put them into a larger context. After 20 years of police work and working within the justice system, I often hear great frustration with our justice system. Even when violent criminals are put behind bars, they are never seen to complete their sentences. And before you know it, they're back on the street committing crimes. Meanwhile, the rights of the victims are overlooked and forgotten. There's something wrong with that picture, Mr. Speaker. Canadians know it, and so does our government. When we first took office, we identified greater safety and security for Canadians as a priority. For the past 6 years, we've moved decisively on our law and order agenda. We've invested substantial resources to help law enforcement agencies do their jobs better. We've passed laws to ensure that offenders do serious time for serious crime. And we've supported crime prevention to help keep youth away from gangs, drugs, and violence. We've pursued these efforts with one overarching goal: to make our streets and communities safer. I'm proud to say that Bill C-10 is a natural extension of these efforts. The proposed legislation before the House would go a long way toward protecting the most vulnerable of our society, as well as victims of terrorism. It would hold offenders and supporters of terrorism more accountable for their actions. Let me highlight exactly how it would do that. Mr. Speaker, first, the bill would continue to work begun with the Serious Crime for Serious Time Act. To that end, it would establish or increase mandatory minimums and increase maximum sentences for various serious offences, particularly related to children and youth. Offenders convicted of child exploitation would no longer be eligible for a conditional sentence or house arrest. And drug dealers involved with organized crime who target youth could also expect harsher sentences. Nor are we willing to wait until a crime is permitted before taking action. Police will be given the tools to be proactive rather than reactive. This bill would require judges to consider putting limits on suspected or convicted child sex offenders. It would empower police to arrest offenders without a warrant who are in breach of the conditions of release. In other words, this bill would put the rights of victims ahead of the rights of offenders, which is where they should be. Mr. Speaker, in the same vein, Bill C-10 introduces new measures both to increase the accountability of offenders and strengthen the voice of victims. Under the new legislation, offenders would be required to have a correctional plan that laid out clear expectations of behavior. This would include, for example, a requirement to meet court-ordered obligations to repay victims or for child support. And the legislation would also introduce new penalties for inmates who display disrespectful or intimidating behavior, whether it's directed at staff or at other inmates. The bill would also make an important change, exchanging the word pardon for the phrase record suspension. We want to send a clear message that closing off a criminal record for the public eye does not forgive the offense. The offenses committed by these individuals can often scar victims for a lifetime, and we believe it is important to recognize that fact. Mr. Speaker, what's more, we would make it impossible for certain offenders to apply for a record suspension. In the government's view, anyone convicted of a sexual offense related to a minor does not deserve a record suspension. In the interests of public safety, child molesters, even after release, should carry the history of their offense with them for all time. Not as an extra punishment, but rather to protect the safety of the most vulnerable in society, our children. By the same token, the bill would allow the minister to refuse offenders' transfer from a foreign prison back to Canada if there was any risk to the public, in particular to the safety of a child. Offenders should serve the time in the country they were convicted. Mr. Speaker, victims are generally kept in the dark about an offender's life in prison. They don't know whether offenders are taking part in rehab programs, if they've been absent from the institution temporarily, or if they're getting transferred to a minimum security facility. Victims deserve more, plain and simple. And so Bill C-10 will give them the right to take part in conditional release board meetings and to be in the loop about the behavior and handling of offenders. I've spoken up until now about keeping our streets and communities safer from crime. But there are other risks and other types of victims. I am speaking, of course, about terrorism and its victims. Mr. Speaker, just as victims of crime deserve a greater voice, so too do victims of terrorism acts. Bill C-10 would allow victims to seek redress in the courts against the perpetrators of terrorism and their supporters. And it would set in place a rigorous process for the listing of state sponsors of terrorism by the Government of Canada. Mr. Speaker, our government is determined to do everything in its power to protect Canadians and make our streets and communities safer for all. To achieve that goal, we want to make this legislation as strong as possible. And so I'm proud that the government passed 4 amendments at the committee stage and has introduced another one at report stage. Mr. Speaker, I would like to add my support to the amendment proposed today and to the 2 passed by committee pertaining to public safety. Mr. Speaker, the initial legislation proposed that victims should be able to sue foreign states for supporting terrorism. The government has proposed today that victims should also be able to sue foreign states for having directly committed an act of terrorism. I am proud to support this proposed amendment. I'm equally pleased to support the 2 amendments related to the public safety passed by the committee. The first would help lighten the burden on victims of terrorism, while the second would allow a court to hear a matter based solely on the plaintiff's Canadian citizenship or permanent residency. Mr. Speaker, I want to add my thanks to the committee members for their good work, and I must add, for all the hours that I sat there, they did an unbelievable job on both sides. In recognition of the committee's close scrutiny of the bill, I urge all members to join me in supporting these amendments. Together, we can make our streets and communities safer for all Canadians. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Thunder Bay, Superior North.
Mr. Speaker. Mr. Speaker, in the last 6 months, I've bought 13 copies of the book The Spirit Level by Wilkinson and Pickett and given them away. And I'll buy more because it's a scientific work that shows how in the 33 richest, most developed countries, the 4 best countries in the world with outcomes, including crime, are the Scandinavian countries, how the U.S. is the worst in all these parameters, and how Canada is sliding towards that American model. So my question for the member is, instead of investing, as the U.S. has foolishly done and now started to see the error in their ways, when are the Conservatives, and hopefully this member, going to invest in education, health care, treatment for mental addictions, and especially work to reduce the growing gap in income in some of the worst developing countries in the world, the developed countries in the world? Thank you, Mr. Speaker.
Member for Kootenay, Columbia. Thank you, Mr. Speaker, and I thank the honourable member for his question. As a former police officer, I can tell you that there are a number of programs that are instituted by not only the RCMP, but countless provincial and municipal police organizations that work toward trying to keep youth out of the system. And we are pretty successful at it. But there is that segment of society that we cannot control. And for those people, there needs to be a movement toward incarceration. It's unfortunate that that has to occur, but it is part of the process.
Questions and comments? The honourable member for Saanich Gulf Islands.
Speaker, and I'd like to pause for just a moment to thank the honourable member for Kootenay, Columbia, for the nonpartisan way in which he credited members on both sides of the committee. This bill has been so filled with rancour in the debate that was a nice departure. But I do find it worrying that there's a lot of rhetoric about how this bill supports victims, but there's very little in the bill that actually does support victims. I was taken with the evidence of the Ottawa Victim Services Director, Steve Sullivan, who said, where's the support here for women who have been victims of sexual violence? Where's the support, the counseling, the help for victims who need funding to be able to manage when they've been assaulted and can't get to work? Where's the tangible help for victims? Because I don't see it in this legislation.
Kootenay, Columbia. Thank you, Mr. Speaker, and thank you to the member from the Gulf Islands. Certainly, there are victim support groups throughout the provinces, and I'll speak specifically to British Columbia and specifically to my constituency of Kootenay, Columbia. Victim support is part of the court system, part of the provincial court system that allows victims to go and seek redress for whatever type of requirement they need, whether it is for, as the member had indicated, trying to get here and there to a doctor's appointment or to a counseling appointment. It provides opportunities for people to find programs that are available to help them move forward after the crime has been committed. and the perpetrator has been dealt with. So I believe that we are doing an excellent job with regards to crime prevention programs and the support of victims of crime.
Questions and comments? The Honourable Member for Essex.
Mr. Speaker, and just for the benefit of those who are looking in on this particular debate today, there's some context to it. You talk about a balanced approach from this government with respect to how we deal with the criminal justice system. In budgets past, we've had tremendous investments, multi-million-dollar investments for that matter, Mr. Speaker, in measures to prevent crime, to get at the at-risk youth. And, Mr. Speaker, how did the opposition vote on those? Well, they opposed them, notwithstanding what they say today, Mr. Speaker. We have measures to put more frontline police officers on the beat, working in the community to keep people, to find those who are in crime and to work with community groups to keep people away from crime. And how did they vote, Mr. Speaker? They voted against it, notwithstanding what they say about prevention today. Isn't today what we're dealing with is what the opposition has also stalled in previous parliaments, and that is measures to rebalance the criminal justice system to deal with the public safety threats that are out there and they're reluctant to deal with. Would the member comment on that?
Member for Kootenay, Columbia.
Certainly the measures, and thank you, Mr. Speaker, and thank you to my colleague from across the way. Certainly we have been trying our best to move forward with this Bill C-10 to ensure that the victims of crime are the ones that are recognized as the actual victims here. We have to ensure that those that commit the crimes do the time for the crime that they've committed. I believe that Bill C-10 does that, and I believe that we're heading in the right direction, and I'm all for this one. Thank you.
Resuming debate, the Honourable Member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I rise today to speak at the report stage of the Bill C-10, the Conservative Omnibus Bill. A bill, well, actually it's 9 bills combined together into one. A bill that this Conservative government is ramming through this House without proper scrutiny, and we don't even know how much it's going to cost. We saw witnesses being forced through committee so quickly that they barely were given time to speak. New Democrats proposed to the Parliament that the bill be divided so that parts of which would actually improve public safety and help protect our children could be passed at all stages immediately. Mr. Speaker, I'm a father of 2 children, young children. I know how important it is to protect our children. Unfortunately, the Conservative government rejected our proposals. We also proposed amendments to the bill, which the Conservatives flatly rejected in the committee. But the Conservatives don't want to discuss or debate the real problem with this bill or any other bill they have put in front of this Parliament. Every day in this House, they are undermining democracy by shutting down debate prematurely without reason. New Democrats tabled a motion in this House last Friday, a last try to stop this, because this is democracy and Canadians deserve a real debate. Mr. Speaker, the Parliamentary Budget Office estimates that Bill C-10 will cost the federal government $5 billion over 5 years, and the provinces and territories somewhere between $6 to $10 billion. The PBO's office is working to complete a more detailed projections. However, he has to work basically largely in the dark because not all of the facts and figures are provided to him by this government. The government has not provided him with adequate information so he can do his work. Many critics suspect that the government's refusal to produce realistic costing document is because they have no idea what the real price tag for Bill C-10 is going to be. Mr. Speaker, and worse yet, they want to force it into law before we have a chance to find out how much this bill is going to cost Canadian taxpayers. Since the introduction of this controversial omnibus bill, we have seen a groundswell of concern from across this country, from coast to coast to coast. Opposition to the Conservative crime agenda has been steadily mounting. Experts from across the political spectrum urging the government to rethink the sweeping changes to criminal justice system contained in this Bill C-10. Mr. Speaker, we've heard repeated warnings of huge costs to taxpayers, the crippling impact on courts, and enormous pressure on our already struggling corrections system. These serious warnings are simply being dismissed by the Conservatives without any explanation. In response to questions about Bill C-10, the Justice Minister recently commented, and I quote this, "We are not governing on the basis of latest statistics. Clearly, facts and evidence and research were not a priority when this government was drafting Bill C-10, but neither was cost to taxpayers." We've heard in the committee provincial leaders speaking out against this bill, and they have been very clear that they're not ready to bear the cost of this Harper's prison agenda, this government's political agenda. I take that back, Mr. Speaker. Nor do they agree with many of the measures contained in this bill. The Canadian Association of Crown Counsel has spoken out to say that Bill C-10 will overload prosecutors and jam our already stressed court system. This is so-called tough on crime agenda has already failed across the border in the United States, where governments are moving away from the same approach that the Conservatives are now proposing here. States like Texas are now abandoning the mandatory minimum and 3 strikes policies that lead to ballooning prison costs, population, and skyrocketing costs to the taxpayers. The states, they have found that these approaches have actually done little to prevent crime, but do a great deal towards bankrupting the states. Mr. Speaker, Canada should be learning from our mistakes of our neighbours, not repeating them. We need practical solutions on crime that improves safety in our communities, not old strategies that are expensive and proven to be failures. You know, there are some measures in the bill, like provisions that toughen laws around child luring, sexual exploitation of children, that we as New Democrats fully support. But there are also those that will do nothing to make our streets and communities a safer place. Mr. Speaker, New Democrats believe that the primary goal of any legislation, any changes to our criminal justice system, should be public safety, safer streets, and protecting our families and communities. A major way to accomplish this is by supporting cost-effective crime prevention programs that really make a difference, something which this government has failed to address. And I spoke up about a program last week, Mr. Speaker. There is a society in my constituency whose funding is being cut, and they actually help at-risk youth, educate them about self-esteem, getting back into school, and the funding for this particular program is being cut by the Conservatives. Mr. Speaker, our communities would be safer if this government focused on goals like putting more police on the streets and stopping gangs from recruiting our youth. Mr. Speaker, I see Conservatives always talk about how they're investing into policing the frontline officers. The facts are, the Auditor General, in the last report in June, pointed out that the police is woefully underfunded to fight against gangs, to fight against crime. What we need is more frontline police officers. Not only they'll help prevent crime, but they help to deter crime. That is a good way to go about preventing crime in our communities. Mr. Speaker, also by ensuring that our corrections system has rehabilitation programs that reduce the rate of reoffending. Unfortunately, this government is cutting funding to prevention programs like the Pathfinders I talked about. Youth gangs prevention programs are a critical future of our children and the safety of our communities. And I'll conclude, Mr. Speaker. You know, this approach, conservative approach, is not smart on crime. Canadians deserve better. I urge the government to reconsider the real concerns of Canadians and expressed by members of the opposition and people across this country. At the last stage of the bill, the report stage, I urge the Conservative members to consider the amendments proposed by New Democrats, and I urge the government to stop and not push through this bill. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Health.
Thank you very much, Mr. Speaker, and I've been listening to my colleague's comments, and I'm very interested to hear his viewpoint on a couple things he brought forward. First, he said there's a groundswell across Canada against this bill. Well, I was actually one of the members of Parliament that I had a protest outside my office, and there was 10 people there. 10 people, and the majority of them were affiliated with special interest groups, some actually involved with the New Democratic Party, and some with different points of view, let's say original points of view on drug use. The member talks about we need more police officers on the street. Mr. Speaker, you know in our budgets we put up money for 1,800 more frontline officers, but the NDP have voted against it. I know this gentleman is a new member, but he doesn't realize that his party's stance on this is way out of touch with Canadians. And I was wondering, he talks about the program cut in his own community. Well, we put these programs in. They aren't meant to be forever programs, but then they want us to extend programs that they've already voted against. So, Mr. Speaker, I was wondering if you could address the fact that there is a difference in the criminal justice system. There are these hard-nosed criminals that repeat, and the best thing we can do for victims is keep them off the street instead of allowing them back on the street and coddling these criminals. Could you address that, please?
Member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I may be new to this House, but I do know what's been going on in the community. And I've been listening to my constituents, and there is a huge support for the amendments, the proposals that we're making. In fact, I've heard from many constituents of mine that are dead set against this approach to crime and prison agenda. We've seen over the years, you know, I don't have to look at the Conservatives' facts. I can look at the facts that are provided by our Auditor General. The Auditor General, in his June report, stated that the RCMP is woefully underfunded by this government. And we need to have more police officers, front lines, so we can deter crime from happening in the first place. Thank you, Mr. Speaker.
L'Honorable Député de...
The Honourable Member for Charlottetown.
Thank you, Mr. Speaker. My question for the Honourable Member relates to the impact of this bill on the provincial coffers. In my province, the provincial institutions are already strained. This will add an additional strain, yet there's apparently no compensation that comes with it. We have heard from the Canadian Association of Crown Prosecutors that there's lots of money for police, there's lots of money for prisons, but in between there's a system that's stressed to the max, and that system is largely the responsibility of provincial governments. Could I hear from my honourable friend with respect to the impact on provincial governments?
For Surrey North.
Thank you, Mr. Speaker. We've heard from a number of ministers at the committee stage, and first of all, thank you for asking the question there to my honourable colleague. We've heard from Quebec, we've heard from BC, we've heard from a number of other provinces. The fact of the matter is, this is basically a cost or offloading federal costs to the provinces. And I saw this morning in the papers this morning. BC is already running a very high deficit. This is going to add additional costs to the provinces. So some of the programs that the provinces are responsible for, education, healthcare, our schools, those are going to be chopped as a result of this bill by this government.
There is time for a brief question and a brief answer.
For Thunder Bay, Superior North.
Thank you very much, Mr. Speaker. I've heard the Conservatives say repeatedly that police officers, I'm a former police officer, and I'd just like to ask our honourable member if he's aware that before he was elected, that repeatedly the NDP has been asking for thousands of more police officers. We just heard a question saying that there's money for police officers in prisons. Unfortunately, it's only prisons. Is he aware of how we've been asking and how those needs have not been met?
Member for Surrey North.
I thank my colleagues for answering the question, Mr. Speaker. Mr. Speaker, I have worked with the police for 14 years. A number of them were my colleagues, and I'd worked side by side at my former job at the Justice Institute in Westminster. And I've talked to many, many police officers over the years, and we do training for police. In my former job, that's what part of my job was. And I've heard from many, many police officers, and the number one thing they say is that we need more police officers, frontline officers, out on the street. And Mr. Speaker, I know my time is up, but I'm going to just add this on. They have been asking for additional police officers, and we have been asking for additional police officers. In fact, one of my first questions to Public Safety Minister was of getting more police officers out on the street. Thank you, Mr.
Resuming debate, reprise de débat. The honourable member for Etobicoke Centre.
Thank you, Mr. Speaker. Honourable members, I'm grateful for the opportunity to speak on Bill C-10, the Safer Streets and Communities Act. I welcome all of the proposals in this bill. I believe that their enactment, both individually and collectively, will make a significant contribution to safeguard all communities across Canada. I will first address the impact for victims of violent crime. In my riding of Etobicoke Centre, there is a family named Sikovic. The parents are Vesna and Dvorin. Vesna is a piano teacher, and Dvorin works at CBC Radio. Their son Boris attended high school in Etobicoke at Scarlet Heights. The Sikovics were refugees from war-torn Sarajevo, with Boris arriving in Canada as an infant. This family worked to escape the horrors of a war where former neighbours preyed upon each other and visited atrocities upon each other in every form imaginable. The family settled in Canada, grateful for the new start that they had and grateful for the opportunities that Canada had provided their son. As Boris grew up in Canada, he became the all-Canadian kid, an athlete and gifted hockey player, a leader on the ice, helping less skilled players score and achieve rather than allowing his own talent to dominate. He mentored his teammates. At so young an age, he showed maturity and a wisdom that was returned by his large circle of friends through great affection and strong bonds that developed in elementary school and endured through high school and what would have appeared to be beyond into university and throughout life. Boris was a leader and one that this close circle rallied around. He was a natural and his future appeared limitless. Then, Mr. Speaker, on a night in 2008, Boris and his friends were transiting a local park, were accosted, and he was shot and killed while being robbed of his backpack and valuables. Mr. Speaker, the Sikovics are victims devastated by the tragic loss of their only son, their son who had natural gifts and talents and was on his way to becoming a model Canadian success story. What of the Sikovic family in this? Do they care that Statistics Canada says crime is down, that as the opposite members opposite often cite? I asked them that, Mr. Speaker, and their response was a resounding no. I challenge any members opposite to look that family in the eye and quote that statistic. The Sikovics are not vengeful people, but they are entitled to justice for their son. On the many provisions in Bill C-10, victims of crime will have the ability to present statements at a parole board hearings. If attending the hearing, a victim may comment on the harm or damage resulting from the offence and its continuing impact, including concerns for his or her safety and the possible release of the offender. Even if the victim does not attend, the parole board may authorize presentation of the statement in an alternative format. Also authorized to present the statement are persons described who were harmed or suffered a loss due to the act of the offender. This includes any safety concerns and concerns regarding the offender's potential release. This provision provides victims with empowerment and a role in the corrections process. Other areas include the elimination of pardons for violent crime and measures that protect the public from violent and repeat young offenders. Mr. Speaker, today I speak for a family that has been tragically victimized, and I speak in the name of Boris Sigovich, who can no longer speak for himself, but today in this House, Mr. Speaker, his voice is heard. I will focus my remaining remarks on Bill C-10's proposals addressing child sexual exploitation and violent crimes in Part 2 of this bill. As members will know, these proposals were originally introduced as Bill C-54, the Protecting Children from Sexual Predators Act, and with all-party support had been passed by this chamber in the last Parliament. Bill C-10 reintroduced these proposals with some additional sentencing enhancements that are consistent with and reflect the overall objectives of these reforms. Part 2 seeks to better protect children and youth from sexual predators in two ways. First, by proposing sentencing enhancements to ensure that all sexual offences involving child victims are consistently and strongly condemned. Second, by creating new offences and measures to prevent the commission of a child sexual offence. Mr. Speaker, Bill C-10 has been reported back to the House of Commons after having been thoroughly studied by the Standing Committee on Justice and Human Rights, without any amendments to its child sexual exploitations reforms. Indeed, Part 2's proposals received strong support by witnesses appearing before the Justice Committee, including the Canadian Association of Chiefs of Police, the Canadian Police Association, the Kids Internet Safety Alliance, KINSA, as well as the Minister of Justice and Attorney General from New Brunswick, who said, "I believe strongly that crimes against children deserve strong sentencing. We believe the changes proposed in this crime bill will make it possible to achieve that objective." I couldn't agree more. Bill C-10 proposes to enhance the sentencing or penalties for sexual offenders involving child victims in two ways. It proposes to impose 7 new and 9 higher mandatory minimum penalties, as well as higher maximum penalties for 4 child-specific sexual offences. These amendments are needed because currently the Criminal Code only imposes MMPs in 12 child-specific sexual offences and none at all in the general sexual offences where the victim is a child. And for those offences that already impose MMPs, these are inconsistent and or simply inadequate. The effect of imposing MMPs in only some but not all sexual offences sends an inconsistent message that not all child sexual offences are serious and perhaps even that some child sexual assault victims are less victims than others. Imposing inconsistent and inadequate MMPs is equally problematic. For example, currently the Criminal Code imposes a mandatory minimum penalty for 45 days for the offence of sexual interference with a child, even though the maximum penalty or indictment is 10 years. Bill C-10 proposes to fix this by increasing this MMP to 1 year. To my mind, and I think to all of us here, the current inconsistent and inadequate approach to sentencing in child sexual abuse cases is wrong. Who among us does not agree that children are the most vulnerable in our society and that all children are deserving of equal protection against all forms of child sexual exploitation? As I noted earlier, Bill C-10 also seeks to prevent sexual assault against children. It proposes 2 new offences criminalizing sexual assault against children that police witnesses were particularly against. The first new offence would prohibit anyone from providing sexually explicit material to a young person for the purpose of facilitating the commission of a sexual offence against that young person. Child sex offenders often use adult pornographic material to groom their victims, for example, to lower their victims' sexual inhibitions with a view to making it easier to sexually exploit them. Though any such use of child pornography is already prohibited, this is not the case for adult material. Accordingly, this new offence would fill a gap. The proposed new offence would impose a mandatory minimum penalty consistent with other parts of the bill. The second offence proposed by C-10 would prohibit anyone from using telecommunications to agree or make arrangements with another person to commit a sexual offence against a child. This offence is modelled on the existing luring a child offence. of the Criminal Code that prohibits the use of a computer system to directly communicate with a child for the purpose of facilitating a sexual offense against that child. However, as the luring a child offense only applies when communication is with the child victim, this new offense closes the gap where the communication is between two other persons to facilitate the commission of a sexual offense against a child. This offense will also impose a mandatory minimum penalty. As well, Bill C-10 will impose a condition on convicted child sex offenders or on suspected child sex offenders, a recognizance or peace bond under Section 810.1, prohibiting them from having any unsupervised access to a young person or unsupervised use of the Internet, preventing a known or suspected child sex offender from having the opportunity and tools to commit a child sexual offense should protect other children from being victimized. Mr. Speaker, I urge all members to support the swift enactment of Bill C-10 so that Canada's children will be protected against sexual exploitation. Thank you, Mr. Speaker.
Questions and comments? Kesha, commentaire. The Honourable Member for York South Weston.
Thank you, Mr. Speaker. And my heart goes out to the family of Mr. Sikovic that you referred to earlier, and we certainly don't disagree that we on both sides of the House would like to prevent crimes such as this. And I guess that leads me to my question. How does this bill do anything to prevent what happened to the Sikovics from happening again? Could you explain to that for me, please?
The Honourable Member for Etobicoke Centre.
Mr. Speaker, I thank the Honourable Member for his question. It assists in preventing further crimes because mandatory minimum sentences are imposed on a lot of these crimes within Bill C-10, which will add a further deterrent to criminals contemplating perpetrating this form of crime, especially a violent crime in this case. It also allows, if a crime in this case, as it has been committed, is perpetrated, it also allows the victims a form of redress in being able to access the parole system and have an ability to impact on the offender's incarceration.
Questions and comments? The Honourable Member for Charlottetown.
I just want to follow up, Mr. Speaker, on that last answer. The suggestion from the Honourable Member is that mandatory minimum sentence will provide a deterrent. Yet there is no evidence for this. In fact, there's evidence in the United States to the contrary. My question is whether this member's view of the criminal law is that the right way to go is an eye for an eye and a tooth for a tooth, or does he subscribe to a more enlightened view based on proportionality?
The Honourable Member for Etobicoke Centre.
Again, Mr. Speaker, I thank the Honourable Member for his question. And this Bill C-10 is a made in Canada law. It's not a made in the United States law. So we're not looking at them, we're looking at us. And Canadians have given this government a very strong mandate to enact the laws. We made a promise that we would pass Bill C-10 with strong laws involved and making sure that serious offenders are jailed for the appropriate length of time. It also ensures that our victims feel that justice has been rendered. It's not an eye for an eye thing. It's an ability for the victims to be able to redress the crimes that have been perpetrated against them and to ensure that the criminals are incarcerated for an appropriate period of time. Although rehabilitation still happens, it provides comfort to those victims that these criminals will not be released too early and that their rehabilitation will have time to take root, Mr. Speaker. Thank you.
Questions and comments? The Honourable Member for Fort McMurray, Athabasca.
Thank you, Mr. Chair, and I appreciate the opportunity to ask this member a question. I'd like to congratulate him on the speech, a well-done speech. And indeed, I did listen to the question from the Liberal member opposite, but I had an opportunity to practice criminal law, actually be in the trenches in this kind of situation. And I had a client that received 2 years less a day for sexually assaulting two of his daughters over a 7-year period of time. And he was able to do that in a house. And I was ashamed of getting that sentence. I was quite frankly surprised that that sentence was available, first of all. That was about 8 or 9 years ago. But it's still available today, Mr. Chair, and we're taking away that opportunity. And I just want to ask the member, does he think it's reasonable that a person that would do that to his daughters, two family members, over any length of time, if at all, is that a reasonable thing to be able to do any time or any punishment in your own home. Is that a reasonable disposition as is allowed today under the Criminal Code?
The honourable member for Etobicoke Centre.
I thank my honourable colleague for the question and his comment. And absolutely, it is not a reasonable time, especially, first of all, any offence against a child, whether it's your own child or someone else's, is absolutely reprehensible. However, when they are your own children and they are to feel safe and secure with their parents in their own home, and they don't feel that and they are victimized by their own parents, and then that parent is only sentenced to the absolute minimum possible term, that continues to victimize those children once again, because that individual will be released in 2 years less a day, or less than that even. And that will cause further harm to those children down the road because of psychological impacts and because justice will never have fully been rendered in their case. Thank you, Mr. Speaker.
Resuming debate. Reprise de débat.
Resuming debate.
Winnipeg North.
Thank you, Mr. Speaker. Mr. Speaker, it's with pleasure that I get to stand today to talk about Bill C-10. Bill C-10 does and will have a very profound impact. I think, Mr. Speaker, in good part, it kind of sets the stage in terms of different ways in which we want to be able to deal with crime in our country, not only for today but well into the future. And it's nice to use this particular bill as a bill that clearly illustrates the difference between the Conservative government and the Liberal Party of Canada, or even to a certain degree, the New Democratic Party, Mr. Speaker. On the one hand, you have a government that's very determined to try to give an impression. The impression that they're trying to give Canadians is the fact that they, as a government, are going to be tough on crime, giving the perception that, look, by supporting the Conservatives, that somehow the crime rate in Canada is going to be going down. And, Mr. Speaker, this is something in which, over the years, they have been going out of their way to try to give that impression. Well, Mr. Speaker, for me personally, and I believe for the Liberal Party, the real push should be how it is that we can prevent crimes from taking place in the first place. Mr. Speaker, I want to go back to what real people are saying on our streets and in our communities across Canada. You know, I can recall one lady, and I might have made reference to this fact in the past. I represent Winnipeg North, which is a beautiful, beautiful area of Winnipeg. One of the areas in Canada that I believe in has, great attributes, very characteristics, has a great deal of history. It has a modern suburban area. But there was one constituent that was living in and around that Selkirk and Pritchard by Arlington area. And I was kind of touched by her comments that she had said to me. And that was that she did not feel that she was safe enough during the nighttime to be able to go to sleep, that she preferred to sleep during daytime because she felt it was safer for her to go to sleep. And one of the comments that she had given was that she was also scared to go outside her home at night, even into her own yard. In essence, saying that, when the sun goes down, she, in essence, becomes confined to being in her own home. And, Mr. Speaker, I was very concerned about that particular constituent. And throughout the campaign, whether it was the by-election of last year or the general election this year, Mr. Speaker, in the door-knocking that I conducted, what I found is that the whole issue of crime and safety is one of those issues. It didn't matter which house you knocked on. If you were to raise the issue, the residents were more than happy to give an opinion on the issue, that they were concerned about the issue of crime and safety. You could talk about defense spending, you could talk about health care, you could talk about many other different issues that are out there. And the only issue that I found that was consistent, no matter what door, if I wanted to engage someone, was to talk about the issue of crime and safety. And what that one elderly lady had raised to me was not the only instance where something really struck me. I remember being with another individual senior. He was a gentleman living, I believe it was in the McGregor apartment unit, and he talked me about two wallets, and that when he walks around, he carries 2 wallets, Mr. Speaker. And the reason why is because that if in fact he was mugged, he gives the empty wallet, and this way he can continue on. And Mr. Speaker, it starts to draw a great deal of concern as a local member of Parliament why it is that people get the opinions and feel that insecure when they go out into our communities. Now, there are many examples that I could give that people raised at the door, but the overriding concern that I have, Mr. Speaker, is that I want to be able to make a real, tangible difference in the community in which I live and the community in which I represent. And I believe, in most part, that members of Parliament would like to do likewise, that they want to deliver for their constituents. They want to ensure that their constituents are feeling better in the communities in which they live, or they're feeling secure in the communities in which they live. As I indicated, Winnipeg North is a wonderful area. I'm very proud of the fact that I come from Winnipeg North. I want the seniors in my community of Winnipeg North to feel comfortable, and in most part, I believe that they do, because we recognize the richness of our community. But having said that, Mr. Speaker, I know that there's a lot that needs to be done in order to make our seniors and others feel safer in the environments in which they live. And that's why, when I look at this legislation, I get a little bit frustrated. And the reason why I get frustrated is because the Conservatives' agenda on crime is not necessarily going to deal with the issues that my constituents want them to deal with. Because you see, Mr. Speaker, what my constituents want the Government of Canada to do is to prevent crimes from happening. That's what they really want, Mr. Speaker. Sure, they want consequence. All of us recognize that there needs to be a consequence when someone commits a crime. We don't question that, Mr. Speaker. But what they really want to do is they want to see a government that is caring and compassionate, that wants to deliver. They want to see safer communities. Well, let's take a look at Bill C-10. And what does it really purport to do? Well, number one, Mr. Speaker, it's a huge bill. This is a bill that could probably have been broken into 8 or 9 other bills very easily, Mr. Speaker. But you know, what happens is the government's kind of compiled everything together, because there are some good things within the legislation, Mr. Speaker. But the overall tone of this legislation is not good. Because I would suggest to you, Mr. Speaker, and I've made reference to this when I was asking questions earlier, and that is that the focus of this bill seems to be to build more jails into this whole super jail complex that a number of American states experimented with years ago, Mr. Speaker. That there were individuals at one time in the early 80s, late 70s, maybe even mid-80s, that were saying, build more prisons and put the criminals in jail, keep them in jail, and then our crime on the streets would go down. Well, Mr. Speaker, those very same states that started to evolve in that direction have now recognized that it was the wrong direction. They're now starting to recognize that there is far greater value to having programs that will, in fact, make a difference in preventing crimes, but keeping individuals that don't necessarily have to be in a jail for 15, 20 years, 5 years, whatever it might be, Mr. Speaker. That, in fact, what you'll find is that there is very few, and I would challenge the government to talk about other jurisdictions that are moving in this same direction. I think you'll find that most modern Western countries in the world today are moving in a direction of rehabilitation. They're moving in a direction of trying to prevent crimes from taking place by getting and being more proactive within our communities, Mr. Speaker. Well, you know, the government's response quite often is, well, you know, at the end of the day, we have to keep people in jails because of the victims. And we're not talking about everyone, because at the end of the day, what we're thinking of is property crime is far greater than violent crime. And you'll find that there's a lot more interest on the violent crime in terms of making sure that there is some form of jail time, Mr. Speaker, an adequate jail time, in which I think in most part judges have done a very good job in using that discretion, Mr. Speaker. But what we're doing is the government needs to recognize that it's a balancing thing, Mr. Speaker. Your priorities need to be either create the additional jails or invest in things that will keep people out of jails. And I would think that we'd be much better off, Mr. Speaker, if we put more focus on that, because it is a finite amount of resources, and when there's a finite amount of resources, it becomes an issue of prioritizing, and I believe the priorities of the government on fighting crime is in the wrong direction. I assume I'm out of time, Mr. Speaker. We'll have to hopefully continue on through questions. Thank you.
I must apologize to the member for Winnipeg North. I usually give the 1-minute signal. I allowed him a little bit of extra time here to finish up, but I appreciate it. Questions and comments? Question et commentaire. L'honorable député.
The honourable member for Jean-Lebert.
In speaking to some of the workers, community workers in my riding, they gave me consistently some really interesting figures, saying for every $5 invested in prevention, there's $95 spent incarcerating an individual. Now, I don't think, again, there's nobody in this House who does not agree with stiff sentences for people who harm children. There's nobody that doesn't agree with stiff sentences for people who take people's life. In fact, in my writing, a mother lost her son to 3 young individuals who beat him to death. And my heart goes out to her, and for her, I think, you know, justice needs to be served. But what we're talking about are those people who grow a little pot and are thrown in prison for 1.5 years. Now, prison can be a very scary place, but it can be a very educational place. So after that 1.5 years, when those young people get out, they're hurt, they're bitter, they're messed up, and they're going to take that out on society. So I would like my honourable colleague to comment on how this helps keep crime off the streets by creating better criminals.
Just before we get the member for Winnipeg North to respond, just a reminder to honourable members to watch the chair from time to time, just so we can indicate how much time is remaining. The honourable member for Winnipeg North.
Yes, Mr. Speaker, I was a provincial justice critic for many years, and one of the biggest things that we wanted to be able to establish was the fact that the best way to tackle crime, to fight crime, and prevent crimes from taking place in the first place is to invest money up front. And by investing money up front into programs that will steer people away from committing crimes is far more effective in terms of, at the end of the day, we'll have less crime on our streets, and we'll have better communities and safer communities to live in. I appreciate the comments, and I must say I do also concur with his comments. You know, just because I don't support the bill doesn't mean in any fashion whatsoever that I believe there needs to be a consequence for many of those crimes, such as pedophiles and so forth. Thank you for the question.
Questions and comments? The honourable member for Prince Edward Hastings.
Well, thank you, Mr. Speaker. And I'm just, I've been listening to the member opposite, and with the greatest of respect, I did serve as a police officer for a number of years, and I do recognize the reality of the balanced approach. We do have to have prevention, we have to have treatment, we have to have rehabilitation. Certainly have no difficulty with that, as do most Canadians. But we also have to recognize there is an element of society, unfortunately, that is dangerous. And these people need to be isolated from the public as a matter of protection. The challenge we have, of course, everybody, I'm just hearing, well, money, money, money for jails. Well, I'm wondering how many of my opposition members have actually been in some of our penal institutions. Many of them, quite frankly, are archaic. They are barbaric. There is no possibility, even for facilities, for rehabilitation and or for self-improvement. We have to be able to bring things up to a level of accommodation where we can provide that balanced approach. So we do need protection, we do need preservation, and we do need prevention. But it does take all. This bill obviously does not deal with the total scope. There are other bills that do deal with prevention as well, but this does deal with protection and victim protection, and I hope the opposition members would certainly recognize that and give it due course reading and support due to those principles.
For Winnipeg North.
Gary Kowalski was a wonderful police officer. Both him and I served inside the Manitoba legislature. Gary Kowalski talked about if you want to be able to deal with some of these youth, what you should do is you should get involved in youth justice committees, Mr. Speaker. And by getting involved in youth justice committees, that you're going to be able to deal with, again, preventing crimes from taking place in the first place. You'll find in the last number of years, especially in the province of Manitoba, that youth justice committees and the roles that they've been playing has actually deteriorated. Again, it's an issue of priorities. If the government put more priorities in that, Mr. Speaker, then in fact we would be able to see better results at the end of the day. Less crime on our streets.
Question and commentaire.
Questions and comments?
Compliment my colleague certainly on his passion when he speaks here in the House. I think he should be winning the award for the most passionate speaker on many issues, frankly. But in particular on this bill and the concerns that a lot of us share about wanting to have a balance. But the issue of the mentally ill and how they are treated. I wonder if there's been enough discussion and debate, and is there anything in this C10 really that is going to speak to those who are mentally ill when it comes to crime?
The Honourable compliment, and Mr. Speaker, she brings up an exceptional point. You know, whether it's mental illnesses, issues such as disorders, fetal alcohol syndrome, these are issues that have a profound impact in terms of what individuals are doing in our communities. And if we don't allocate the resources that are necessary to be able to support better programming, at the end of the day, we're going to end up spending more money in our jails, and there will be, again, more crime on the street. And I know that's a point that I hammer home every time I get. And for me, it's all about reducing crime on our streets. And that's one of the reasons why I find it so difficult to support this bill. And if we just invest a little bit more in things like the member just made reference to, looking at mental illness and trying to address with that, will do far more than this bill will do in terms of reducing crime on the street. Thank you, Mr.
Order.
I have the honor to inform the House that communication has been received. Mr. Speaker, I have the honor to advise you that the Right Honourable David Johnston, Governor-General of Canada, has granted royal assent by written declaration to the bills listed in the appendix to the current letter, November 29, 2011. With the highest regards, Stephen Wallace.
To inform the House that a communication has been received which is as follows. Mr. Speaker, I have the honour to inform you that the Right Honourable David Johnston, Governor-General of Canada, signified royal assent by written declaration to the bills listed in the schedule to this letter on the 29th day of November 2011 at 4:15 p.m. and it's signed Stephen Wallace. Oh, pardon. C'est nécessaire pour... je lis le projet de loi.
I also have to read the bill.
Projet de loi ayant reçu la sanction.
Bills receiving royal assent on Tuesday, November 29th, 2011. An act to implement an agreement between the Cree and Her Majesty the Queen in Right of Canada. Bill C-22, an act, number 3, to harmonize federal law with Quebec civil law and amend other bills so that each language jurisdiction to take into account both systems of law. Bill S-3, an act to amend the National Defense Act, military judges. Bill C-16.
Tuesday, November 29th, 2011, an act to give effect to the agreement between the Crees of EU Ishti and Her Majesty the Queen in Right of Canada concerning the EU Marine Region, Bill C-22. Secondly, a third act to harmonize federal law with the civil law of Quebec and to amend certain acts in order to ensure that each language version takes into account the common law and the civil law, Bill S-3, and an act to amend the National Defense Act, military judges, Bill C-16. I have the honor to inform the House that a message has been received from the Senate informing this House that the Senate has passed the following bill, Bill S-206, an act respecting World Autism Awareness Day.
I also have the honor to inform the House that the Senate has conveyed the following communication, Bill S-206, an act to create World Autism Awareness Day.
Resuming debate, the Honourable Member for Yukon.
Thank you, Mr. Speaker. We are told that the Safe Streets and Communities Act will harden criminals and increase recidivism, yet experts agree that rehabilitation strategies work. Many of these programs occur within the correctional environment, and the length of a sanction should be proportional to the offence and must consider the victims of crime, who are all too often ignored. This bill has many facets designed to protect the rights of victims by enshrining a victim's right to participate in parole hearings and address inmate accountability. At the same time, the bill will allow judges to defer sanctions for offenders enrolled in drug and alcohol treatment programs. Our government continues to invest in prevention strategies, which are critical in ensuring safe streets and communities. A key pillar of our national anti-drug strategy is prevention and treatment for those with drug dependencies. Since 2007, the health portfolio has invested $577 million over 5 years for the strategy's prevention, treatment, and enforcement activities. Our government has made significant treatment investments to strengthen existing treatment programs through the Treatment Action Plan. Communities can celebrate funded health promotion and prevention projects for youth through the Drug Strategy Community Initiatives Fund, with over 100 approved projects across Canada. This represents approximately $40 million in multi-year community-based investments. The National Crime Prevention Strategy's priorities include addressing early risk factors among vulnerable children, youth, and young adults, preventing recidivism among high-risk offenders, fostering crime prevention in Aboriginal and Northern communities, and preventing youth gang and drug-related crime. It also includes the SNAP Girls Connection program. All too often, the message of media fixates on the silos of government. When one looks across departments, there are tremendous and well-balanced approaches to safer streets and communities. Mr. Speaker, we continue to hear the NDP bring up Texas. I fundamentally disagree with any comparison between the Canadian correctional system and the Texas model, Mr. Speaker. Texas has a population nearly equivalent to Canada in its state alone, yet it incarcerates its citizens at a rate 5 times higher than Canada. The NDP quote a recent article, but experts from Texas failed to mention that their relative crime rate has actually gone up for offenses of murder, forcible rape, robbery, and burglary, despite their enlightened approach to crime and sanctions. Texas still boasts the death penalty and has eliminated last meal rights for the condemned. Texas crime rates have fluctuated up and down since 1960 and will continue to do so. Texans will certainly be left scratching their cowboy hats when their rates continue to fluctuate over time. Mr. Speaker, I encourage members opposite, when discussing Canadian realities, to remember these facts, and please, don't mess with Texas. In respect to marijuana grow operations, there has been a tremendous amount of fear-mongering and misinformation around this aspect of the bill. First, one must consider the volume and value 6 plants of marijuana can create. The proliferation of the idea that it's just 6 plants, meaning no harm can be caused, is both irresponsible and wrong. Once again, there is failure on the critics' part to consider victims and innocent people. Take, for example, drug-endangered children. Carbon dioxide enhances plant growth, but poses serious health risks to humans. High concentrations can displace oxygen in the air, resulting in oxygen deficiency, combined with effects of carbon dioxide toxicity. Grow operations contain high levels of humidity and are prone to buildup of various molds, which can damage human health, causing aggravating immunological diseases such as hay fever allergies, asthma, infections, and even cancer. The likelihood of a house fire is 24 times greater in a home with a grow operation compared to an ordinary household. Drug-endangered children are at greater risk of neglect, domestic violence, pre- and postnatal and alcohol abstinence syndrome, and sexual abuse. Grow operations are often linked to criminal activity and organized crime. The environment is also very high risk for physical assault, home invasions, gang violence, homicides. Increasing liberal attitudes toward marijuana has led to an increase in the number of child neglect and abuse cases that can be directly attributed to marijuana, according to Laurie Moriarty at the Stafford Conference. There is also a misnomer that this bill creates new criminals, when in fact all of the offenses dealt with are criminal, and our government is committed to dealing with the most reprehensible crimes in our society. 1. Protecting children from sexual predators. This point I find particularly positive considering the recent RCMP intelligence report, which states the availability of child sexual exploitation material for purchase over the internet remains a problem. Penalties for organized drug crime. Protecting the public from violent and repeat young offenders, and I emphasize violent and repeat. Preventing trafficking, abuse, and exploitation of vulnerable immigrants. Corrections Canada applauds the bill's efforts to address inmate accountability, responsibility, and management under the Corrections and Conditional Release Act, which protect and encourage inmates engaged in rehabilitation programming. On the topic of new prisons, initial projections of population increases from past legislation has not been realized. There's no link between new prisons and this legislation. New prisons are required to reflect the rehabilitative and corrective model essential to achieving objectives of help, hope, and healing of inmates. The opposition criticizes the new prisons, yet presses for more programming and single cells for inmates. They fail to realize the intrinsic link between the building of new correctional facilities with cleaner, safer environments with more room and controls in order to allow staff and inmates the best possible environment to engage in rehabilitative programs. The Yukon Corrections model is an excellent example of moving from a closed supervision model to a direct supervision model, which will be greatly enhanced with the move to their new correctional facility in 2012. When one considers the cost of correctional facilities and housing offenders, it must be remembered that the tangible cost of crime on victims is much higher, 80% of which is borne by the victims themselves. Mr. Speaker, the Canadian Bar Association stated this bill will do nothing to improve that state of affairs. Through its overreach and overreaction to imaginary problems, Bill C-10 could easily make it worse. It could eventually create the very problems it's supposed to solve. If there are imaginary problems, then we won't see the contradictory message they are suggesting of an increased prison population, as there won't be imaginary criminals, imaginary trials, and imaginary sentences that would have such a result. We do know, Mr. Speaker, that the problems are real. And I would invite the Canadian Bar Association to write to the community of Citadel, which was devastated when an illegal grow operation caught on fire and damaged 7 neighboring homes. Write to the province of Alberta, where the Alert organization dismantled 200 grow operations in Calgary, seizing nearly 70,000 plants. 151 of those grow operation locations were unfit for human habitation. In 2011, almost 46,000 plants worth $56.3 million has been taken off the streets of that province. Imaginary, Mr. Speaker? According to a Justice Department study, only 1 in every 6 individuals convicted of running a grow operation in BC, Alberta, and Ontario between 1997 and 2005 actually served time in prison. The killer of RCMP officer Dennis Stronquil, Lorianne Bell, an impulsive, drug-addicted alcoholic whose contempt for the courts and had shown little remorse for or her understanding for the impact of her crimes, according to National Parole Board records, but her hands were tied under the current legislation, and she was released after serving less than 7 years. Corporal Brian Auger, Stronquil's former partner, was not told of Bell's impending release. Nobody's ever spoken to me, he said. They should maybe talk to the people that were involved and get a better idea or understanding as to what the victim goes through. And Mr. Speaker, Bill C-10 will do just that and enshrine victim participation in parole board hearings and keep victims better informed about the behavior and handling of offenders. Perhaps the Canadian Bar Association and the NDP would like to reaffirm their position to Corporal Auger and Dennis Stronquil's family that our government is reacting to imaginary problems. Under this government, we have another 1,000 RCMP officers on the front line, and we have invested $400 million to help the provinces and territories recruit more police officers. The 9/11 attacks claimed 3,000 people, including Canadians. The 2002 Bali bombing attack was the deadliest attack in the history of Indonesia, and that killed Canadians as well. Were these imaginary problems? On a personal level, I have engaged youth in the communities to deliver teamwork, leadership, health, and anti-bullying workshops, which have engaged youth and community leaders and increased self-esteem in both the boys and girls who have participated. This demonstrates what we can do as individuals to raise a respectful, healthy, law-abiding community. So when we step outside the silos we create and see the bigger picture, beyond the body of legislation, our government is achieving the right balance between victim rights, crime prevention, and rehabilitation for a better Canada. Thank you, Mr. Speaker.
I see the government House Leader is rising on a point of order.
Yes, Mr. Speaker. In the last election, the Conservative Party received a mandate to take action with tougher sentences for child molesters, tougher sentences for drug dealers, and tougher sentences for organized criminals. All of those measures are included in Bill C-10, the bill the House is currently debating, which the government committed to passing within 100 sitting days. With that in mind, I must advise that agreement has not been reached under the provisions of Standing Order 78 sub 1 or 78-2 concerning the proceedings at report stage and third reading of Bill C-10, an act to enact the Justice for Victims of Terrorism Act and to amend the State Immunity Act, the Criminal Code, the Controlled Drugs and Substances Act, the Corrections and Conditional Release Act, the Youth Criminal Justice Act, the Immigration and Refugee Protection Act, and other acts. Under the provisions of Standing Order 78-3, I give notice that a Minister of the Crown will propose at the next sitting a motion to allot a specific number of days or hours for the consideration and disposal of proceedings at those stages. Thank you.
I see the honourable member for St. John's East is rising on the same point.
No, I'd like to seek unanimous consent, Mr. Speaker, to move the following motion that, notwithstanding any standing orders or usual practice of the House, the proceedings at report stage of Bill C-10, an act to enact the Justice for Victims of Terrorism Act and to amend the State Immunity Act, the Criminal Code, the Controlled Drugs and Substances Act, the Corrections and Conditional Release Act, the Youth Criminal Justice Act, and the Immigration and Refugee Protection Act and other acts be discharged, and that the bill be immediately referred back to the Standing Committee on Justice and Human Rights for the purpose of more fully conducting clause-by-clause consideration of the bill, and that it not be reported back to the House in fewer than 15 sitting days. Mr. Speaker, we're proposing this motion in order to ensure that this bill receives proper consideration. We saw at report stage this morning a half a dozen or more amendments by the government itself that were ruled out of order because they could have been, I think in the words of the Speaker, they could have been presented at committee. That's what the Speaker said in his ruling this morning. I think it seems pretty obvious that the government itself now recognizes that there wasn't sufficient time at committee to give consideration to proper amendments, that the bill is flawed, and that the way to resolve this is to send it back to committee. So I'm assuming that we will have unanimous consent. I'm assuming we can have unanimous consent from members opposite for this motion.
Is there unanimous consent to consider the motion? There is no consent. Questions and comments? The honourable questions and comments. Question and comment there. The honourable member for Thunder Bay Superior North.
Thanks very much, Mr. Speaker. Mr. Speaker, we heard a lot of words about how somehow prisons, spending on prisons is going to help children. it was a little lost on me. But I noticed an interesting story from the member from Winnipeg North about two wallets. It seems to me the Conservatives do have two wallets. They have a bulging wallet for about $3 billion a year in burgeoning prison costs, but there seems to be little or nothing in the wallet for school nutrition programs, dental care for children, early childhood education, child care, national child care program, and secondary elementary and post-secondary education. I'd like to ask if the honourable member, if he really does care about children, why is there no investment in that wallet?
The honourable member for Yukon.
Well, thank you, Mr. Speaker, and I thank the honourable colleague for the comments. I'm not sure that those all were directly related to the bill at hand, but let's talk a bit about that wallet that we are carrying. $577 million over 5 years through the strategy's prevention, treatment, and enforcement activities out of the health, our anti-drug strategy. Our health portfolio has invested millions of dollars. It's the one thing I commented in that speech, Mr. Speaker, about not operating in silos. When we look at our investments in education, health, sport and recreation, across all those pillars, our government is making exceptional investments in the people of our country. It's when we just look at the one bill, and if this were the only strategy we had for improving the lives of Canadians, I would agree that would be problematic. But it is one tool in a whole host of tools we're using to improve the lives of Canadians. And I do take exception, Mr. Speaker, to the fact that that member said that there was any link or I made any suggestion in my speech to how prisons were going to help children. Because nowhere in my speech did I mention that.
Comments? The honourable member for Winnipeg North.
Mr. Speaker, we recognize that we have provincial governments. We have many professionals across Canada who have expressed great concern in regards to Bill C-10. We have a chamber that has a third, I believe close to a third, of new members of Parliament. Yet we just had the government House Leader stand in this place and move yet another motion of time allocation, thereby preventing many members of Parliament, thereby for being able to speak on the bill and provide comment on the bill as to what their constituents might have to say, and so forth. Why is the government so focused on taking away the ability of MPs to contribute to the debate on Bill C-10, and why is the government so focused on ignoring the professionals across Canada and the many different provincial jurisdictions that say that this is a bad bill? Why are you doing it?
For Yukon.
Well, thank you, Mr. Speaker. And it's no wonder that that there are other organizations and jurisdictions concerned about this. And a large part of that has to do with a tremendous amount of misinformation and fear-mongering that's been done by the members opposite. It's been outstanding to hear the comparisons to a Texas model. They're warning people that we're going to be throwing 6-year-olds in jail over 2 marijuana plants growing in their basement. All kinds of misinformation going out there. What we're doing during this debate is correcting the record. And, Mr. Speaker, we've heard time and time again that many of these bills that are now combined into one to make it more efficient were already passed and presented were it not for an untimely election that we were thrust into courtesy of the Liberal Party that's now relegated to the backbenches. Thank you.
Questions and comments? The honourable member for Chilliwack, Fraser Canyon.
Well, thank you, Mr. Speaker, and it was a pleasure to listen to the member from Yukon. I appreciate his experience as former RCMP officer, and I just want to talk. I've met with correction officers who are very pleased with the provisions in this bill, as they will allow accountability for inmates who often before had no consequences for their activities in correctional facilities. So maybe he could address the positive measures in this bill that correction officers can use and the correctional system can use to ensure that inmates are accountable for the activities when they are in prison.
Yukon, a short response, please.
Well, I thank my honourable colleague for that. And having been a deputy superintendent of operations at a correctional facility in the Yukon, I can say that when inmates have a plan and that plan is worked with case managers and they have goals and objectives, we can find correctional environments to be a place of help, hope, and healing. recidivism programs, opportunity and time for them to work on things that have brought their criminality to the point where they're in jail is a very important location for them to do that. And Mr. Speaker, the investment in new facilities, clean environments, safe places where staff and inmates can interact together are very important to close that gap so that we actually can work on those recidivism programs and truly reduce crime in this country.
Before I recognize, it's resuming debate, by the way, but before I recognize the member for Halifax, I'll have to let her know we've only got about 3 to 4 minutes, but we'll get started just the same, and I'll give her an indication when there's 1 minute remaining, and then we'll have to go to the next order of business. The honourable member for Halifax.
Thank you, Mr. Speaker. I'm disappointed by that timing, but I will be back tomorrow, hopefully, to finish my speech because it's really important for me to get on the record about this bill. I've been thinking about the Omnibus Crime Bill a lot, and it comes to mind whenever I have a moment to think, like on the plane from Ottawa to Halifax or on the walk to the office. And last week, in fact, in church, because last Sunday, November 20th, at the Cornwallis Street African United Baptist Church, together with community members and descendants, Reverend Rhonda Britton and Dalhousie President Tom Travis, we celebrated not only the life but the legacy of James Robinson Johnston, the legacy that he left for Nova Scotia and for all of Canada. And it was at this commemorative service that I started to think differently about C10, and I'd like to explain that. James Robinson Johnston enrolled at Dalhousie University at the age of 16. He received his Bachelor of Letters degree in 1896 and his Bachelor of Law in 1898. And he was the first member of Nova Scotia's black community to graduate from university and then also from law. And he blazed a path for many to follow. His work in the African Nova Scotian community made a profound impact on the progress of African Nova Scotian communities today. In 1991, a James Robinson Johnston Chair in Black Canadian Studies was established at Dalhousie University to commemorate and deepen the link between the African Nova Scotian community and the academic study that takes place at universities. So that Sunday, last Sunday, at the Cornwallis Street Church in my community, we not only remembered James Robinson Johnston, but we also had the opportunity to welcome the new JRJ Chair in Black Canadian Studies, Dr. Afua Cooper. And in her address, Dr. Cooper noted that James Robinson Johnston, along with many members of our African Nova Scotian communities, was a descendant of the 2,000 black refugees that fled the United States after the War of 1812 and settled in Nova Scotia. The War of 1812. And that caught my attention, and it made me stop and think about this government's recent decision to commemorate the War of 1812 and spending millions of dollars to do so. And it made me stop and think about how our government is spending millions of dollars to commemorate a moment in history when free slaves came to Canada, and how we are at the same time debating a bill in the House that will see thousands more Canadians in our jail added to a prison population that is already disproportionately African Canadian. I was sitting there thinking about this, Mr. Speaker, trying to figure out if it was ironic or if it was just plain shameful. And a young woman named Elle Jones stood up, and she took the stage. She is an amazing spoken word artist. I've seen her perform many pieces about the realities of our community, and her performances are always thoughtful, provocative, and truthful. And in her piece about James Robinson Johnston, she said one line that crystallized what I was thinking about. In describing some of the needs of the black communities in Canada, she said, "Because we need black lawyers and judges to advocate for us, reforming the courts where we are disproportionately jailed." That's it, Mr. Speaker. We have failed to apply a racial lens to these bills. My NDP colleague from Edmonton Strathcona eloquently spelled out the potential impacts of this bill on First Nations, Inuit, and Métis people earlier this afternoon, and she's exactly right. Because who is our system failing? All you need to do is look in our prisons, Mr. Speaker, and you will see who our system fails. And I look forward to the next opportunity in this House to finish my speech. Thank you, Mr. Speaker.
The honourable member for Halifax will have 6 minutes remaining and 5 minutes for questions and comments when the House next returns to debate on this motion. And now, it being 5:30, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private
members' business, second reading of Bill C-316, an act to amend the Employment Insurance Act, incarceration, standing in the name of Mr. Harris, Caribou, Prince George.
Mr. Harris, Caribou, Prince George, seconded by Mr. Cramp. Prince Edward Hastings moves that Bill C-316, an act to amend the Employment Insurance Act, incarceration, be now read a second time and referred to the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities. Debate. The Honourable Member for Caribou, Prince George.
Thank you, Mr. Speaker. Mr. Speaker, I'm really, really pleased to move the Bill C-316, an act to amend the Employment Insurance Act referring to incarceration. Mr. Speaker, simply put, this bill will ensure that a convicted criminal will not have preferential access to EI insurance benefits compared to law-abiding Canadians. This bill would remove the extension to the qualifying period and the benefit period under the Employment Insurance Program that is currently equal to a time a convict spends in prison. As we speak, Mr. Speaker, convicted felons, inmates, have the ability to extend their qualifying and benefit periods up to a maximum period of 104 weeks, as opposed to 52 weeks for a law-abiding citizen who is out of work. People out there don't know that, Mr. Speaker. This is a section of the EI Act that must be changed. Given these extensions are not available to a law-abiding claimant who is actively looking for work, Madam Speaker, this is simply not fair. The bill as written, Bill 316, removes the extension of the qualification and benefit period for the time someone spends in jail. The Minister of Human Resources and Skills Development has indicated that the government would like to move two friendly amendments, and I certainly support these amendments. The first one is to ensure that my bill will only remove the extension of qualification and the benefit periods for individuals who have actually been convicted of a crime and are in jail. This will ensure, and my friends across the way, this will ensure that individuals held in pretrial custody but who are subsequently found innocent will not be affected by this bill. The second amendment is that the bill will have it coming into force on a Sunday. This will align the implementation date of this bill with the employment insurance calendar, which works in a 2-week increment starting on a Sunday. Mr. Speaker, let me reflect quickly on how the current employment insurance system works and what motivated me to move this bill. Currently, when an individual applies for employment insurance, they are evaluated as to whether or not they have worked enough hours in their qualifying period to receive benefits. The standard qualifying period being 52 weeks in length. The qualifying period can only be extended under 4 circumstances under the Act and can only be extended to a maximum of 104 weeks. I'll read them quickly to explain some context as to why I feel the exemption related to prison must be removed. The first extension for being incapable of work is because of prescribed illness, injury, quarantine, or pregnancy. The second extension is being confined in jail, a penitentiary, or a similar institution. The third applies if you receive some assistance under employment benefits, such as a plan from your previous employer. And the fourth relates to receiving payments under a provincial law that on the basis of having ceased to work because continuing to work could result in danger to an unborn child or a child for whom a woman might be breastfeeding. It is the second provision related to jail that I'm seeking to amend because it relates to circumstances under the control of the individual themselves. Let me provide an example of how this exemption works. Under our current legislation, a convicted criminal could be in jail for 1 year, come out of jail, apply for EI, and the hours worked in the last 2 years would be considered to qualify for employment insurance. A law-abiding citizen who applied at the same time would only be able to count the hours worked in the last year. In other words, a convicted criminal who spent a year in jail would have 104 weeks to apply a 52-week qualification period. It would be as if the prison time simply didn't count, but a person who took a year off for family reasons or to pursue some other interest would only have a 52-week period. This is not fair. Similar situation can occur with the benefits period. Typically, an individual can only receive employment insurance benefits for regular benefits for 52 weeks from the date of applying. Again, there's an exemption, one of which is being in jail or prison, like I just mentioned. It would allow someone coming out of prison to have an extension of 104 weeks in which they could take their employment benefits. So the 52 weeks they spend in jail would be as if it didn't happen and they're starting on their 52 weeks. This is not fair. It's particularly unfair because any EI benefits, regular benefits that a law-abiding citizen apply for but does not take within 52 weeks of filing an EI claim, disappears once that 52-week period expires. This is in contrast to a convicted felon, as I said, who can collect their benefits up to 104 weeks after making a claim, depending on how long they spend in prison. Mr. Speaker, Madam Speaker, this is all in contrast to a law-abiding citizen who started receiving the same length of benefits at the time of the convicted criminal. They would have lost their benefits. The convicted criminal would have retained their benefits because of the fact they'd been in prison. It's just not fair, Mr. Speaker. As a matter of fact, it is simply unfair. There should not be a preferential access to employment insurance benefits because someone is convicted of committing a crime. Madam Speaker, this is something they made a choice to commit the crime. Why should they receive preferential treatment over someone who is a law-abiding citizen who made a choice to take time off and as a result of that would lose their benefit period? It's simply not fair. If someone is unable to work because they're sick, Madam Speaker, that is one matter. It's another matter entirely if someone has greater access because they were convicted of a crime. And that's the basis of this bill, because that individual, Madam Speaker, made a choice to break the law. To be clear, Madam Speaker, this is not about punishing criminals further. Our justice legislation has been clear about what we feel the punishment for crime should be, and thanks to a strong, stable, national, conservative majority government, what the punishment will be. This bill, Madam Speaker, is about ensuring that convicted felons are forced to live by the same rule as law-abiding citizens. What Canadian could agree that a convicted felon should have preferential treatment in regards to employment insurance benefits? I don't think any right-thinking Canadian could actually support that for a second. Madam Speaker, if someone chooses to break the law and they lose their job because of it, it is no different than someone being fired for just cause because they made a choice to act in a way that ended their employment, whether they committed a crime and went to jail or whether they committed some other offense on their job that caused them to be fired. They made a choice, Madam Speaker, and they should not receive preferential benefits, EI benefits, that a hard-working, law-abiding Canadian who loses their job through no fault of their own makes. It should not happen, and that's the purpose of this bill, Madam Speaker. This bill is about fundamental fairness when it comes to accessing employment insurance benefit. And let me say it this time, Madam Speaker. Our country, Canada, has probably the most generous and most helpful in employment insurance and employment programs than any other country in the world. And one only has to look at the last couple of years when we've been through this terrible recession. The bills that we brought in, the extended work benefits, benefits bills, the job sharing, the work sharing bills, the job sharing bills, and we did everything we could, something that is unheard in most other countries. But this government believes about fairness, and we were being fair to the people that work in this country and are law-abiding. How much time do I have, Madam Speaker? Madam Speaker, as I said here before, the issue is about fairness. And I ask the question, should a convicted felon, an individual found guilty to have willfully committed a criminal act, be given preferential treatment, preferential access to employment insurance benefits simply because they were confined in a jail? Madam Speaker, I can tell you the members on this side of the House say a resounding no. That should not happen. And I think, as I said, that any clear-thinking Canadian would come up with the same response: no. Therefore, Madam Speaker, I ask my colleagues in this place to support this bill in principle and to support it passing at the second reading, because it's the right thing to do. Who can argue, who in this House can successfully argue that someone that has committed a crime, willfully committed a crime and gone to jail, should all of a sudden be eligible for preferential treatment under the EI program? Who can successfully argue that? Madam Speaker, I suggest no one can. I'm kind of afraid that given the NDP soft on crime ideology, that there will be some sort of arguments there, which it's beyond me how they will be able to justify that. But Madam Speaker, I'm sure that the people watching this program tonight at home are thinking, I never knew that. I never knew that if someone gets put in jail because they committed a crime, would have preferential treatment. How could that possibly happen? Well, it happened years ago when the Employment Insurance Act was written. I don't know what government it was under, but somehow it got put in there that allowed for this. Madam Speaker, I ask my colleagues in this place to support this bill at second reading. It's a good bill. It's a bill that needs to be passed to clean up that portion of the Act that is simply not fair. And Madam Speaker, I think that our government has clearly shown that we care about people that have trouble with their jobs. We care about people that go through some hard times because they lose their jobs, because of the expanded access that we have provided to Canadians that have found themselves in that position. And it's only right for a caring government to do that. And this government does care about working Canadians. We care about their families. We care about their ability to provide for their families through their jobs. And we'll always be there for Canadians, Madam Speaker. But we must not allow someone who willfully puts himself in a position that they're convicted of a crime and goes to jail, or willfully does something to get fired from their job for just cause. We cannot allow them to have a preferential treatment over someone who's a hardworking Canadian that loses their job through no fault of their own. And Madam Speaker, I would be just so happy to answer any questions that my colleagues may have. Thank you, Madam Speaker.
And comments.
The Honourable Member for Jonquière, Allemand. Thank you, Madam Speaker. My question for my colleague is how it will be managed if somebody is in preventive custody or somebody who is detained and the person will only have 52 weeks to qualify for the benefits, but it could go over that.
Well, Madam Speaker, I thought it was quite clear about who this bill was targeting. It was targeting individuals who had committed a crime and were convicted and sent to jail. Someone who is in preventive custody is not that same person. And that's the difference. Someone who is arrested for a crime and detained until trial, and if they're subsequently go to court and are found innocent of that crime, it doesn't affect them. Someone who is in an institution for health reasons, but not in jail, not a prison, it wouldn't apply to them. So, Madam Speaker, I thought I was quite clear about that, but I can assure the honourable member there that this is specifically targeted to convicted felons who are in jail that are now receiving preferential EI treatment because they went to jail.
Questions and comments. The honourable member for Winnipeg North.
Yeah, Madam Speaker, I'd like to get a little bit more clarity on that particular issue, and maybe the best way to do that is to give a tangible example. If an individual, John Doe, is collecting unemployment benefits today, and for whatever reasons he is put in or remanded into custody, and it takes 2 or 3 months to ultimately go to trial, but he's held in custody, what happens to the check? Does he continue to receive the checks until he goes to trial and the determination is made? What specifically happens to the check? Because there might be other financial responsibilities for that individual that is, for all intents and purposes, innocent until proven guilty. Financial responsibilities that could include children, spouse, parents, or whatever it means, whatever it might be. So can you just provide 100% clarity as to, does the person continue to receive unemployment benefits if, in fact, they're held in custody?
The honourable member for Caribou Prince George.
Thank you, Madam Speaker. I thought I just dealt with a situation like that. If someone is being held in custody pending trial, they are not yet a convicted felon. Therefore, it would not apply to them. So I really want, and that's why the government put these friendly amendments forward, which I support, was to take care of a situation like that. So, Madam Speaker, it has to be clear, and I'll say it again. This getting rid of this extension, this preferential treatment, applies only to someone who is a convicted felon that goes to jail.
Questions and comments. The honourable member for Kildonan St. Paul's. There's a minute or so left, so a brief question.
Thank you, Madam Speaker, and I applaud my colleague for this very important bill. And I'm just wondering, could he tell the House, please, why you are so passionate about this particular bill and this issue?
The honourable member for Caribou Prince George.
Well, Madam Speaker, it's not hard to get passionate about fairness, or passionate about correcting an unfairness, which is the case now. As I pointed out earlier, this is about someone who willfully commits a crime, goes to court, convicted, sent to jail, having preferential EI benefit treatment, as opposed to someone who works very hard, providing for their families, is a law-abiding Canadian. For reasons of their own, they want to take some time off to spend more time with their family or to pursue another interest. If a law-abiding Canadian does that, they don't have the same treatment that is someone that's been in jail. I mean, they lose their benefits for that period. Someone who's in jail, it's like it's like a period in time never happened. They're eligible immediately.
Resuming debate.
Resuming debate, the honourable member for Jonquière Alma. Thank you, Madam Speaker. Today, I want to express my indignation regarding Bill C-316. I strongly recommend my colleagues from all parties vote against this absurd and useless bill. As you know, People are quite cynical about the political work that we are trying to do, and this cynicism is growing every day. This bill just adds to the problem. According to the twisted logic of the Conservatives, if people who are in custody have a privilege that pregnant women don't, then that right should be taken away instead of extending it to pregnant women. So people will understand this, and they will severely judge those who vote in favor of this bill. We have to look at why people who are in custody for less than a year have a right to extend their qualifying period. It is because during this period, which is the weeks during which one acquires the right to employment insurance benefits, which is normally 52 weeks, the person is then eligible for benefits for a period of up to 52 weeks. That doesn't mean a full 52 weeks, but they have to be taken within those 52 weeks. The Conservative member is simplifying the facts, but is not really talking about the reality. He gives the impression that prisoners receive benefits while they are in prison, and that's not true. People who can take advantage of this exception are those who have worked enough to obtain benefits, and they deserve to get them when they get out of prison. This bill will amend the Employment Insurance Act by removing the extension to the qualifying period and the benefit period of those who are in a prison, a detox center, or another similar institution. The Conservatives would like to abolish an exception that encourages former inmates from getting back into the workforce and becoming more confident again and getting training, for example. The Conservatives and all those who might support this pointless bill should not be proud of doing so, because the issue is not equality of Canadians or favorable treatment, as it's being called, of prisoners, but rather changes to an unjust bill that would help women who are on maternity leave. This government is incompetent in this area, and yet they say they are defending family values. They are blinded by their obsession for law and order, and we absolutely have to prevent them from jeopardizing the future of thousands of citizens. The Conservatives seem to be making political capital on the backs of offenders with their various bills, and they are ever more arbitrary. Their approach doesn't leave any chance for rehabilitation and for those who deserve a second chance. In Canada, the figures show that our rehabilitation system works quite well and crime is going down. The member for Caribou Prince George does not want to admit this, but helping people actually works well. Our system may be imperfect, but it is well-intentioned. Many of those who have been in prison have difficulty getting work after they get out, and often the incarceration has a long-term negative impact on their income. Someone who serves less than a year is usually someone with their first sentence, and they deserve a second chance. Often people who get out of prison are unemployed, and they have jobs that pay less well than before they went in. So extending the qualifying period and benefits can be helpful to them and their family. However, somebody who is in for more than a year will not be able to receive the benefits when they get out. So someone who is in prison for less than a year might be able to qualify because of hours worked before, and therefore might be able to extend their qualifying period. It should also be noted that those suspected of committing a crime may be held pending the outcome of their trial, and therefore an innocent person might be incarcerated while waiting for a verdict that may exonerate them. Under this bill, a person accused of a crime that he or she has not committed may be without the employment insurance benefits when they get out. So we're talking about innocent people in that case. The solution to the inequalities in the employment insurance program is not to abolish the exception for people in detention, but rather making changes for regular and special benefits. The Act should enable new mothers and other workers who have lost their jobs to benefit from the system when they need it. So we should extend the benefits rather than take them away from these people. Why eliminate this exception? Why not extend it to other people? I would add that in the 2011 election platform, the NDP made a commitment to guarantee parents who had taken maternity or parental leave that they would not be penalized. The Minister of Human Resources and Skills Development has acknowledged that there is a problem with the interpretation of the Employment Insurance Act for women on maternity leave and other types of benefits. So we need to rectify that situation. That is unfair. Therefore, colleagues, we should not support this absurd and mean-spirited legislation which is not in line with the values of Canadians who elected us. Why is this government penalizing people rather than supporting them? We should concentrate on the real priorities of Canadian families, which are employment, health care, and the rights of workers. So we should vote against Bill C-316. So just to be clear, somebody who is in prison for more than 1 year has no right to employment insurance benefits, rather. I think that 98% of women, if I have the figure right, are there for reasons associated with their poverty. So therefore, the NDP intends to vote against Bill C-316.
The honourable member for Cape Breton Council.
Thank you very much, Madam Speaker, and I'm looking forward to joining in on this particular debate. I'm in a little bit late, and I didn't get the entire speech of the presenter, and he had made reference to a couple of friendly amendments that I haven't had an opportunity to see yet being proposed by the government, but I'll look at seeing what kind of impact they have on the overall legislation. But I come here with a little bit of skepticism. This particular bill impacts on so few cases, so few instances. It doesn't have any far-reaching impact whatsoever, really. Not in the broader scheme of things. Certainly on the individuals that it would impact. It would have certainly a negative impact on those. But during the course of my friends, and he's a longtime member of the chamber here and a very eloquent orator for sure, but I was given the impression during the course of his speech when he spoke and said, I wouldn't think people would support people in prison receiving EI benefits. Well, know full well that currently they don't receive EI benefits, and that's not what this legislation is all about. This piece of legislation is talking about eligibility. So, I want to make sure that we're debating exactly what's being put forward here. And we know that as far as the jurisdictional split, it's the 2-year split where if you're going to prison for longer than 2 years, it's going to be served in a federal institution, whereas under 2 years, it would be served in a provincial institution. And the current EI extension clause only benefits individuals who spend less than 2 years in jail. So those serving federal time in federal institutions it wouldn't impact on them. The current legislation doesn't impact on them. Current EI extension clause, for the most part, only deals with individuals who are being released from non-federal prisons, those that are serving time in provincial jurisdiction. We also know, when we look at these are 2008, 2009 numbers, Madam Speaker. They're the best numbers that we had access to. But so there's 30,000. To set the table that the two opposition parties are soft on crime, I think there's probably a little bit more in the messaging than that's the skeptic in me, maybe thinking that way. That there's a little bit more in the messaging in this particular piece of private members legislation than what's fact. But 37,000 inmates in federal prisons right now. Of course, that number is going to go up considerably in the next number of years, even with the decrease in the crime rates in this country. There are 24,000 in the various provincial institutions across the country, and 56% of those would be on remand. So they're not convicted criminals. 56% are on remand, and remand being, waiting for trial, some waiting for sentencing, but in many cases, charges are dropped. Persons are found innocent. We see a number of different variations of this, but the vast majority are people waiting for trial. And of course, under the rules and the laws of this nation, those people are considered innocent until proven guilty. This bill would disadvantage those people that are waiting for trial. 3 out of 10 cases are resolved by being stayed, withdrawn, or dismissed. 3 out of 10 trials. Another 3% of the cases will result in acquittal of the accused, and 1% of the cases would have other decisions. So really, there's 33% of those cases that would not result in a guilty verdict, Madam Speaker. Some individuals charged with an offense, they can make bail. Some can't. Some are remanded because they can't make bail. So, they're forced in. They may be certainly innocent and waiting for an opportunity to prove their innocence, but because they don't have access because of their socioeconomic situation, they're unable to post bail, so they find themselves in a situation where they're incarcerated. And this bill disadvantages those particular people. Madam Speaker, I think we've seen on the omnibus justice bill that has been put through this House, what we've seen is that the approach to justice issues, we're stepping back as a nation. We see the decrease in crime rates in this country, but we see a propensity by this government that they're wanting to grow the number of prison cells, put people behind bars for longer periods of time. And we've seen that model unfold in Texas, in California. California is, for the most part, a bankrupt state right now because of their approach to these justice issues. We see Texas, and some of the leading judicial minds in Texas are saying, Canada, don't do that. We've been there. We've done that. We've got the T-shirt. We've got the debt, the state debt, to prove that that's not the way to go. The rates of recidivism, how about that? Certainly haven't gone down. We see repeat offenders. Once they get into an institution and they're put behind bars, they become professional criminals, and that's the experience that we've received south of the border. That's what we've learned with the approach to dealing with crime south of the border. Madam Speaker, a lot of these people, they come from fractured homes. They are dealing with mental health issues, addiction issues. Number one, I think, if they are behind bars, then I think it's in our best interest as law-abiding citizens that we try to do something to help them through this. We try to help through education. We try to help through allowing them to grow as a person, understand where they went wrong. But when they come out, the single best thing that could happen to that person once they come out, once they, hopefully they come out a better person and a more understanding person, and they with a willingness and a want to be a better citizen. But if we throw them out of jail and put them on their own without any great hope for employment, with any great hope for income, then we're doing them a huge disadvantage. And I like the way the law works now. It makes sense the way the law works now. And simply what it is, if you open up an EI claim and you receive, let's say you're eligible for 48 weeks of employment insurance, and 2 weeks into that claim where you have 46 weeks left and you go to jail, well, you don't receive benefits while you're in jail. That single mom that's trying to care for her kids and maybe has a delinquent husband that doesn't provide for them, and she gets caught stealing, and she does, name the scenario. But when she comes out of that institution, she's going to be cast back into poverty. But if she's able to, after that 6 months in jail, able to pick up that next 48 or 46 weeks of employment insurance, then I think, as a nation, I think as Canadians, we've done her a great service. And folks, it's not like winning the 649. EI benefits, I know that they've referred to, Madam Speaker, they've referred to EI benefits as very generous. They aren't very generous. The scope of this bill, the number of people that it impacts on, it's not great. It's not a huge number. But to give these people, after they come out of incarceration, to give them a chance so that they don't return to a life of crime, so that their families don't have to live in poverty. I think the way the laws stand now makes sense and work. I'll look at the amendments that are being put forward, the friendly amendments that are being put forward by the government, but right now I think that the way that the rules stand, I think serve all Canadians well. Thank you, Madam Speaker.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Human Resources.
Madam Speaker, I rise before the House today to support Bill C-316, an act to amend the Employment Insurance Act, incarceration, presented by my colleague from the riding of Caribou, Prince George, and I want to commend this member for all of his hard work on this bill. I can also indicate that our caucus will be supporting Bill C-316 with two friendly amendments. The first amendment will narrow the scope of the bill to remove the extended qualifications and benefits period to those convicted of a crime. And the second amendment will create a coming into force date on a Sunday to synchronize the bill with the typical administration of the employment insurance benefits. As previously mentioned by the member from Caribou, Prince George, he has indicated he supports these amendments. Madam Speaker, I'm pleased to support Bill C-316 because the bill addresses something that is fundamentally unfair. Namely, that convicted criminals currently have preferential access to employment insurance benefits over law-abiding citizens. To properly understand the inequity of Bill C-316, we need to look at the context. Under the Employment Insurance Act, prisoners cannot collect EI benefits while incarcerated. Therefore, this bill only addresses employment insurance benefits granted after an individual leaves prison. The purpose of the employment insurance program is to provide temporary income to replace lost employment income while claimants are looking for work. La régime vient aussi en aide.
The system also helps a worker who's ill or a parent looking after a newborn or an adopted child, or someone looking after a seriously ill loved one.
As unavailable for work due to circumstances beyond the individual's control. When an individual applies for benefits, there are two key time periods, the qualifying period and the benefits period. The qualifying period is a period in which an individual must have worked a minimum number of hours in order to qualify for a benefit under the program. The benefit period is the period of time during which a claimant may collect the benefits for which they have qualified. No benefits can be taken past the end of the benefits period. To make things simple, the benefits period can be thought of as a cutoff date in which all benefits can be taken before, or else they will be lost. In most cases, both the qualifying and benefit periods are set at 52 weeks. There are, however, exceptions to the 52-week limit. These allow for the extension of the qualifying period and the benefits periods for up to 104 weeks if an individual is on sickness leave or workers' compensation. Currently, there are also extensions of both periods by the time an individual spends in prison, jail, or in similar institutions. The member for Caribou Prince George has already gone into some depth about those exemptions and has demonstrated how these benefits predominantly are related to situations out of the control of the individual. This bill deals only with the extensions of the qualifying period and the benefits period for individuals in a prison, jail, or a similar institution. Currently, the existing extensions ensure that convicted criminals who serve less than 52 weeks in jail merely have their full 52 weeks of qualifying and benefits period interrupted with no repercussions because of their jail sentence. This potentially allows them twice the period of time to collect benefits or to count hours of work to qualify for benefits as a law-abiding citizen. Les dispositions.
The provisions of the Act create a cleavage. They create a benefit for the majority at the expense, for the minority rather, at the expense of the majority.
And as a result, increase the cost of the program to hardworking Canadians. To be clear, we are all in agreement on the extensions individuals should be granted for life circumstances beyond their control, such as illness or injury. But this is not the case with crime. To be convicted of a crime, an individual made a choice to commit that criminal act. This choice is within the control of the individual.
Why should inmates have a privilege that the general population is not entitled to? For law-abiding Canadians, this makes no sense.
The importance of providing former inmates with every opportunity to reintegrate into society. Correctional Services Canada already offers a number of programs to inmates during their incarcerations aimed at helping them reintegrate into society, providing them with employment training, and helping them to acquire the skills they need to improve their employability. Correctional Services also offers employment services which help prisoners find a job once they are released. And finally, Correctional Services works in partnerships with community colleges and industrial organizations to offer a large array of certification programs and works with recognized employers and industry associations.
These measures contribute to putting people back on the right path.
To expect that their government is just and fair when defining and adopting laws that govern our lives. It is a fundamental principle of democracy. This bill ensures that convicted criminals have to play by the same rules as law-abiding citizens. If their EI benefits lapse because they are in jail, that is not the responsibility of Canadian taxpayers to fix. It is the responsibility of the guilty party for making the choice to commit a criminal offence.
It's a matter of fairness and equity.
Resuming debate. The honourable member for seeing no one rise. The honourable member for Caribou Prince George for his right of reply.
Thank you, thank you, Madam Speaker, and I want to thank my colleague for the explanation that she gave regarding this bill. Madam Speaker, as I mentioned earlier, this bill is about it's about fairness. It's about removing a preferential benefit that's applied under the EI Act right now to someone who spent some time in prison, a year or less, that allows them to have an extended benefit after they come out, an extended benefit that isn't offered to a law-abiding citizen who, for no reason of their own, lose their jobs and doesn't have that extension, or make a choice to take time off work and cannot get that extension. Madam Speaker, there was some concern from my honourable colleague across the way about someone who comes out of incarceration losing this sort of a leg up, losing the money that EI would provide to them under this preferential treatment. The fact is, Madam Speaker, as my colleague pointed out, there are a myriad of benefits that are of help that's offered through the correction system, both federal, through halfway houses, through organizations that help people that come out of incarceration to help them get them jobs and back into society. But this bill is, those are available, but this bill is not about that. It's about removing a preferential EI benefit provision that applies to someone who's committed a crime, been incarcerated for a year or less, that does not apply to an average hardworking Canadian that takes time off their job through their own because they wanted some time to pursue another interest. They lose that benefit period. Someone that goes to jail doesn't lose it. That's unfair. We want to remove that from the Act. And I thank my colleague again for the support, and I ask my colleagues across the way to gain a real understanding of this bill and the unfairness that piece that we want to take out of the Act, what it means, and how it's an unfair provision. Thank you, Madam Speaker.
Is the House ready for the question? La question est la suivante.
The question is as follows.
George, seconded by Mr. Crabb, Prince Edward Hastings, that Bill C-316, an act to amend the Employment Insurance Act, incarceration, be now read a second time and referred to the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disability.
Is it the pleasure of the House to adopt this motion?
All those who support this motion, please say yay. Yay!
All those who oppose this motion, please say nay.
In my opinion, the nays have it. Pursuant then to Standing Order 93, the division stands deferred until Wednesday, November 30th, 2011, immediately before the time provided for private members' business. Okay. The Honourable Member for Ancaster, Dundas, Flamborough and Westdale.
Thank you. Seeking unanimous consent to see the clock at 6:30.
Is it agreed?
Agreed.
Yeah. Agreed. Agreed. Allowed.
Order.
Order. In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The Honourable
Member for Beauharnois-Salaberry. Thank you, Madam Speaker. So I would like to say that Canada missed an important opportunity to act positively on the international stage during the World Conference on the Social Determinants of Health. This took place in Brazil from October 19th to 21st of this year. The Minister of Health did not feel it was a good idea to participate in this event, where 118 countries met to develop an action plan. And yet, in Canada, 20% of healthcare expenditures are related to social issues, such as homelessness and unemployment. When I asked the minister to explain why she was not participating in this crucial meeting, she was not able to explain the reasons why she was not doing so. And in the end, she answered that she had participated in other international conferences. Clearly, the minister was not aware of this conference on the social determinants of health, or this is not part of the Conservative government's priorities, because they showed no leadership at all in this matter. And yet, Madam Speaker, allow me to explain to you why this meeting should have been a priority for Canada. First, according to the World Health Organization, social determinants of health are, and I quote, circumstances in which people are born, grow up, live, work, and age, as well as the systems implemented to deal with illness. These circumstances that reflect political choices depend on the distribution of power, money, and resources at all levels, that is, local, national, and global. These social determinants represent one of the main causes of disparities in health, gaps that are unfair and that can be avoided between different countries in the world. Canada, which is part of the G8 countries, should have been concerned by this issue and should have participated in this meeting. As far as I know, here in Canada, people are still suffering from poverty, social exclusion, stress, unemployment problems, homelessness, and food problems, which are just some of the factors among the major social determinants. Here's some direct impacts of these factors on health. According to a study conducted in 2003 by Wilkinson and Marmot, who participate in the WHO, it is homeless people who are at the highest risk of dying early. This is very current because we held the 22nd edition of the Homeless Nights in Quebec on October 21st. Did you know that it costs $24,000 to the current health system, according to, to the Quebec health system, to care for a homeless person, whereas if community services received adequate funding to fight homelessness, it would cost half that much to the federal government. So this is a strategic choice, it would seem to me. In 2004, the Canadian Child Health Institute said that the lower the household income, the more problems with children. As a teacher who worked in underprivileged areas, I can tell you that children who do not have a safe and stable environment are more affected by learning difficulties and behavioral problems. And there are many studies that prove this. More recently, numerous health experts who came to testify before the Standing Committee on Health agreed that elderly people who live in an isolated area are more likely to develop mental health problems. They also stated that the low income of seniors did not allow them to buy fruit and vegetables, and those are basic staples of our diet, and that causes many problems. So these are some examples. Every day on the world stage, there are 21,000 children who die before their 5th birthday. So these are all alarming figures from the WHO, and health should be a priority. And so why was the Canadian government not in Brazil?
Secretary to the Minister of Health.
Thank you very much, Madam Speaker. And of course, I disagree with the premise of the members' statements here in the House. But I do appreciate the opportunity to respond to a question here this evening. Canada actually played an important leadership role at the World Conference on Social Determinants of Health. La délégation était dirigée.
The delegation was led by Dr. David Butler-Jones, who is the Chief Administrator of the Public Health Agency.
An opportunity to work with Canadian and international partners to identify actions that can be taken on these challenges. Over 1,000 attendees representing more than 125 World Health Organization member states participated in the Rio Conference. It brought together Canadian and international partners to develop strategies for reducing health inequalities internationally, share experiences and knowledge, and build on existing initiatives. The major conference outcome was the Rio Political Declaration on Social Determinants of Health, which was supported by all member states, including Canada. Why is this declaration important? It signaled that countries supporting the declaration are on the same page, understanding the need to look at whole-of-government collective solutions. Madame le Président, le gouvernement...
Madam Speaker, the Government of Canada intends to continue to work with these organizations after the Rio Conference. Canada has already put relevant measures in place. According to the recent investment announcement in 11 new research programs to improve fairness in the area of health.
Conference Group on Social Determinants of Health, a unique group of NGO and academic leaders in the field of environment, labor, social development, and business to help build momentum for efforts at the local level. Madam Speaker, global action is making a difference. I'd like to take a moment to highlight an important meeting the Minister attended in September in New York. She attended a conference on non-communicable diseases. The Minister signed the UN Declaration on Preventing and Controlling Chronic Diseases. This important declaration addresses the growing threat of chronic diseases around the world. Countries agreed that they must take effective action to reduce their risk factors. That's why our government has taken action on many things, for example, to reduce tobacco use and promote healthy living. We also make significant investments in all of Canada's disease-specific strategies. This includes the Canadian Partnership Against Cancer, the Canadian Diabetes Strategy, the Aboriginal Diabetes Initiative, and the National Lung Health Program, and the Canadian Heart Health Strategy and Action Plan. Madam Speaker, our government's participation at these international conferences are important. They not only help to improve the health of the people in Canada, but they also help improve the health of the people around the world. And Canada will continue to be a leader in the world at these conferences. Thank you very much, Madam Speaker.
The Honourable Member for Beauharnois-Salaberry. Thank you, Madam Speaker. And so, yes, indeed, there was a participation in the meeting in New York, but the Minister of Health was in the room during the Rio conference, and she did not appear at all to be aware of this conference. And given that she was unable to respond to my question, and she diverted the question to another topic, and so if the government's priorities were really to act on social determinants of health, which create inequalities, then the minister would have been absent at this meeting, and the parliamentary secretary would have taken the question instead. So to say that it is important, well, that's all very well, but we need to act as well. We need to walk the talk. And so there are still 20% of health that is attributable to social determinants. So we have to look, for example, at social housing as well.
Madam Speaker, our government has been working very hard on the social determinants of health. The problem is every time we bring things forward to improve the situation, the NDP constantly votes against it. La Conférence Mondiale,
the World Conference on the Social Determinants of Health, which took place in Rio, was an important opportunity for the member states of the World Health Organization.
Mental organizations, stakeholders, academics, and other UN agencies. The conference involved a discussion on strategies and action for reducing health inequities at the national and the international level. It also provided a unique venue to work with Canadian and international partners to identify actions that can be taken to address the underlying environmental, social, and economic conditions that affect health and well-being of Canadians. Dr. David Butler-Jones, Canada's Chief Public Health Officer, had the opportunity to highlight the significant steps Canada has taken in addressing social determinants. Our government's commitment to this issue is underscored by Minister Gluka's recent announcement. Canada recognizes the complex causes of health inequalities among Indigenous populations. The Canada HoC.
Canada also emphasized that it will continue to work with all parties to develop, test, and...
Order, please. The Honourable Member for Halifax.
Thank you, Madam Speaker. Madam Speaker, so the hole in the ozone over the Arctic has grown to record size. As we've heard in this House, it is now twice the size of Ontario, and reports are that it could take about 4 decades to repair. And this hole poses major long-term health and environmental concerns related to ultraviolet rays, and it represents a massive environmental, social, and financial debt that will be paid forward to our children and grandchildren. And that's why it was so concerning when this summer our government announced cuts that would affect Canada's ozone programs. These are programs that are world-renowned, they're made in Canada solution, and people from around the globe rely on the information that these programs gather. So on September 23rd in this House, I asked the Minister about cuts to the ozone monitoring program, and I specifically asked about the reports that he was getting rid of one of 2 measurement systems that are used to monitor 2 very different aspects of the ozone. So that day, and in subsequent rounds of questions, he's responded repeatedly in the House and in the media that the cuts were to address duplications within the program. He also refused to provide any analysis for how the cuts could be carried out without actually affecting scientific data that was being produced by the programs. And incidentally, he has also refused to this date to provide Canadians with an analysis about how the government will continue to ensure a healthy, biologically diverse environment, how we're going to pass it on to future generations, despite massive cuts to Environment Canada and to the Environmental Assessment Agency. But lo and behold, last week, it was revealed that one of the minister's senior officials wrote a report to the minister in September about the ozone monitoring program that contradicted everything the minister had been saying in the House, and that she herself had said to the media only a week after writing their report. The minister responded to the questions about these contradictions in the House by saying that that the document was actually being misquoted. That document, dated September 16th, 2011, discovered through access to information requests, talks about, it says specifically here, these methods measure different characteristics of the atmosphere and thus complement but do not duplicate each other. So that's actually in this freedom to information, access to information request. The wording is very clear. There's no duplication within the ozone monitoring program, and yet the minister's response was to attack opposition MPs and the journalist who broke the story. He chose, as usual, to suppress the science of the matter with spin, something we're used to seeing here, but he's continued to do so since on this issue, more about any other issue it seems he's questioned about, including his government's climate change plan, which, according to all data and analysis, is actually failing spectacularly. As with many of the decisions that are being made by this minister, the core of this issue is scientific capacity, because these cuts are part of a systematic attempt by the government to reduce the ability of the federal department and agencies to monitor and respond to environmental hazards. We need good science for good environmental assessments, for project planning, for research and innovation, and both industry and environmentalists agree that enhanced scientific capacity is essential at the federal level. So, my question to the parliamentary secretary is, is the minister going to come clean about the cuts to this program and actually reinstate the funding to Environment Canada to save these programs? Thank you, Madam Speaker.
The Honourable Parliamentary Secretary to the Minister of Environment.
Thank you, Madam Speaker. Like my colleague opposite, I'm very proud of the track record that Canada has with regard to excellence in monitoring ozone. This is why we've said numerous times, repeatedly in this House, that our government, our Department, Environment Canada, will continue to monitor the ozone. But what I'm getting tired of hearing is that there has to be a trade-off between efficiency in program delivery and in service delivery. And that's what we hear over and over again. So with regard to this question, I will answer the same way that I've answered several times in this House. Taxpayers expect government officials to conduct the nation's business at a reasonable cost. They also expect service delivery. We believe we can achieve both. We know we can achieve both. And this is something our government takes very seriously.
The Honourable Member for Halifax.
Thank you, Madam Speaker. I think that answer was very short because there isn't much to say when it comes to defending what's happening with these programs. Sorry, that was my feedback problem. Efficiency in program delivery. How about the fact that we have a program that is run by one scientist And that scientist got a notice saying that he may lose his job. And how about the fact that another program that monitors something completely different, a completely different set of data that is relied on by the international community, run by one scientist, who also got a notice saying that, sorry, your job may be on the line. The minister does not understand what these programs do. He does not understand that they do different things, and he does not understand that they are all very much needed. This is not about efficiency in program delivery. This is about shutting down science. When is the minister actually going to own up to the fact that that's what he is trying to do here?
The Honourable Parliamentary Secretary.
Again, Environment Canada takes monitoring of the ozone quite seriously. That's why we have such a strong track record in doing so over the last several years, over the last decades. This is something that we've said over and over again in the House. We will continue to monitor the ozone. We will continue to deliver excellent services. And it's something that Environment Canada is committed to, as is our government.
The Honourable Member for Cardigan.
Thank you very much, Madam Speaker. I'm pleased to stand in my place this evening and say a few words on behalf of the people that I represent. I represent the riding of Cardigan and Eastern Prince Edward Island that contains a lot of farmers, fishermen, and small business and tourism. But fisheries is a major issue in my area. And I recall, Madam Speaker, when I was seeking to become a Member of Parliament, and the first term I was a Member of Parliament, and touring through the federal riding of Cardigan and viewing the wharves. I remember in particular of going to Savage Harbour and looking at what they call the Black Wall. It was a breakwater. At that time, Madam Speaker, it would have taken less than $200,000 to repair the wall. But I could not convince the government that that should be done. And when it was all over and we finally got in government, it cost over $2 million to repair that wall. In fact, wharf repair is like taking care of your home or your buildings or your vehicle or anything else. It's an ongoing issue. I also remember, Madam Speaker, going down to Graham's Pond and looking at the facing of the wharf being off, and I tried to convince the government at that time that that needed to be repaired. And everybody knows in the fishing industry what happens when the face goes off. The ice gets in behind and it pushes the wharf to pieces. In fact, the plant there was about to go into the run. And then I look at North Lake and New Fraser and all the dredging that was needed to be done there. And the boats harming their propellers on the way in because there was not enough dollars. After we got elected to government, Madam Speaker, we put the harbour authorities in place. And that was some concern of mine when that did happen. But it ended up that the fishermen decided that it was part of their responsibility, but it was an understanding that the Government of Canada would supply the proper funding. There would be a small amount from the Harbour Authority, but they would work together in order to make sure that the wharves were kept in proper order. And on October the 17th, I asked the Minister of Fisheries, I received an internal memo that indicated that ocean management projects, science, services, aquaculture, and other important programs were being slashed by DFO. And in fact, the minister responded that, not to repeat everything he said, but to better manage. Well, Madam Speaker, back then, at one time, there was just about $100 million in small craft harbour funding in order to repair wharves. Today, Madam Speaker, there is $57 million in today's dollars available to repair small craft harbours. I just hope that my good friend, the Parliamentary Secretary for the Minister of Fisheries, will be able to indicate that he will go back to the government. He will go back to the government and indicate what a serious issue this is. He knows very well that we're dealing with, we're looking at a close containment and the open net concept for raising salmon. We need the scientific dollars. We need to know what is going on with close containment and what goes on in the open net concept. So I hope that my friend, the Parliamentary Secretary, will indicate specifically what areas is going to be cut. And also, Madam Speaker, they're going to change the fishing licence service to an automated service. I would just wonder, there's a lot of things happens in the fishery, Madam Chair, but let's say if somebody cannot take their boat out and they have to shift, how are they going to arrange those things? How are they going to avoid hurting people that do not have the internet? I hope the Parliamentary Secretary will be able to respond.
The Honourable Parliamentary Secretary.
Well, thank you, Madam Speaker, and as always, I welcome the opportunity to respond to some of the comments made by my friend from Cardigan. It allows me to outline some of the measures being taken by Fisheries and Oceans Canada to help our fisheries and maritime sectors grow and ensure that our aquatic ecosystems are protected for future generations. If he's asking the question, have we made changes in the way we do business? Well, of course, the answer is yes, we have, Madam Speaker. And modernization is essential to a stable, prosperous, and sustainable fishery. In fact, over the summer and fall, the Minister of Fisheries and Oceans traveled from coast to coast to coast, meeting with key players from the fishing industry to discuss how the department can support the growth and sustainability of the industry. He has spoken to stakeholders whose interests lie in aquaculture and wild fisheries and heard their views on licensing, sustainability, conservation, export markets, and all the other important issues that are especially important to these fishermen. And in fact, these consultations help shape the planned changes in how the department operates, changes that will come into effect over the next 3 years to ensure we continue to protect our ecosystems and build a more competitive fishing industry. So some of the things we can expect to see include accelerated progress towards a more modern, economically and ecologically sustainable Canadian fishing industry, modernization of fisheries management programs, increased use of modern navigational services, and a department that appropriately focuses on core mandate responsibilities. Now, my colleague has raised a number of specific issues. I could respond to all of them, but I think it would be important to just refer to the actual memo that he refers to. It's a memo that came out of the Deputy Minister's office, signed by her over her name and the Associate Deputy and the Commissioner of the Coast Guard. And it's to employees of the Department of Fisheries and Oceans, and it begins by saying, as you will know, Fisheries and Oceans Canada is pursuing a dynamic change agenda that will transform many of the ways in which we and our stakeholders do business. Over the past year, we have taken advantage of opportunities to advance modernization of our organizational model, as well as many of our programs, services, and business practices. Today, we're providing you with further information on initiatives that our government will be taking to pursue our modernization goals and, in turn, to help support the Government of Canada's priorities. Now, he referred to one of them in his question to the Minister back in October, and he said we're slashing, I think that was the word he used, our large ocean management area program and science and other things. Well, here's what she had to say about that. She said, as she cites some examples of the modernization that's taking place, she says, realigning our oceans management responsibilities by winding down large ocean management areas pilot projects now that we are in a position to begin applying integrated oceans management approaches as part of our regular operations. So, of course, she wasn't saying anything about the end of large ocean management areas as part of our program, but just these pilot projects now that they will become part of our regular operations. She says focusing aquaculture science activities on issues relevant to the department's regulatory duties in relation to fish health and environmental interactions in order to strengthen our capacities in these areas, finding efficiencies and simplifying how science is managed, for example, by aligning our science resources to reflect the transition to an ecosystems approach to science. I hope my colleague agrees with these approaches. They're important. This approach means a greater emphasis on science working in teams to address complex, interrelated issues affecting fish habitat, and the integrity of aquatic environments. In fact, Madam Speaker, the modernization ship is sailing, and I encourage my colleague from Cardigan to get on board.
Honourable Member for Cardigan.
Thank you very much, Madam Speaker, and I appreciate, but I am disappointed with what my honourable friend had to say. I'm pleased that the Minister travelled to talk to fishermen. I know they're realigning. I wonder, did the minister happen to mention when he was travelling and talking to fishermen that he was going to cut the budget for small craft harbours from close to 100 million to 57 million? I'd be very surprised with the people that I represent. I live among fishermen that understand what needs to be done, what it takes to keep harbours in shape. I hope that that my honourable colleague, the Parliamentary Secretary for the Minister of Fisheries, will go back and tell the Minister and tell the government that that is just unacceptable. If they cut the budget from 100, in fact, they're cutting the budget in half. And I'd also like, when in his final comments, Madam Speaker, if it would indicate if that 57 million is the wharf in Pangerton and Nunavut. We support that wharf. But is that money coming out of the budget now, or is it new money, as we were told by the government a couple of years ago? Or
the Honourable Parliamentary Secretary.
Well, thank you, Madam Speaker. And, you know, I would be more sympathetic to my colleague and his concerns if he hadn't been part of a government that throughout the 90s and even as late as 2005 made arbitrary cuts, much greater arbitrary cuts than you'll ever see on this side of the House. But just with respect to small craft harbours, he knows that the budget hasn't been changed for that. He should know that in 2008 we put $45 million into the divestiture program, and then through the Economic Action Plan, $200 million. That's a lot of money, even by Liberal standards. $200 million into projects across the country to allow us to catch up from the condition that we found the harbours when we inherited it from the Liberal government.
The motion to adjourn the House is now deemed adopted. The House therefore stands adjourned until tomorrow, pursuant to the standing orders.